The third and fourth respondents also filed a similar motion on 12th of May 2023. Therein, the third and fourth respondent prayed for an order of this honorable court striking out and or dismissing this petition for being incompetent, fundamentally defective, and vesting no jurisdiction on this honorable court to adjudicate thereon. The grounds for the application have been listed. In this motion, several grounds were raised. Now, it is apparent that the sole ground of this petition is based on the qualification of the second respondent. The issue of qualification or disqualification of a candidate to contest an election for the office of President of Nigeria is a constitutional one. That is why it is stipulated in section 134, subsection 1A of the Electoral Act 2022 that an election may be questioned on any of the following grounds. A person whose election is questioned was, at the time of the election, not qualified to contest the election. The qualifications and or disqualifications of a candidate to contest an election for the office of president are stipulated in section 131 and 137 of the Constitution of the Federal Republic of Nigeria as amended. While the qualifications are inherent in section 131, the disqualifications are ingrained in section 137, subsection 1A to J of the Constitution, supra. It is apparent, therefore, that the issue of qualification of a candidate to contest an election could be a ground in an election petition, though it may also ground a pre-election matter, where such issue of qualification or disqualification of a candidate arises from the primary election of the party by virtue of section 285, subsection 14 of the Constitution. Where the issue of qualification or disqualification arises from before the election, it is an election, a pre-election matter, and an action on that issue must be instituted pursuant to section 285, subsection 11 and 14 of the Constitution. It should be noted that upon a quick and careful perusal of the pleadings and in the petition, the issue of disqualification of the first respondent rests solely on the issue of the alleged invalid nomination of his running mate, with the third respondent. The issue of invalid nomination is captured by paragraphs 18, 19, 20, and 21 of the petition. For proper understanding of the facts pleaded, those paragraphs have been reproduced. The second issue, arm of that issue is captured in paragraphs 22, 23, 24, and 25, and 26 of the petition. Considering the facts pleaded above, it is clear that the claim of disqualification or non-qualification disqualification, non-qualification with third respondent is centered solely on the invalid or double nomination of the fourth respondent. However, it is the settled law that the issue of nomination of a candidate at an election is a pre-election matter. Therefore, the issue of qualification or disqualification can only be ventilated on the grounds enumerated in sections 131 or 137 of the Constitution. That is why section 84, subsection 3 of the Electoral Act 2022 stipulates that a political party shall not impose nomination qualification or disqualification criteria, measures, or conditions on any aspirant or candidate for any election in its constitution, guidelines, or rules for nomination of candidates for elections, except as prescribed under Section 65, 66, 106, 107, 131, 137, 177, and 185 of the Constitution. 187. It therefore means that the conditions of qualification or disqualification are prescribed by, under Sections 131 and 137 in case of person contesting for office of president. That means that where it is alleged in an election petition that a person is or was not qualified to contest election to the office of President of Nigeria, as stipulated in Section 134, subsection 1A of the Electoral Act 2022, it is Sections 131 and 137 of the Constitution of Nigeria that are applicable. See the cases of PDP and ANIC, Kaki and PDP, Ucha and Onwe, and Captain Idris, Ichala Wada and others versus Yahya Bello and others, all citations supplied. That's why election has been conducted and result declared. Such election cannot be questioned on grounds of qualification under sections 131 and 137 of the Constitution in the case of a presidential election. This postulation is supported by Section 134, subsection 3 of the Electoral Act, where it is stipulated that with respect to subsection 1A, a person is deemed to be qualified for an elective office, and his election shall not be questioned on grounds of qualification if, with respect to the particular election in question, he meets the applicable requirements of Section 65, 106, 137, or 177 of the Constitution, and he is not, as may be applicable in breach of Sections 66, 107, 137, or 182 of the Constitution. As stated earlier, the applicable provisions are Sections 131 and 137 of the Constitution. It is clear from the plenitude of the pleadings in this petition that the facts grounding the petition's claim of disqualification or non-qualification of the third and fourth respondents is hinged on double and invalid nomination of the first respondent. I had pointed out earlier in the course of this ruling that the issue of qualification or disqualification of a candidate at an election is strictly a requirement of the Constitution. That it was held in the case of Al Hassan and another versus Ishaku and others, citation supplied, I quote, by virtue of the provisions of Section 138 sub 1A of the Electoral Act, a tribunal's power to decide whether a person is qualified to contest an election is restricted to establishing the requirements of Section 177 and 182 of the Constitution against the adverse party. An election tribunal has no jurisdiction to inquire into the primaries of a political party, close of court. It is apparent, therefore, that issues of nomination or sponsorship of candidates by political parties come under pre-election matters and should be instituted and determined before the conduct of the election. Shinkafi and others versus Yari and others, Ella and others versus Abo. That being so, a ground of election petition questioning the election of a person duly qualified to contest such election as required by the Constitution cannot be sustained, where it is predicated on nomination or sponsorship of such candidate. Therefore, a petitioner who relies on non-qualification of his opponent to nullify the election must bring the facts of such non-qualification within the ambits of Sections 131 and 137 of the 1999 Constitution. I have noted that the petitioner respondent sought to tie his complaint of non-qualification to Section 142(1) of the 1999 Constitution. That provision stipulates as follows. I quote, in any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate for election to the office of president who nominated him as such associate is duly elected as president in accordance with the provisions of aforesaid. I am of the view that the above cited provision of the Constitution does not create additional qualifications or disqualifications for a candidate contesting for the office of President of Nigeria. Furthermore, Section 142 of the 1919 Constitution, read along with Section 141 of the said Constitution, create the office of President and Vice President. Section 142(1) is a specific provision donating power to the President to nominate a person as his associate to occupy the office of the President. That's why subsection 2 of Section 142 mandates that the requirements of qualification and disqualification attaching to the occupier of seat of President also applies to the holder of the office of Vice President. It is therefore my view that Section 142, subsection 1 of the Constitution does not introduce the issue of nomination or sponsorship of Vice President so as to enlarge the scope of qualifications or disqualifications applicable to the seat of President. There cannot therefore be a disqualifying factor of a candidate for the office of President outside those specified in Section 131 and 137 of the Constitution. It can safely be said that those provisions have sufficiently and conclusively covered the field until there is an amendment to the Constitution. See the cases of AG Abia and AG Federation, also PDP and ANIC Supra. As a fallout to my findings above, I hold the firm view that the issue of nomination or sponsorship of the first respondent, being a pre-election matter, ought to have been ventilated by the petitioner before the Federal High Court, as this court has no jurisdiction to delve into the matter. Even if this court has such jurisdiction, the course of action being a pre-election matter is statute barred by virtue of Section 285, Sub 9 of the Constitution of the Federal Republic of Nigeria 1999 as amended. Having found as above, it is my view that the two motions filed by the first respondent and third and fourth respondents on 7 May 2023 and 12 May 2023, respectively, have no merit. Accordingly, I find that the petition is have merit. Accordingly, I find that the petition is liable to be struck out for being incompetent. By a motion on notice filed on the 8th of May 2023, the second respondent, applicant, sought the following relief. An order of this Honorable Tribunal granting leave to the second respondent applicant to bring and argue this application before, or outside, or during the pre-hearing session. 2, an order of this Honorable Tribunal striking out grounds 1 and 2 contained in paragraph 16 of the petition for being incompetent. 3, an order of the Honorable Tribunal striking out paragraphs 17, 18, 19, 20 to 29 of the petition, which are predicated on the incompetent grounds 1 and 2 in paragraph 16 of the petition for being an abuse of court process. And order 4, an order of this tribunal striking out reliefs 1 to 7 of the petition for being incongruous, illogical, and ungrantable. And 5, an order of the Honorable Tribunal dismissing or otherwise striking out the petition for one of jurisdiction and on the ground that the petition does not disclose any reasonable course of action. Here's the grounds stated here in, and I've considered the arguments of counsel which I have summarized in this ruling. It will be seen. It will be seen that this application is premised on several grounds. The first is that the grounds of the petition are incompetent. This is premised on the erroneous argument of the second respondent or applicant that the grounds for the petition are as stated in paragraphs 16 of the petition. A careful perusal of the petition will disclose that there is only one ground for the petition and is stated in paragraph 15 of the petition as follows: that your petitioner states that the ground upon which this petition is presented is that the third respondent was at the time of the election not qualified to contest the election. The averments in paragraph 16 as unequivocal caption deal with the facts of the petition. This ground for the objection to the competence of this petition therefore lacks substance, and it is accordingly discountenanced. The second ground for the objection is that the petition is an abuse of court process. It is premised on the fact that the petitioner respondent had earlier instituted an action before the Federal High Court in suit number FHC/ABG/CS/1215/2022 between Allied People's Movement and INEC and 12 others on the same subject matter as in this petition against the first, second, third, and fourth respondents in this petition and others. It was, however, deposed in paragraph 3M of the counter affidavit filed by the petitioner in opposition to this application that the matter was not determined on the merit by the trial court, who referred the matter to the court appeal for interpretation. That in any case, the matter had since lapsed in 180 days for determination by law, being a pre-election matter. It is tried law that abuse of court or judicial process simply means the use of a court process mala fide or in bad faith to the annoyance of the opponent. One variety of it is the institution of multifarious actions between the same parties with regard to the same subject matter and same issue in the same or another court. A quick look at the originating summons in suit number FHC ABJCS 1275/2022 will show that same was instituted in the Federal High Court, Abuja, on 27th day of July 2022. Being a pre-election matter, it ought to have been determined within 180 days, as required by Section 285, subsection 10 of the 1999 Constitution. It therefore means that it lapsed by January 2023, about a month the election in question was conducted. This petition having been instituted on the 20th of March 2023, when suit number FHC was no more alive, does not qualify as an abuse of court process. This ground for this objection is also discountenanced. On whether this petition is covered by the doctrine of estoppel, it was argued that the issues raised in this petition have been firmly resolved by the Court of Appeal in appeal number CS/ABJ/CS/08/2022. Issue estoppel arises when the issue has been decided upon to finality by a court of competent jurisdiction. In other words, once an issue has been raised and distinctly determined between the parties, another party can be allowed to fight that issue all over again. The same issue cannot be raised by either party again in the same or subsequent proceedings, except in special circumstances. For issue estoppel to apply, the following conditions must be satisfied. A, the question must have decided, the same question must have been decided in both proceedings. B, the decision which creates the estoppel must be final, and the parties to the judicial decision or their previous to the proceedings in which the estoppel is raised must be the same. To determine whether the above three elements exist, the court will closely examine the reasons for the judgment and other relevant facts that were actually in issue in the proceeding. See the cases of Oyekola and others versus Amodu, OSPM Limited versus Nibel Company Nigeria Limited, and Dasuki Retired versus Federal Republic of Nigeria Sanitation Supply. I have studied the case sought to be relied on as estoppel in this case. It is apparent that the parties in that case are not the same as in the instant petition. The issues, though the same, were not resolved to finality in the previous case. The action was struck out on ground of lack of local standard by the lower court, which this court affirmed on appeal. Thus, the objection on that ground is also discountenanced. On whether the question is statute barred, I had held in the earlier motion filed by the first respondent on 7th May 2023 and third and fourth respondent's motion filed on 12th May 2023, which were taken together. This petition, which is premised on the nomination or sponsorship of the fourth respondent, is a pre-election matter. That being a pre-election matter, it ought to have been instituted and ventilated by the petitioner before the Federal High Court within 14 days from the date of recurrence of the event or action complained of. That not having been done, the course of action in this petition stands barred by virtue of Section 2859 of the 1919 Constitution of the Federal Republic of Nigeria, as amended. On the issue of local standing, I had also held in the previous motions filed on 7/5/23 and 12/5/23 that issues of nomination or sponsorship of candidates by political parties for an election come under pre-election matters. It is settled that the issue of nomination of candidates by substitution is purely a pre-election matter. The only person with the local standing to challenge the nomination is an aspirant who participated in the process of such nomination. In other words, apart from an aspirant who took part in the primary election, no other person is authorized to challenge such nomination by a political party for an election. Such process of challenging the nomination is sanctioned by Section 84, subsection 14 of the Electoral Act 22 and 285, Section 14 of the Constitution. Shinkafi and another versus Abdul Aziz Ayari and Al Hassan another and Ishaku. It therefore follows that the course of action in this petition, which is rooted in the nomination or sponsorship of the fourth respondent, is a pre-election matter. Being a pre-election matter, the petitioner herein has no local standing to challenge or question such nomination or sponsorship of the fourth respondent by the second respondent. Thus, in People's Democratic Party (PDP), an Independent National Electoral Commission and others, unreported decision of the Supreme Court, delivered on 26th day of May 2023 in SC/CV/501/2023. I heard the matter has been reported, but I have not been able to avail myself of the report. Held at the Supreme Court held at page 71 page 31 lines 1 to 16 thereof as follows. Court, the provision does not make the filing of pre-election matters by political parties an all-comers affair. It is not the purpose of the provision that the floodgate of pre-election litigation be open to political parties who will hide under it to challenge the actions or inactions of rival political parties under the guise of challenging the decision or activities of INEC. The application of Section 285, Section 14C of the Constitution does not extend to a political party poking into the affairs of another. The position of the law has always been that no political party can challenge nomination of the candidate of another political party, no matter how pained or disgruntled a political party is with the way and manner another political party is conducting or has conducted its affairs concerning its nomination of its candidates for any position. It must keep mum and remain an onlooker, for it lacks the local standing to challenge such nomination in court, close of court. It is clear, therefore, that a political party such as the petitioner herein only has the local standing to file a pre-election matter when the situation affects it or its candidate by virtue of Section 285, Section 14C of the 1999 Constitution. That being so, as in the instant petition, where the grounds of the petition is rooted on the nomination or sponsorship of the candidate of another political party, this petitioner will have no local standing to institute the action, be it in the Federal High Court or an election tribunal. For that reason, it is my view that the course of action in this petition being on the nomination and sponsorship of the third and fourth respondents by the second respondent applicant, the petition is incompetent for lack of local standing on the petition to institute the action. It is also liable to be struck out for being incompetent. The second respondent applicant also contended that the petition is not properly constituted as the candidate sponsored by the petitioner has not been joined as co-petitioner in the petition. The short answer to that is that Section 133, subsection 1B of the Electoral Act 2022 entitles a petition as a political party to institute an election petition. The applicant has not referred us to any provision of the Electoral Act or any authority that mandates the political party to file an election petition only when its candidate has been joined as a co-petitioner. It is true that it is proper for the candidate of the party to be so joined, but there is no law that compels the political party to join its candidates in the petition. After all, the purpose of such joinder is so that the candidate can be bound by any judgment or order of the court or tribunal, but any non-joinder will not invalidate the petition. This is particularly so when Section 133, subsection 1 of the Electoral Act stipulates, I quote, an election petition may be presented by one or more of the following persons: A, a candidate in an election, or B, a political party which participated in the election. By the use of the disjunctive word or, it means that an election petition may be filed by the candidate alone, or the political party alone, or both of them. The objection on this ground is also discontinuous. By another motion filed on the 15th of May, 2023, the fifth respondent, thus Kabir Masari, prayed this court to grant him the following reliefs. 1. An order of this court dismissing this petition in its entirety for want of jurisdiction. 2. An order striking out the name of the fifth respondent applicant from this petition for non-disclosure of any reasonable course of action against him. And first, other orders that this honorable court may deem fit to make in the circumstances. The grounds for the application have been stated. I've also considered the submissions of counsel. Now, Section 133. Section 133 of the Electoral defines persons who are necessary parties in an election petition. Generally, necessary respondents in an election petition are the persons whose election or return is complained of and the electoral body that conducted the election. This is Section 133, subsection 2 and 3 of the Electoral Act 2022. Those are what are termed statutory respondents. It should be remembered that election petitions are sui generis. As sui generis, and is procedure strictly regulated by statute. That's why a person does not fall within the category of statutory respondents. They are not registered parties in an election petition. See the cases of Agbere and Mimra, Buhari and Yusuf, APC and PDP. That's in Waziri versus Gaidam. The Supreme Court held, I quote, from the above, I have no difficulty in going along with the submissions of the respective counsel for the respondents that Section 137, sub 2 and 3 of the Electoral 2020 has no room for the joinder of the fifth respondent who neither won the election nor performed any role as electoral officer or agent of the third respondent in the election petition, challenging the result of such an election, and even no relief was claimed against the said fifth respondent, and indeed, he had nothing to gain or lose in the petition aforesaid, close of court. Indeed, a holistic reading of the facts of this petition does not disclose any complaint against the fifth respondent. The only fact that relates to the fifth respondent relevant to the petition is the act of withdrawal of his candidacy as the running mate of the third respondent. That is an act that occurred within the pre-election period, therefore cannot amount to any act done by the fifth respondent at the election. It cannot therefore ground any complaint by the petitioner against the fifth respondent in an election petition. It may be relevant in a pre-election matter, but not in an election petition. It is therefore my finding that there is no any claim on the fifth respondent. In other words, the relief sought in the petition will not in any way affect the fifth respondent, as he did not participate in the petition either as a candidate or agent of the second respondent, and no declaration was made in his favor by the first respondent. In that respect, I hold that the objection of the fifth respondent on this ground has merit. Finally, I order that the name of the fifth respondent is struck out of this petition. These are the rulings in respect of the petition number 4. I will now go to the main petition itself. So after the pre-hearing session, hearing on the petition opened and closed on the 21st of June 2023, the petitioner called one witness and closed his case. None of the respondents called any witness, but tendered some documents from the bar, and the petition was adjourned for adoption of written addresses. Parties then filed and served written addresses as directed by this court, and same were adopted on the 14th of July 2023. The matter was then adjourned for judgment. The first respondent's written address was filed on the 30th of June 2023. Therein, 4 issues were raised for determination as follows. 1, whether considering the facts of the petition and evidence laid thereon, the petitioner has the local standing to question the nomination of the first respondent as a ground of challenging the qualification and the return of the third respondent as the winner of the presidential election of 25th February 2023. 2, whether having regard to the facts pleaded and evidence laid thereon, vis-a-vis the provision of Section 134, subsection 3 of the Electoral Act 2022, can the issue of validity of the nomination of the first respondent as the vice president candidate of second respondent be validly raised as a ground before this honorable court to question or challenge the qualification and return of the third respondent as the winner of the presidential election of 25th February 2023. Number 3, if the answer to note 2 is in the affirmative, whether having regard to the facts pleaded, the nomination of the first respondent as the vice president candidate of the second respondent is void, as to render the third respondent not qualified to contest the presidential election of 25th February 2023. 4, whether considering the relief sought as per the petition accrues no utilitarian benefit to the petitioner, petition not an abuse of court process. Well, to save time, all the other respondents filed briefs and raised issues. These issues have been produced in this judgment, including the issues raised by the petitioner. Now, it is apparent from the averments in the petition, the oral and documentary evidence, and the submissions of counsel that this petition is grounded on the disqualification of the third respondent to have contested the presidential election of 25th February 2023. This is evident in paragraph 15 of the petition, wherein the petitioner pleaded thus. I had read it earlier. This is further explained as emanating from the non-qualification of the first respondent to have contested the election as the vice president candidate of the second respondent. It is specifically pleaded in paragraph 17 of the petition as follows. Your petitioner states that the fourth respondent was not qualified to jointly contest with the third respondent for the presidential election held on 25th February 2023, having been purportedly nominated by the second respondent as its candidate for more than one office. The specific reasons for questioning the qualification of third respondent have been pleaded in paragraph 16(1) and 2 of the petition as follows. Those paragraphs have been reproduced. If you get the judgment, you will see it there. So a combined reading of paragraphs 15, 16, and 17 of the petition, coupled with the particulars thereof, show clearly that the petition is premised on non-qualification of the fourth respondent. I find it necessary to state that the grounds for questioning the return at an election are stipulated in section 135, subsection 1 of the Electoral Act, that has been reproduced earlier. For the purpose of this petition, it is the ground stipulated in section 134(1)(a) that is relevant. In other words, the election of the third and fourth respondent as president and vice president is questioned on the ground that they are not qualified to have contested the said presidential election. I've considered paragraphs 18, 19, 20, 21, 22, 23, 24, 26, and 28 of the petition as relevant for determination of the petition, which paragraphs have been reproduced in this judgment. In response, the first respondent, that's INEC, filed a reply to the petition where it was averred in paragraphs 14, 15, and 16 of the first respondent reply to the petition as follows, which have also been reproduced. The second respondent also filed a second respondent reply to the petition, and also made their own averments in paragraph 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, and 25, 29, which have been produced herein. So from the totality of the pleadings in the petition and the replies of the respondents, what appears from the complaint of the petitioner is that the fourth respondent, while still a candidate of the second respondent for Borno's Central Senatorial District, was nominated and did accept to be the vice president candidate of the second respondent. That this act violated the provision of Section 35 of the Electoral Act 2022 as it amounted to his double nomination. That in the circumstances, his nomination as an associate of the second respondent for the presidential election is void. That the result is that the third respondent was disqualified from contesting the election because he did not have a validly nominated running mate at the time of the election. The petitioner relied on Section 131 and 142(1) of the 1999 Constitution for his postulation. Section 131 and 142 sub 1 of the Constitution of Federal Republic of Nigeria as amended stipulate as follows. A person shall be qualified for election to the office of president if A, he is a citizen of Nigeria by birth, B, he has attained the age of 40 years, C, he is a member of a political party and is sponsored by that political party, and D, he has been educated up to at least full certificate level or its equivalent. 142(1). In any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running mate for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate is for election to the office of president who nominated him as such an associate is duly elected as president in accordance with the provisions aforesaid. The general principles of interpretation of the Constitution, which is the supreme law of the land, is that mere technical rules of interpretation of statutes are to some extent be avoided in a way as not to defeat the principles of government. That's why the words used are clear and unambiguous. A literal interpretation should be applied. In the interpretation, therefore, the provisions of the Constitution are to be accorded holistic interpretation so as to avoid ambiguity and arrive at the true intention of the legislature. The court must limit itself to the words used in the Constitution without resort to any external aid or materials. In the cases of Sani and President Federal Republic of Nigeria, Amadi and Ani, and Agi and PDP and others. Thus, in Wike Ezonwo Nwesom, Honorable Dr. Dokuku, Adol, Peterside, and others, the Supreme Court observed that, I quote, the principle of conception of the Constitution to the effect that a Constitution is a living document, not just a statute, providing a framework for the governance of a country, not only for the present, but for generations yet unborn. It was held that in construing the Constitution, undue regard must not be paid to merely technical rules, because in doing so, the objects of the provisions as well as the intention of the framers of the Constitution will be frustrated. Courts have always been encouraged to adopt a broad and liberal spirit in interpreting the provisions of the Constitution while constantly bearing in mind the object which such provisions were made to serve, close of court. That being so, where the Constitution has stipulated the qualifications to be attained by a person contesting or seeking to contest for any elective office created by the Constitution, the courts cannot create or import into the Constitution any other qualifying or disqualifying factor. This has been the position of the Supreme Court and dutifully followed by this court. It has therefore been held that qualification or disqualification of candidates to contest election is exclusively determined within the context or scope of the Constitution, and that nothing can be added to it. In other words, the Constitution being the ground norm is superior to any other law, including the Electoral Act. Therefore, where the Constitution has qualified a person or candidate to contest an election, no other law except the Constitution itself can disqualify him. The petitioner in this case has premised his complaint of non-qualification or disqualification of the third and fourth respondents as the president and vice presidential candidates of the second respondent on the issue of invalid nomination of the fourth respondent. The fourth respondent, while still the senatorial candidate of the second respondent for the Borno Central District, allows himself to be nominated as the vice presidential candidate of the second respondent for the same election. Rulings earlier delivered on the motions and preliminary objections, we had ruled that the petition grounded solely on the issue of invalid nomination or improper nomination is not a cognizable ground of disqualification under the Constitution. In other words, the claim in the petition that the third respondent was not qualified to contest the presidential election because he nominated an associate whose nomination was invalid does not flow from any ground of disqualification of a candidate to the office of president as stipulated in section 131 and 137 of the 1999 Constitution. See the cases of Balewa and Muazu and Faleke and Anik, Tazu versus Ioria. Then in Shinkafi versus Yari, the Supreme Court held that the Supreme Court has listed in section 182, section 182 very exhaustively all the issues that can qualify a person from contesting the office of governor of a state. From the record of this court, the facts have not disclosed any evidence to show that the first respondent was not qualified to contest elections into the office of governor of Zamfara state. It is my view that once a candidate sponsored by his political party has satisfied the provisions set out in section 177 of the Constitution and is not qualified under section 182 subsection 1 thereof, he is qualified to stand election to the office of governor of a state. No other law can qualify him. This authority can apply mutandis to section 131 and 137 of the Electoral Act. It has not been contended by the petitioner that either the third or fourth respondent is trammeled by the provisions of section 131 or 137 of the 1999 Constitution. The complaint of the petitioner rooted on nomination and sponsorship of third and fourth respondent will find accommodation in a pre-election dispute, which the petitioner cannot even pursue, not being a member of the second respondent. This section 84, subsection 14 of the Electoral Act 2022 and 285, 14 of the Constitution. While I'm tempted to put an end to this petition at this stage, but realizing that this court is not the final court on the matter, I'm constrained to look at the merit of the petition. As pointed out earlier in the course of this judgment, a complaint of the petitioner in this petition is that the third respondent was at the time of the presidential election held on 25th February 2023 not qualified to contest the election. This is because, according to the petitioner, the fourth respondent was not qualified to run on a joint ticket with him, that's third respondent, as the fourth respondent nomination was invalid for double nomination, which violates section 55 of the Electoral Act 2022. As stated earlier, the petition contended that the fourth respondent was a candidate of the second respondent for the Borno Central District when the third respondent nominated him as his vice presidential candidate on the 14th July 2022. In other words, that at the time the fourth respondent was nominated, he had accepted nomination as the vice presidential candidate of the second respondent, who was still a validly nominated central candidate of the second respondent for Borno Central District. The petitioner then contended that the second respondent had earlier submitted the name of the third respondent together with that of the fifth respondent to ANIC as his presidential and vice presidential candidates for the 25th February 2023 election. However, that before the date of the election, the fifth respondent withdrew his candidature as the running mate of the third respondent on the 24th June 2023, and the name of the fourth respondent was then submitted to ANIC, that's first respondent, on the 15th July 2022. that the second respondent did not conduct any fresh primary election for the purpose of picking another running mate for the third respondent after the withdrawal of the fifth respondent. The respondents conceded that the fourth respondent was ab initio the central candidate of second respondent for Borno Central District. However, that on the 6th July 2022, the fourth respondent via a letter dated the same date notified his political party, that second respondent, of his withdrawal from the central candidature. That upon receipt of the fourth respondent letter, the second respondent immediately notified INEC, and which notification letter was received on the 13th July 2022. That the said letter also notified the first respondent of his intention to conduct a fresh primary election for the replacement of the first respondent following his withdrawal as a central candidate. That it was until 14th July 2022 that the first respondent was nominated as the third respondent associate for the presidential election of 25th February 2023. The fifth respondent notice of withdrawal as a candidate is in evidence as Exhibit PA2, while the notice of withdrawal and letter of voluntary withdrawal of the fourth respondent are in evidence as Exhibits PA3 and PA4 respectively. It will appear that the petitioner is the view that the fourth respondent was still the central candidate of the second respondent as at the 14th of July 2022, when the fourth respondent was nominated as the vice presidential candidate of the second respondent. However, the respondents contended that the issue of alleged double nomination of fourth respondent has been determined finally by the Supreme Court in People's Democratic Party, PDP versus ANIC, that in the circumstances, the said judgment of the Supreme Court constitute estoppel parem judicata and binding on the parties in this petition. Now, for a judgment to constitute issue estoppel, the conditions I had earlier stated in the rulings. So the three elements must be present and coexist for a plea of estoppel parem judicata to apply. See the cases of Ito and Epe and others, Oshoboja versus Amida and others, and Alexandra and others versus Lone Star Drilling Company Limited, all citation supply. It is obvious that the judgment sought to be relied on for the plea of estoppel is that of the Supreme Court, the highest and final court in this country. There is no doubt that the decision was final, and the issue that was done by the Supreme Court is the same as in the present petition, with whether the fourth respondent breached Section 35 of the Electoral Act by allowing himself to be nominated in more than one constituency. The petitioner has, however, argued that the issue decided by the Supreme Court was merely on the local standing of the PDP to question the nomination of the fourth respondent, the candidate of the APC, a different political party. That may well be so, but it is clear from the judgment, thus Exhibit X1, that the Supreme Court pronounced on the substantive issue of double nomination. So, Joro JSC, who delivered the lead judgment, declined to exercise the powers of the Supreme Court under Section 22 of the Supreme Court Act to pronounce on the merit of the case. The other laws of the Supreme Court proceeded to do so. It is settled law that a contributory or concurrent judgment has equal weight as the lead judgment. It is part of the lead judgment and therefore has the same force and binding effect. The mere fact that a concurring or contributed judgment contains what is not in the lead judgment will not whittle down binding effect. Thus, in Olu Fegba and others versus Abdurrahim, my Lord Fabi JSC said, of course, the concurrent judgment has equal weight with or as a lead judgment. A concurrent judgment complements, edifies, and adds to the lead judgment when the justice adds its certain fact aspects which the writer of the lead judgment did not remember to deal with. Insofar as the concurrent judgment performs same for all the above functions, it has equal force with or as the lead judgment insofar as the principles of stare decisis are concerned. Now, it is apparent that the parties in Exhibit X1, PDP and ANIC and other supra are not the same as in the present petition. The earlier decision, though, involved the first, second, and fourth respondents. The present petitioner was not a party in that case. That is why it was argued by the petitioner herein that Exhibit X1 cannot operate as to stop it from litigating the issue of dominant nomination of the fourth respondent. The respondents have responded that the judgment in PDP and Annex Exhibit X1 is a judgment in rem as opposed to judgment in personam. In law, a judgment in personam is a judgment against persons who are parties or privy to the particular suit or proceeding alone. It is referred to as judgment inter partes. It is a judgment binding on the parties to the action alone. A judgment in rem, on the other hand, is a judgment that determines the status of a person or thing as distinct from the particular interest of a party to the litigation. It is referred to as judgment contra mundum, binding on the whole world. It is therefore binding not only on the parties to the dispute, but even non-parties. Therefore, once the status of a person or thing has been pronounced upon by a court of competent jurisdiction, no person is permitted to assert the contrary of what that court has decided. See Black's Law Dictionary, 11th edition at page 1008. Demishola versus Bolarinwa, Yanati Petrochemical Limited and EFCC. Then Ladi Jobi and others versus Oguntayo and others, partition supply. It is no doubt that the judgment matter in PDP and INEC others X1 was in respect of the alleged double nomination of the first respondent as the vice president candidate of the second respondent in the 25th February 2023 presidential election. That is the same issue raised in this petition as grounding the disqualification of the third and fourth respondent in this petition. Pronouncing on this issue in this case, in the contradictory judgment, my Lord Okoro JSC, who presided on the panel of the Supreme Court, held as follows, I quote, "There is no doubt that the fourth respondent was at a stage nominated as a candidate representing Borno Central District, but upon being muted, he would pair with the third respondent as vice presidential candidate of second respondent, All Progressive Congress, APC, in the 26th February 2023 general election. He withdrew his candidature for the Senate before taking up the position of vice presidential candidate. Documents in the record attest to this fact. These are APC 1, APC 2, which were made on the 6th and 10th of July 2022, respectively, laws of court. After considering those documents, His Lordship concluded at page 7 of the contrary judgment that, quote, "It is crystal clear that the two exhibits alluded to above, the fourth respondent did the needful by resigning his position of senatorial candidate for Borno Central District since 6 July 2022, before being nominated by the third respondent to run alongside him as vice presidential candidate of All Progressive Congress." Close quote. My Lord Okoro went on to, after citing section 31 of the Electoral Act 2022, held at page 8 of his contributory judgment that I quote, "The above provision of the Electoral Act 2022 was duly complied with by the respondent. My well-considered opinion that as at the 6th of July 2022, having withdrawn his nomination and personally served him on the second respondent of the withdrawal of nomination of 6 July 2022, the fourth respondent was no longer a candidate for the Borno Central District elections, and his subsequent nomination as vice presidential candidate of the second respondent for the presidential election was not multiple nomination, as there was no longer a nomination for the fourth respondent since his withdrawal on the 6th of July 2022. I have also cited the elaborate contribution of His Lordship, Ajim JSC. So I have endeavored to quote extensively the dicta of the laws of the Supreme Court in PDP and INEC Supra in order to show that the issue of double or even multiple nomination of the fourth respondent as the central candidate and vice presidential candidate of second respondent in the 25th February 2022 general election has been settled to finality. It is a judgment in rem, therefore binding on the parties to this petition and in fact the entire world, including this court. Being the judgment of the final court of the land, of this land, this Supreme Court, no person is permitted to again raise and litigate on it in any other action or proceeding. It is therefore settled and remains settled that this petition, which questions the qualifications and seeks to disqualify the third and fourth respondents from contesting and occupying the seat of President and Vice President of Nigeria on ground of double or multiple nomination of the first respondent and Vice President candidate of the second respondent on ground of double or multiple nomination for the respondent has no substance. I only wish to add that Section 35 of the Electoral Act is targeted at the candidate and not the political party. That is why it uses the terms a candidate and normally allows himself to be nominated by more than one political party or more than one constituency. That's to prove that the candidate knowingly allows himself to be so nominated. Both the intent and actual acts of nomination, that is, the mens rea and actus reus of the act prohibited, must be proved, the stipulation in the section being a penal provision. In the instant case, neither the intent nor the fact of the first respondent to allow himself to be so nominated was established. That's why His Lordship Ogumi JSC, in his contributory judgment, in Exhibit X1, held as follows, I quote, by Section 31 of the Electoral Act, the first respondent, Shetima, was obliged to submit a notice of withdrawal in writing to his party, which he did. And then his party is to deliver that notice to the Commission not later than 90 days to the election. In view of the above stated position of the law on this issue and the facts of this case, there exists no animus or display of intention by the first respondent to stand as the nominated candidate of the second respondent for the vice presidential position and also the senator representing Borno Central District in the general election of 26 February 2023. There cannot be any other interpretation in the circumstance unless there is clear intention to knowingly stand as a candidate for two elective posts in the same election cycle. Jim JSC also contributed as follows, quote, the manifest intention to relinquish the earlier nomination to pave way for the nomination of another person to replace him as the party's central candidate cannot be overlooked or disregarded. To simply isolate the assumed or purported short-lived coexistence of the two nominations for treatment as multiple nominations without regard to the obvious intention of the first respondent not to be the party's candidate in elections in two constituencies is against the legislative intent of Section 35 of the Electoral Act 2022. The sequence of the occurrence of the events is not what determines the existence of multiple nominations. It is the intention, design, or purpose to hold two or more nominations as candidate for election that shows that the person so nominated knowingly did so. Second respondent did not intend that the first respondent should be its candidate for Borno Central election and its vice presidential candidate for the presidential election. The first respondent did not understand or know that he was so nominated. The word knowingly in Section 35 of the Electoral Act must be interpreted broadly to include all its literal meanings. Barton's Legal Thesaurus, fourth edition by William C. Barton at page 356, is defined to include advisedly, deliberately, designedly, intentionally, learnedly, pointedly, purposefully, with knowledge, etc. It is clear to me, therefore, that from the oral and documentary evidence adduced by the parties on this petition, the intention and fact of knowingly allowing himself to be nominated in more than one constituency, as alleged by the petitioner against the first respondent, has not been established. In other words, both the mens rea and actus reus of the Act prohibited by Section 35 of the Electoral Act 2020 were not established. One other aspect alleged by the petitioner on his claim of invalid nomination of the third and fourth respondent is that the second respondent did not comply with Section 33 of the Electoral Act in the nomination of the first respondent as vice presidential candidate. That after the withdrawal of the fifth respondent, the second respondent should have conducted a fresh primary election within 14 days for the purpose of nominating a new vice presidential candidate. Now, Section 33 of the Electoral Act stipulates that a political party shall not be allowed to change or substitute its candidate whose name has been submitted under Section 29 of this Act, except in the case of death or withdrawal by a candidate, provided that in the case of such withdrawal or death of a candidate, the political party affected shall, within 14 days of the occurrence of the event, hold a fresh primary election to produce and submit a fresh candidate to the Commission for the election concerned. The interpretation of this provision does not, in my view, cause any difficulty as to require the application of any technical rule of construction. Therefore, a literal interpretation will suffice. It therefore means that where a political party has submitted the name of a candidate pursuant to Section 29 of the Electoral Act Supra, it cannot be allowed to substitute or change that candidate except in the event of death or withdrawal of such candidate. By the proviso thereto, a political party affected is enjoined to conduct a fresh primary election for the purpose of producing a new or fresh candidate to submit to the Electoral Commission. The grounds of the petitioner here is that the first respondent withdrew his nomination as vice presidential candidate of the second respondent, but the second respondent did not conduct another primary election for the purpose of producing a new vice presidential candidate within the 14 days prescribed by Section 33 of the Electoral Act. It should be remembered that by Section 142, subsection 1 of the 1999 Constitution, a presidential candidate for election to the office of president has the sole discretion, authority, or power of nominating his associate who shall run with him in the election as vice president. The choice or nomination of vice presidential candidate is not the product of any primary election. Therefore, in my view, the requirement to conduct a fresh primary election does not apply to the nomination of a vice presidential candidate. Thus, my Lord of GJC highlighted this point in its one as follows. The fourth respondent was not required to buy any nomination form. He was the second respondent, APC's candidate at the election into the office of Senator representing Borno Central District. But before the election could hold, he was nominated as the third respondent's associate, who is to occupy the office of vice president. The fourth respondent did not buy a nomination form for the said office, and most importantly, did not contest any primary election in order to emerge as APC's vice president candidate. The petitioner in paragraph 28.2 of his petition had averred and also contended in his final address that there was a gap of about 3 weeks between the period the first respondent expressed his intention to withdraw and his actual withdrawal or purported nomination, thereby invalidating the nomination of third respondent, because the candidature of the third respondent had lapsed and was no longer in a position to constitutionally nominate a running mate. This contention of the petition is, however, misconceived. There is nothing in the Constitution which robs a presidential candidate of his right to nominate his associate, who shall be his running mate for the office of president. There is also nothing that invalidates the nomination of a new associate by a presidential candidate as his running mate after the withdrawal of a previous associate, so long as the nomination of the new associate was submitted to the first respondent 90 days before the election as mandated by Section 31 of the Electoral Act 2022. This contention of the petitioner is therefore discountenanced. It is therefore my view that, that the position of a person as vice presidential candidate not being subject to primary election, the provision of Section 33 of the Electoral Act 2022 does not apply. On that note, I hereby hold that the petitioner failed to prove the lone ground of his petition to the effect that the third and fourth respondents were not qualified to contest the election held on 25th February 2023 for the reason of double nomination. Having resolved the sole issue of this petition against the petitioner, this petition held to be devoid of any merit. we'll rise for just 15 minutes and continue with petition number 3 and 5. I can see Dr. Levy moving up and down. So, as an elderly person, I know what is going on.
My Lord, we're just wondering, sir. We just wondering, my Lord, if your brethren agree with your judgment or not. Pardon? I said, we're just wondering.
No, it's a consolidated judgment. They will give their contributions after we have read all the judgments.
Oh, my Lord, yes. Please. We just needed to know, sir.
Yes, they will give their.
Thank you very much, my Lord. Thank you, sir.
All the court.
Well, so far.
The first part. Well, we can't tell at this time if it's the first part, but first part of the proceedings has just gone underway.
Well, what the justice said was that's the fourth item, so to speak. So there's still the third one, there's the second and the first. But the reason they're taking them all up together is according to the justice. They're consolidated. In other words, they are all related one way or the other. You'll see that a number of times he would say, look, as we had previously mentioned, it's a pre-election matter. As previously mentioned, it's a pre-election matter. But at least one thing can be said clearly now, that this court has struck out APM's suit against Shettima and Tinubu for lack of merit. For the preliminary objection, the court held that the petitioner, that's APM, ought to have filed the case before the Federal High Court within 14 days from the course of action, from the day of the course of action arose. The court agreed with the respondent that the issue is statute barred, and consequently, the justice who read the lead judgment added that Section 285 sub 14C does not allow members of any political party to challenge the nomination of candidates of another political party, and consequently declared that the petitioner lacks the local standing to institute the petition.
And recall that the PDP did indeed take the matter to court as a pre-election matter, and the Supreme Court held that there was no double nomination. So on this case, the petition, the judge has ruled that the petitioner failed to prove that the third and fourth respondent failed to prove that they were not validly nominated. And on that strength, has been struck out for lacking in merit.
It's a long haul. We're still, this is pretty much, as we have been informed, the long haul.
The long haul mean by implication.
Yeah.
We could be here for another 2 to 3 hours, so to speak. But, in response to one of the council's inquiry just moments ago, Justice Salmon may have said that, it's a contributory judgment. I wonder what's the implication of that? Is it that it's a contributory judgment from all of the other 4 justices, or will there be a dissenting judgment?
Well, I guess that's what we would wait to see, because, I mean, if you recall what Mr. Quakers told us the other time, as well as Dr. Otitoju in Abuja, that look, a lead judgment could take X number of hours. And if you also recall what the justice said to us, this is just the judgment. There are other arguments in it. You have to get it later. I'm like, okay, so this whole conversation started sometime around 10 o'clock?
9:27 to be precise. I took note of the exact time that the judges walked in. But, you know, just also warn you that Senior Advocate Morrison also said that in case there's a dissenting judgment, that could also take some time. Yes, yeah.
So, so there is contributory judgment, there is dissenting judgment.
We do not know for sure.
I don't know. This is what makes. That's why maybe I should ask senior journalist of Nigeria and senior advocate of journalism, but no, that's Chamberlain and Sheon, because they went to town on the case the other time as well. But I guess we'll wait to see at the very appropriate time. The court is taking a bit of
a break,
leg stretching break. The justice said 15 minutes, and he said, going by the ages of the people informed, yes, he knew what it meant.
Justice Samani indeed said jocularly, you know, that Mr. Uzoku, Senior Advocate of Nigeria, was up and about due to age. So it was just a good time to take a break.
Well, and that's actually humane. The fact that we have work to do does not mean that we shouldn't be sensitive to the issues. So I guess that's 1 down, 3 to go so far.
You were talking about Senior Advocate of Journalism. The Senior Advocate of Journalism in Abuja was telling us earlier that there are 3 main hinges upon which, you know, the judges always rule. The strength of the case, that's the strength of the argument, the facts of the matter, and evidence, you know, tendered before the court. And we're seeing that play out in the first, you know, of the many items before the court today.
See why I called him Senior Advocate in Journalism?
Yeah.
Okay. So we'll take a short break in a moment or two, just to let you know that any moment from now we will continue with our broadcast of this. And as we mentioned to you, we've been trying. Oh, by the way, we could also inform you that not a few issues are trending right now on X about this particular case. Number one, the PPT judgment is the #1 hashtag right now. 25% in FCT is also trending. Justice Samani earlier trended, I think, #3, but now he's trending quite down the ladder, at least about #9 or so right now. And a number of other trends. Presidential Tribunal is also trending, and several others like that. So just so we know.
Also to inform you that during the first part of the proceeding, just before the break, we had more than 24,000 views.
More than 46,000 on our dedicated stream. But we have others all numbering up to about between 4,000 and 5,000 on X. Watching this live broadcast.
And I believe Senior Advocate of Journalism on the other end in Abuja, Nyota, wants to weigh in on the matter. Nyota, are you there now?
Well, I'm not sure that he is, but let's see. Most certainly when he is, he will most certainly be brought in to have a conversation with us on the matter. So we need to take a little bit of break in a moment or two, but just to let you also know that the court, the Presidential Election Petition Court, has declared that as at this moment, APM suit against the Vice President Shetima and President Tinubu has been struck out for lack of merit. The critical case made was that, look, this is supposed to be a pre-election matter and consequently should have been dealt with within 14 days from the day the course of action arose.
Actually, Ayo, we surpassed the 46,000 mark. I think that was the last time we checked. the update now is that we hit 70,000 views.
Oh, wow.
At the peak of the proceeding, during the reading out of the judge's ruling by Justice Haruna Samani.
See?
Yeah, 70,000. And we're bound to surpass that when there's a resumption of the continuation of proceedings, when the judges begin to read the ruling from the other petitions.
But at this moment, maybe because of the break, we've come down to 59,000 watching as we speak. And that's just for one of our views, as we've mentioned to you earlier. We have two other streams that are doing about the same thing. So, well, as I'm being corrected now, someone is saying that the journalistic equivalence of SAN is SAP, Senior Advocate of the Pen. Well, I guess we'll come back to that some other time. So if we can take a short break, and we'll be right back with you to take on more of that. Don't forget, so far, the decision of the court remains that the APM suit against the president and the vice president have been struck out for lack of merit. And the court has said it's something that should have happened at least 14 days within the time it happened and the cause of action that should have arisen. We'll be right back.
The Nigerian Police Force has diligently emplaced all necessary deployments and security measures during this critical period, as officers and men are fully prepared to maintain order and enforce laws while respecting the rights and freedoms of all citizens. Furthermore, the Nigerian Police Force strongly cautions all individuals, including mischief makers and political gladiators, to be cautious in their actions and statements, as the force will not condone activities capable of inciting violence or causing a descent into anarchy. It is imperative for all citizens to embrace peace and maintain calm, regardless of their political affiliations, to ensure a peaceful and secure environment.
Well, in another 20 minutes, it'll be 12 o'clock. So still some time to get the rest of the balance of judgment. But as you can see, my colleague, Shola Shuyele, is standing by right there at the tribunal, well, look at the PEPC, Presidential Election Petition Court, to give us an update. Shola, good morning. How's it been so far? We've received some reports from you. Hear exactly what you're saying to us, but well, as you can see, she's standing by right there, and she's going to give us a live update of what has been happening so far. As we mentioned to you earlier, the formerly named Twitter, X, is agog with a lot of trends about this particular issue. And as we have told you, the justices said, look, we're going to take a short break of about 15 minutes to do the needful and then come back to us. Well, you mentioned Nyota the other time. Nyota is also right there in Abuja. Hopefully, he will have a couple of people to speak to us. But for now, just to give you that update, that expectations are high, and it's also instructive what the police spokesman mentioned earlier, that every one of us should recognize that we have one nation, that we must prioritize its interests. Everyone who is agitating one way or the other, we definitely love the country Nigeria. That's the reason we're doing everything that we are doing. So now that that is our reality, our words, our thoughts, our deeds should be guided in that reaction.
Absolutely. Even though civil society has advocated, before now, just hours before today's ruling, that the right to protest, by the civil society should be respected. But amid all of that, we must prioritize the stability of the polity above all other interests. So if there will be any protests should be done responsibly without any violence.
Absolutely.
Every agitation must be ventilated responsibly.
Because it's for the love of country that every one of us is doing what we are doing, and that should be the major thing. Well, you asked for Nyota the other time. Well, he's also, should I say, sitting by, ready to take this on. So Nyota, so far, so good. 1 down, 3 to go.
I was actually looking at the trends, and I noticed a couple of things that are really, really trending. For instance, it appears all of Nigeria is watching, and on all the platforms. Yes, a lot of people are watching what we're doing here on mainstream television. Some are watching via live stream on the different platforms. We're streaming on Facebook, YouTube, and all of that. But looking at the trends on X, I see that the Supreme Court has about 137 posts. Top trend, 134 at the Supreme Court. Peter will be 137 posts. Top trend, those are among the top trends. The PPT judgment is 66.2 thousand posts. Trending in Nigeria, 25% FCT is also top on the post. Justice Samani is amongst the top trends today. But everyone wants to know what the judges are saying. Indeed, the APM case struck out said, the judges said, I'm paraphrasing it, not their words exactly. It looks like as though they're interfering in another party's matter when it comes to double nomination, and then that the Supreme Court had settled the matter of double nomination, besides the fact that they didn't file that case in time. But I'm not here alone. I have Dr. Titoju here, who's been monitoring what's happening there. You should have seen him scribbling. He was, you know how it is in primary school when you had, is it primary or secondary school, when the teacher comes in and says, take notes, bring out your pens and papers, you're taking notes. That's what Dr. Titoju was doing here. So I'm sure he'd have some comments on this judgment. We also have here in the studio joining us Professor Ademola Abbas, who's a professor of international law and global affairs analyst. He's a visiting senior research fellow, University of Reading, UK, former special advisor to the Lagos State Governor on overseas affairs and investment. Thank you for joining us, Professor Abbas.
Thank you very much for having me.
So before we come to you for a fresh perspective, let's find out from the man that was taking the notes earlier. Dr. Titoju, what were you writing?
Well, I was actually following the decisions that has been laid down by the Supreme Court via the decision of this of the presidential election petition court. You know, very fundamental. The court went through the objections, took APM's objections, even though it has been, of course, consolidated, the entire petition. Each of those petitions will still be independent of itself. Now, the APM petition was struck out at the preliminary stage. And then the judges went down into the substance and also dismissed it. So it was struck out, merit was entertained, and was finally dismissed. In arriving at the decision, at the preliminary stage, the court found that the issue of double nomination is a pre-election matter. That they don't have jurisdiction to entertain it. And of course, we have legions of authority that when the pre-election matters are, brought before the petition, the petitioner, the court, the tribunal, which is the Presidential Election Petition Tribunal, would not entertain such election because they are not issues that prompt up during election.
Okay, so while Dr. Chistoji is talking about his take from the judgment of the Election Petition Court, we'll bring you live footage of what's going on within the courtroom. The lawyers are still seated, waiting for the judges who have taken a break to return from their break and then continue. Still have some other judgments that need to be passed. The petition of the PDP and the Labour Party would have to come up next. I can't say which particular order, but we'll get to that as we go along. And I mentioned earlier that we have Professor Abbas. Again, our studio within the court premises is still there live. Our colleagues Chimlin and Sean will be joining us much later. We also have our correspondents in the court premises and outside the court premises also keeping tabs on what's happening. We'll bring them to you in the course of this conversation. Shola Shwele is there, Ella is also there. But Professor Baz, the question some people are asking is, why say if you have any grievance, go to court? If these matters had already been settled, going by what the judges said, had already been settled by the Supreme Court, why tell people go to court on the same matter? Is it a question of the lawyers not paying attention of the judgments that have been given before?
Well, thank you very much. It's not necessarily so, but you're right in that question. It's a very fundamental question because I think it's also going to play out in the subsequent judgment the court is going to give. And I say that because even if a court has given a judgment before, it does not mean that the court is bound by that judgment itself. As an example, so number one, you have a distinction between the lower court and the higher court. Say, for instance, the high court gives a judgment on a particular issue. The higher court might come and give a different judgment on the same point of law, probably because the lower court errs in law when it did that decision also. But another thing is sometimes even a higher court itself might give a judgment. Even Supreme Court can overrule itself.
Yes.
And people keep forgetting that. And that is why lawyers cannot presume, or let me say litigants cannot presume that, because there is an existing authority or precedent on this, if I were to go to court, the result would automatically be the same thing. That is a mistake we are making. And I think that can pan out in a lot of issues. And I don't want to preempt certain discussions today. It's going to pan out in a lot of issues. I think I've had an opportunity to speak on this platform before about the fundamental. I remember one of the arguments that was made in the past about Abuja 25% and this and that. And I said, look, even if there is an existing judgment of the Supreme Court on this side, the same court can distinguish another case on the same point and come to a different conclusion. It is completely acceptable.
For clarity for those who are not lawyers, what would you say that would be based on? Is it based on the judgment of the sitting justices at that point in time, or is it based on maybe newly developed evidence that has come before the judges? What would you think would make that kind of
a lot of things could be responsible for that. One is the fact that a court has an opportunity to review its own judgment, as in Roe versus Wade in the US, for instance. The court can come back and take another look at a judgment it gave some 10, 20 years ago. Don't forget, the law is not a brooding omnipotence in the sky. And as one of the judges say, the prophecy of what the courts will do are not more pretentious, is what I mean by the law. What it means is that, look, courts are made of human beings. Human beings can make errors. It's normal. And don't forget what this famous judge, the Supreme Court said. He said, we are final, not because we are infallible. We are infallible only because we are final. In other words, he realized that even the Supreme Court itself could be fallible sometimes.
But it looks like the justices are back, so we're going back to the appeal court for the continuation of the sitting of the Presidential Election Petition Court.
To take generic size and label. First category consists those applications seeking to strike out some paragraphs. They are first respondent's motion filed on the 19th of April 2023 which essentially sought for the following reliefs. 1. Order striking out paragraphs 60 to 79, 83, 98, and 99 of the petition for being vague, nebulous, and imprecise. After striking out those paragraphs, strike out grounds of petition alleging corrupt practices, failure of the second and third respondents to score majority of law. 2. Strike out paragraphs 57 and 58 of the petition for being inconsistent with paragraphs 65, 67, 70, and 71 of the petition. 3. Strike out prayers 3, 5, Roman 1 and 2, paragraph 102 of the petition, as well as paragraphs prayers 1, Roman 3, 4, Roman 1, 2, and 3, and 4 in paragraph 102 of the petition, and thereafter dismiss the petition, eliminating being academic, being an abuse of. Second and third respondents' motion filed on the 13th of May 2023 sought for the following. 1. Order striking out paragraphs 9, 2, 5, 60, 66, 73, 75, 78, 92, 95, 96, and 97 of the petition, being vague, imprecise, generic, and 2. Order striking out paragraphs 80 to 82, 84 to 98 for failure to disclose facts, support the ground that the second and third respondents did not score majority of law. 3. Order striking out paragraphs 80 to 82, 84 to 98 on the failure to score 25% of the FCT, which cannot be premised on the ground for failure to score majority of law. The fourth respondent, on the other hand, filed motion dated 8th of May 2023, seeking for the following. An order striking out this petition for being incompetent and in gross violation of paragraph 4, sub 1, sub D, sub 2, sub 7 of the first schedule to the Electoral Act 22. Order of this honorable court striking out grounds 2 of the petition and all associated facts contained in paragraphs 20, 2, 33 to 78 of the incompetent. 3. Order of this honorable court striking out paragraphs 2, 20, Roman 2, 33 to 78 of the petition for not being in support of any valid ground in the petition. 4. Order of this honorable court striking out paragraph 21 to 27, 29 to 100 of the petition for being non-specific, lacking in clarity, generic, nebulous, vague, speculative, and gold digging in contravention of the first schedule to the Electoral Act. In the above applications, all the respondents relied on the provisions of paragraph 4, sub 1, sub D, and sub 2 of the first schedule to the Electoral Act, and variously argued that the paragraphs of the petition, which they have listed, are liable to be struck out for being vague, generic, imprecise, and nebulous. So arguing they relied on several cases which are cited here. By contrast, the petitioners have submitted that the respondents' objection in the listed paragraphs of the petition are not vague, nebulous, sufficiently pleaded. On this point, the petitioners cited several cases which are reproduced here. Petitioners further argued that the facts in Belgore and Ahmed, and Ipiazu and Oti, Ogu and Ekwere Madu, Ojuku and Eradua, PDP and INEC and others, and Soga and Iguede, and all other cases cited by the respondents are not the same with the facts of this petition. Those documents were never pleaded by reference or incorporation in those cases. Additionally, petitioners have relied on paragraph 17.2 first schedule to the Electoral Act 2022 and argue that the respondents have joined issues with the petitioners on those paragraphs. Having failed to seek for further particulars, they must be taken to have understood the state paragraph. Having failed to seek for further particulars, they must be taken to have understood the state paragraph. They relied on some cases. Now, resolution. I've carefully considered the submissions of the parties and the judicial authorities cited. It is trite that adversarial civil litigation is basically fought on pleadings. It is the foundation of the parties' respective cases. General principle of law is that such pleadings must sufficiently and comprehensively set out material facts so as to ascertain with certainty and clarity the matters or issues in dispute between the parties. This is because the purpose of pleadings is to give adequate notice to the adversary if the case is to meet, to afford him the opportunity to properly respond to such case. Its aim is to bring to the knowledge of the opposite side and the court all the essential facts, therefore a safeguard against element of surprise. This Shodipo versus Lemini Kane, Odom and others versus PDP and others, Alassane and another versus Ishaku, citations given. The requirements of pleadings in election petitions are primarily provided in paragraph 4 of the first schedule to the Electoral Act 2020. Specifically, paragraph 4 sub 1 sub D mandates that, and I quote, an election petition shall state clearly the facts of the election petition and the ground or grounds on which the petition is based, the relief sought by the petitioner, unquote. Subparagraph 2 of the same paragraph further provides that, and I quote, the election petition shall be divided into paragraphs, each of which shall be confined to a distinct issue or major facts of the election petition, and every paragraph shall be numbered consecutively, unquote. In addition to the provisions of paragraph 4 of the first schedule to the Electoral Act, paragraph 54 of the same schedule to the Act has made applicable to election petitions the rules of procedure in the Federal High Court of 2019, subject to such modifications as would bring same in conformity with the provisions of the Act. By Order 13, Rule 4 of the Federal High Court Civil Procedure Rules 2019, every party to an election petition shall ensure that amendments in their pleadings, and I quote, contain in a summary form the material facts on which the party pleading relies for his claim or defense, as the case may be, but not the evidence by which they are to be proved, and shall, when necessary, be divided into paragraphs and numbered consecutively. Quote. By subparagraph 4 of that rule, such facts contained in the pleading must, and I quote again, be alleged positively, precisely, and distinctly, as briefly as is consistent with a clear statement. Quote. The aforementioned provisions contained in the first schedule to the Electoral Act 2022, as well as the Federal High Court's Rules 2019, state the mandatory requirements of pleadings in election petitions. The requirements for clarity and precision of fact required by paragraph 4 of the first schedule to the Electoral Act means that amendments must not be vague, ambiguous, or unclear, leaving room for speculation or conjecture, while the requirements of distinctiveness means that each amendment must contain a clearly understandable allegation, and there should be no confusion as to the linkages between facts contained in the amendments in the petition, and ascertaining the allegations being made in the petition. In particular, paragraph 4 sub 1 sub D, relating to the facts of the petition, the grounds on which it is based, and the relief sought by the petitioner have been severally considered and interpreted by the appellate court. In Belgore and Ahmed Supra, the complaint against the amendments in the petition was that they were unspecific, generic, speculative, vague, unreferable, omnibus, and general in terms. In that case, the Apex Court specifically held as follows, and I quote, pleadings in an action are the written statements of the parties wherein they set forth the summary of the material facts on which each relied in proof of his claim or his defense, as the case may be, and by means of which the real matters in controversy between the parties and to be adjudicated upon are clearly identified. Although only material facts are required to be pleaded in a summary form, they must nevertheless be sufficiently specific and comprehensive to elicit the necessary answers from the opponent. They must contain such details as to eliminate any element of surprise to the opposing party. In this case, where the dispute involves the election in as many as 895 polling units, the pleading in the petition, which allege electoral malpractices, non-compliance, and/or offenses in, quote, some polling units, many polling units, most polling units, or several polling units, cannot be said to have met the requirements of pleadings as stipulated in paragraph 4 sub 1 sub D of the first schedule to the Electoral Act and or Order 13, Rule 4 sub 1, 5, 6, and sub 1 of the Federal High Court Civil Procedure Rules 2009, unquote. Indeed, in PDP and INEC, the Apex Court was categorical when it held those, and I quote, on whether the affected paragraphs were rightly struck out. I have read the affected paragraphs and found that they relate to allegations of non-voting in several polling units, disruption of election, non-conclusion of election, thumbprinting of ballot papers, falsification of election results, widespread disruption, irregularities, and malpractices without providing particulars or the polling units where the alleged malpractices took place. The lower court was therefore right when it held as follows. Above the paragraphs above, in my view, are too generic, vague, lacking in any particulars, and they are not tied specifically to any particular polling unit or any particular number of people who are alleged to be disenfranchised. The fact that a party can file further particulars or deny in a reply the affirmations in the pleading must not be general, must be specific as to facts. It is settled law that a petitioner's obligation and declaration of the results of the election based on uploaded results, the votes recorded for the second respondent did not comply with the legitimate process of computation of the result and disfavored the petitioners, unquote. In Rivers, Lagos, Taraba, Benue, Adamawa, Imo, Bauchi, Borno, Kaduna, and Plateau, and other states of the Federation. Petitioners neither specified the uploaded results nor the votes illegally recorded by the second respondents and how they were disfavored. Paragraph 83 of the petition, where the petitioners claim that the first respondents scored the majority of lawful votes cast at the election, they did not state the majority of lawful votes they claim to have scored, especially as elections and the determination of who won is about figures. In paragraph 99 of the petition, where the petitioners say they will rely on Form EC8As to establish that substantial votes were unlawfully credited second respondent, they failed to state the figures of the unlawful votes credited to the second respondent. In the petition, petitioners merely made generic allegations of various irregularities and malpractices against the respondents without specifying the polling units, collation centers, or specific places where the alleged irregularities and malpractices occurred. Rather, petitioners only stated that they will rely on spreadsheets, inspection reports, and forensic/expert analysis, which they say they have incorporated in the petition by reference. But none of the spreadsheets, inspection report, and forensic/expert analysis was attached and served along with the petition on the respondents. Rather, they were only listed as items 35 and 36 in the list of documents to be relied upon by the petitioner. It is only in paragraph 62 and 64 of the petition where the petitioners allege that the first respondents suppressed the lawful votes of the petitioners and inflated the votes of the second and fourth respondents in Rivers and Benue states. That the petitioners gave figures of the votes, where the petitioners gave figures of the votes suppressed for the petitioners and those inflated for the second and fourth respondents, and also stated that they claim to be the actual figures scored, what they claim to be the actual figures scored by them and by the second and fourth respondents. But all other paragraphs of the petition where irregularities and malpractices were alleged are bereft of any material details of the polling units or places where they were alleged to have taken place, or the figures of votes alleged to have been suppressed, inflated, or inflated. It is also pertinent to observe that in paragraph 79 of the petition, where the petitioners allege corrupt practices, they merely stated that they are repeating their pleadings in support of the grounds of non-compliance to be in support of their allegations of corrupt practices. It should be noted, however, that not every ground of non-compliance will amount to corrupt practice. In fact, the standard of proof of non-compliance differs from that of corrupt practices. While standard of proof of non-compliance is on the balance of probabilities, that of corrupt practices is beyond reasonable doubt. PDP, INEC, Mohammed Wamako, Board of Customs and Excise versus Alaji Ibrahim Barrow, citations on the record. It is instructive that in paragraphs 3.2, 3.21 of their submission, in opposition to the first respondent's objection, petitioners appear to have conceded that in the averments of the petition, they have not specified the particular polling units where the alleged irregularities and malpractices occurred, or specified the figures of the votes or scores which they are alleged to have been suppressed, inflated, or inflated. Rather, they stated that the details of the polling units are contained in the spreadsheets and forensic analysis reports which they have incorporated and made part of the pleadings by reference. See particularly on this paragraph 67 of the petition. Petitioners further argued that since the respondents have failed to apply for further particulars under paragraph 17(1) and 2 of the first schedule to the Electoral Act, they are deemed to have understood those arguments. However, by paragraph 15 of the first schedule to the Electoral Act 2022, when the petitioner claims, and I quote, that he had the highest number of valid votes cast at the election, the party defending the election or the return at the election shall set out clearly in his reply particulars of the votes, if any, which he objects to, and the reasons for his objection against such votes, showing how he intends to prove the hearing that the petitioner is not entitled to succeed, unquote. This provision presupposes that the petitioner has a first duty to state clearly in his petition the particulars of such votes, in respect of which he claims to have scored the highest number of valid votes, and thus entitled to be returned as the winner. This also presupposes that it is only after the petitioner has supplied the particulars of the votes in support of his claim that he scored the highest number of valid votes, that a respondent will then have a duty to object to any part of the particulars of such votes supplied by the petitioner in order to show that the petitioner is not entitled to succeed. With regard to the petitioner's contention that they have incorporated into the petition by reference the spreadsheets and forensic analysis report containing details of the polling units where they allege that the irregularities and malpractices occurred, it is right that for a document to be properly incorporated as part of pleadings by reference, the document must not only be referred to in the pleadings, but it must also be included as part of the pleadings to be served on the adverse party, so as to enable the adverse party to properly respond to same in his defense. Indeed, in all the cases of EFCC reign, Ekpomo Polo versus Edere Moda, Marine Management Associates Incorporated versus NMA, and Dingyadi and Omako Supra, which were relied upon by the petitioners, the documents which were incorporated as part of the pleadings by reference were served along with the pleadings on the adverse party. In considering a similar scenario, this court, by Ayola, JCA, as he then was, held in Nigeria Merchant Bank PLC versus Ayedun Investment Limited as follows, and I quote, "Before I part with this appeal, it is pertinent to advert to one pleading question raised in this pleading in regard to the consequence of a party pleading that he will rely on certain unspecified documents at the trial. The plaintiff contended that such arguments made the contents of such document part of the pleading. In this case, the plaintiff in paragraph 30 of the statement of claim pleaded thus: the plaintiff at the trial will rely on all letters and documents between the parties pertaining to this suit. Although the principle is established that if an agreement in writing is referred to in a pleading, it becomes part of the pleading, and it is open to the court to give the agreement its true legal effect, irrespective of the term used in the pleading to indicate such effect. That proposition of law should not be used to cover such argument as shown above, which lacks specificity. Besides, a report such as Exhibit P22 in this case, prepared by a witness for the plaintiff and tendered at the trial by the witness, cannot be described as documents between the parties pertaining to the suit. At the appropriate time, when the occasion arises, the true ambit of the proposition of law in such case, such as Bank Genesis versus Petai Limited, ought to be defined, unquote. In the instant case, the spreadsheet and forensic report, which were documents prepared by the petitioner's witnesses, were not served along with the petition on the respondent, but were only listed as documents to be relied upon at trial. I'm not oblivious of the petitioner's argument in relation to paragraph 4 sub 5 sub C of the first schedule to the Electoral Act 2022, which provides that the election petition shall be accompanied by, quote, copies or list of every document to be relied on at the hearing of the petition, quote. This provision undoubtedly only relates to front-loading of documents to be relied upon by the petitioner as his evidence during trial. Contrary to the petitioner's argument, it does not cover incorporation of documents into pleadings by reference. It is also noteworthy that the spreadsheets and forensic reports, which the petitioners claim to be incorporating into the petition by reference, are actually documents prepared by the petitioner's witnesses. In other words, spreadsheets and forensic reports are not documents which are outside the control of the petitioners and which they have to obtain by subpoena. Being the petitioner's own documents, they ought to have served those documents along with the petition on the respondent, so as to enable the respondent to counter same by engaging their own experts appropriately respond to same if they so desire. That indeed is the essence of pleadings, so as to avoid taking the other party by surprise. Petitioners have also tried to argue that the respondents, having joined issues on the general allegations contained in the petition, they are deemed to have understood same. With respect, this is also not a tenable argument in view of the grossly generic allegations made in the petition. Faced with a similar scenario, this court, Agungwimiju JCA, as he then was, now JSC, held in Udiaga and another was Omegara, as follows, and I quote, the argument of appellant's counsel that the respondents did not adequately traverse the petition is unfounded. The petition itself contained general complaints. There was no effort to pinpoint in the pleadings the various places where corrupt practices, non-voting, use of violence, forgery, rigging in polling units, passive thumbprint of ballot papers, fictitious entry of election results took place. Therefore, there was a general corresponding reply denying the allegations in general terms from the respondents. If the petitioners did not plead particulars, how could the respondents traverse non-existent particulars? Governments in the appellant's pleadings should have contained details of the allegations and complaints which the respondents could reply in detail in their own pleadings. Appellants expected the respondents to reply to the various specific allegations contained in the witness statement filed along with petition. That is not the correct procedure. Those specific allegations should have been in the pleadings. The pleadings must show the facts disputed, while the witnesses would give evidence of these facts. In election petitions, it has been held that there is the need for particulars where required in order to prevent taking adverse party by surprise. It is not the function of particulars to take the place of necessary arguments in pleadings, unquote. Indeed, in a presidential election like the one being challenged in this petition, where it was held in 176,846 polling units, 8,809 wards, 774 local government areas, 36 states, and the Federal Capital Territory, it is unimaginable that governments in the petition which merely allege irregularities and/or malpractice without specifying the particular polling units or particular collation centers where the irregularities or malpractices have taken place will be regarded as proper, merely because the respondent has not requested for further particulars. Tibel Gore Ahmed and PDP. Also, when an election petition is by nature a declaratory action, in which the petitioner succeeds only on the strength of his own case and not on the weakness of that of the respondent. Ibusari versus Adepoju, Oyetola versus Adeleke, and Anazong versus Onubogu, citations on them. It is in this respect that a petitioner has an obligation to set up a clear, unambiguous, precise, and positive case in his pleadings, since pleadings is the foundation of a party's case, and it is to the pleadings that the parties to litigation, as well as the court, are all bound. See Enang and others versus Adu. It is in the light of all the foregoing that I find and hold that the motions of the respondents listed above succeed. In consequence, paragraphs 9, 60, 61, 66, 67, 68, 69, 70, 71, 72, 73, 76, 77, 78, 83, and 99 of the petition, which have failed to state the specific polling units, collation centers, or the specific places where the irregularities and malpractices are alleged to have occurred, or the figures of votes which are being claimed are grossly vague, imprecise, nebulous, and bereft of material particulars, and have thus failed to meet the requirements of paragraph 4, sub 1, sub D of the Electoral Act 2020. In accordance with paragraph 4, sub 7 of the said schedule, the said paragraphs are consequently hereby struck out. On the first respondent's prayer to strike out paragraphs 57 and 58 of the petition for being inconsistent with paragraphs 65, 67, 70, and 71 of the petition, the essential contention of the first respondent is that whilst in paragraph 57 and 58 of the petitioners have alleged that the first respondent failed to comply with the order of inspection granted by the court, petitioners have in paragraphs 65, 67, 70, and 71 stated that they will rely on the report of the inspection. Additionally, the first respondent also argued that the first petitioners have alleged that the election was marred by corrupt practices and was not conducted in substantial compliance with the Electoral Act 2022. They have also alleged that they have scored majority of lawful vote cards and should be declared the winner. Relying on some cases which are produced here, first respondent urged the court to strike out the paragraphs as well as prayers 1 to 4 on the one hand, and prayers 5 sub 1 and sub 2 on the other hand for being inconsistent. Conversely, the petitioners contend that the law allows them to plead conflicting facts insofar as they have claimed alternative reliefs. They referred to the alternative reliefs at pages 35 to 37 of the petition, relied on some cases which are reproduced here, as well as the ruling on similar objection by the 2019 Presidential Election Court in the previous case. As rightly submitted by the petitioners, the reliefs in this petition, which I have reproduced at the beginning of this ruling, are undoubtedly sought in the alternative. The settled law is that reliefs can be sought in the alternative, and where so sought by a party is at liberty to plead conflicting facts in line with the alternative reliefs he has sought. In Adigije versus Mwaugu, and others. This court, Ogunwumi Judgement, as he then was, held that, and I quote, in civil litigation and indeed in election matters, a party can make two seemingly contradictory pleadings, leading to two different heads of claim. That is why a petitioner can claim that the election be annulled for reason of substantial non-compliance and in the same breath claim that he won the election by a majority of lawful. Petitioner may plead the same set of facts, ground alternative relief. Those pleadings are not ipso facto held to be self-contradictory. The court can only grant one relief as the party must decide which relief is best supported by the evidence on record. Unquote. See also on this metal construction West Africa Limited versus Abodering, citation given. In any case, the first respondent, which is the body that conducted the election and to whom the first petitioner's nomination documents were submitted by the second petitioner, admitted in paragraph 4 of the petition, wherein petitioners averred that the first petitioner was duly sponsored by the second petitioner, on whose platform the first petitioner contested. I therefore have no hesitation in this countenance in this ground of the. Now, second category of objections or applications. These are the categories that challenge the competence of the petition on some of its grounds. The second category of the respondents' applications that challenge some of the grounds of the petition and or the competence of the petition are as follows. First, respondents' motion filed on the 19th of April 2023, seeking 1. Order striking out ground 2, paragraphs 33 to 79 and reliefs 5, Roman 1 and 2 of the petition on transmission of election results for being cut off by issue estoppel. 2. Order striking out paragraphs 20, Roman 1, 21, 23, 24, 25, 26, and 27 on nomination of the second and third respondents for lack of jurisdiction. Second and third respondents' motion filed on the 12th of May 2023 seeking for the following. 1. Order striking out or dismissing the petition for being incompetent and defective. 2. Order striking out grounds 1, 2, and 3 of the petition. 3. Order striking out reliefs 1, Roman 1 to 3, 2, 3, 4, Roman 1 to 4, 5, Roman 1 and 2 of the petition. The above two motions are predicated on several grounds, which are reproduced herein. It is the view of this court that the issue relating to ground 1, challenging the qualification of the second respondent to contest the election, the issue relating to the competence of ground 2, relating to the allegations of corrupt practices and non-compliance of the Electoral Act 2022, and the plea of estoppel in relation thereto, as well as the issue relating to competence of the reliefs sought in this petition, are matters on which the parties have joined issues in the main petition, the merits of which will be decided after considering the pleadings and evidence laid in the petition. It is the settled position of law that a court should not comment on or decide at preliminary stage matters or issues which are supposed to be decided in substantive case. Wanko and others versus Eradua. Ocholi on Onojo James, SAN versus INEC, citations on the record. Hence, while leaving those issues to be dealt with on the merits of the petition, we shall determine at this stage the objections relating to the petitioner's locus standi, the non-joinder of necessary parties, and the objection to the competence of the petitioner's replies, the respondent's replies, or to some paragraphs of the petitioner's replies. Lack of locus standi of the first petitioner. The second and third respondents and the fourth respondents in this motion filed, their motion filed on the 8th of May 2023, also objected to the first petitioner's locus standi to bring this petition. The principal contention is that the first petitioner was in contravention of section 77 sub 3 of the Electoral Act 2022. They argue that the first petitioner, who was a member of the People's Democratic Party and who was screened as one of its aspirants for the presidential election, only resigned his membership of that party on the 24th of May 2022, joined the second petitioner on the 27th of May 2022. They contended that as at 30th of April 2022, the first petitioner could not have been in the register of members, second petitioner, which it submitted to the first respondent 30 days before the presidential primary election, as mandated by section 77 sub 3 of the Electoral Act 2022. Since the first petitioner is not in the membership register submitted by the first respondent by the second petitioner, the first petitioner lacks the locus standi to challenge the outcome of the election. By contra, the petitioners submitted that the issue of membership of a political party is a domestic affair of the political party concerned. The court lacks a jurisdiction to entertain it. They relied on the cases that are reproduced here. The courts have consistently held in a plethora of cases that the issue of membership of a political party is an internal affair of the it is not a justiciable issue, and courts have no jurisdiction to entertain it. Say Enang versus Asukwo, others, Sani and Galadima, and Tumbido versus INEC, citations on the record, as well as all the cases cited above by the petitioner. The provision of Section 77 sub 3 of the Electoral Act 2022, which only mandates every political party to submit the register of its members 30 days before its party primaries, cannot be invoked by the respondents for the purpose of challenging the first petitioner's membership of the second petitioner. It is only the second petitioner that has the sole prerogative of determining who are its members. And having sponsored the first petitioner as its candidate for the presidential election, first petitioner has satisfied the requirement of being a member. Second petitioner, as provided for in Section 131 sub C, the 1999 Constitution. It is not within the rights of the second and third respondents and the fourth respondent to question the first petitioner's membership, second petitioner. This ground of objection is hereby overruled. No enjoinder of necessary parties. First respondent in his motion of 19th of April 2023, and the second and third respondents, as well as the fourth respondent, raised the issue of non-joinder of Abubakar Atiku or the People's Democratic Party, who came second in the presidential election as respondents to the petition. The contention of the respondent then is that since by relief 1 Roman 3, 4 Roman 4 of the petition, the petitioners who came third in the presidential election are seeking to be declared the winners of the election. The petition cannot be effectually and completely determined without the joinder of Abubakar Atiku or the People's Democratic Party, who came second in the election, as respondents to the petition. For that reason, the respondents have contended that this court lacks the jurisdiction to entertain the petition as constituted. Place reliance on JGD and INEC. Buhari and Obasanjo, citations on the record. No position, however, petitioners relied on the cases of Obasanjo and Eradua, Buhari and Yusuf, Akpoti and INEC, and contended that only statutory respondents provided in Section 133 of the Electoral Act 2022 are necessary parties to the petition. The petitioners are not under any obligation to join Abubakar Atiku and the People's Democratic Party. By Section 133 of the Electoral Act 2022, the statutory respondents in an election petition are 1. The person whose election is being complained of, and 2. The Independent National Electoral Commission, which will also be deemed to be defending the petition on behalf of its officers whose conduct is complained of. In the cases of Obasanjo and Eradua and Buhari and Yusuf Supra, cited by the petitioners, the Supreme Court categorically held that only the statutory respondents stated in Section 133 of the Electoral Act are necessary parties, and that losers at an election who are not statutory respondents are not necessary parties at an election. By the import of Section 133 of the Electoral Act 2022, the contest in an election petition is strictly between the petitioner who challenges the outcome of the election, the person who was declared the winner of the election, and the commission that conducted and declared the outcome of the election. This means that every candidate who lost the election and who is desirous of challenging the outcome of the election is expected to file his own petition against the winner of the election. And in so doing, is not required to join any other candidate who lost the election like himself. It is in furtherance of this that paragraph 50 of the first schedule to the Electoral Act 2022 requires an election tribunal or court to consolidate 2 or more petitions which are presented in relation to the same election or return. As rightly submitted by the petitioners, the case of JGD and INEC cited by the first respondent is clearly not applicable to this case, since the decision in that case is that Maimala Buni was a necessary party because by the provisions of Section 183 of the 1999 Constitution, would have ceased being a governor of Yobe State if the case made out in the petition that you could not combine the offices of governor of Yobe State, acting chairman of the All Progressive Congress is sustained. In this case, Abubakar Atiku, the People's Democratic Party, who were only runners-up in the presidential elections, are not necessary parties, as they are not statutory respondents to this petition. And the petitioners hearing have no obligation to join them in this petition. Again, in Buhari and Obasanjo Supra, relied upon by the respondents, the Supreme Court reconfirmed its decision in Buhari and Yusuf Supra that there is no obligation on the petitioner to make a candidate who lost an election like himself a respondent to his petition. Also, as in this case, Abubakar Atiku and the People's Democratic Party have filed a separate petition number CAPEPC 05-2023, which, as mentioned in the earlier part of this ruling, this court has consolidated with the petition signed with paragraph 50 of the first schedule to the Electoral Act 2020. This ground of objection to the competence of the petition is unmeritorious, is accordingly overruled. On the arguments over the competence of the relief sought in this petition, it is my view that the reliefs which the court can grant in an election petition are statutory, as provided in section 136, sub 1, sub 2, sub 3 of the Electoral Act 2020. Therefore, the determination of whether the relief sought by a petitioner are grantable can only be made after trial. Challenge to competence of the petitioner's replies. The third category of the applications of the respondents seek to strike out the petitioner's replies or some paragraphs of the replies. These are first respondent's motion filed on the 9th of May 2023 seeking 1. Order striking out the petitioner's reply, the first respondent's reply for being incompetent. 2. In the alternative, order striking out paragraphs 15, 16 Roman 1 to 7, 17 to 20, 22, 24, 25, 27 to 32, 34, 36, 37, 38, 40, and 41, petitioner's reply for offending the provisions of the first schedule to the Electoral Act 20. Second and third respondents' motion filed on the 13th of May 2023, seeking for order striking out petitioner's reply of 21st April 2023 for being incompetent. 2. In the alternative, order striking out paragraphs 8 to 17, 19 to 32, 34 to 42 of the petitioner's reply for introducing new facts. Fourth respondent's motion filed on the 8th of May 2023 prays for 1. Order striking out paragraphs 15 to 32 of the petitioner's reply, the fourth respondent's reply, as well as the witness statement on oath with failure to deny the fourth respondent's allegation. 2. Order striking out paragraphs 5 Roman 1 to 9, 15 Roman 1 to 7, 16 Roman 1 to 7, 17 Roman 1 to 7, 18 Roman 1 A to H, 18 Roman 2 A to E, 18 Roman 3, 5 and 7, A to B, A and B, Roman 8 A and B, Roman 9, Roman 11, 20 to 25, A to D, 26 Roman 1 and 2, 27 to 31 of the petitioner's reply, the fourth respondent's reply for raising new issues. All the respondents challenge the competence of the petitioner's reply, their respective replies, or in the alternative, the paragraph thereof, which they have variously listed above. Their essential contention is that the replies, or in the alternative, the paragraph thereof, have either raised or introduced new facts aimed at substantially altering the grounds and reliefs in the petition, or a mere repetition or a hash of the facts contained in the petition, contrary to the provisions of section 16, paragraph 16, sub 1 A and B, the first schedule to the Electoral Act 20. Respondents replied on several judicial authorities, which are reproduced. In response, the petitioners have argued that they have merely reacted to the fresh/new issues raised in the replies of the respondents, which attempted to justify the grounds of non-qualification of the second and third respondents, as well as the non-compliance by the first respondent to the Electoral Act 2020. They relied on Silva and INEC, PDP versus Ezeonguka, citations on the record, and urged the court to discountenance the objections of the respondents and uphold the petitioner's reply. Now, paragraph 16, sub 1A of the first schedule to the Electoral Act 2022 provides as follows, and I quote, if a person in his reply to the election petition raises new issues or facts in defense of his case, which the petition has not dealt with, the petitioner shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, petitioner's reply in answer to the new issues of fact. So, however, that A, petitioner shall not at this stage be entitled to bring in new facts, grounds, or prayers tending to amend or add to the contents of the petition filed by him. Quote. By the import of paragraph 16 sub 1A of the first schedule, petitioner may, in filing a reply, respond to allegations of new facts raised in a respondent's reply to the petition, provided he does not, in so doing, amend or add to the petition. It is instructive to observe that the words used in paragraph 16 1A are, quote, new facts grounds or prayers tending to amend or add to the contents of the petition, unquote. The word new suggests something which is not there, while the word amend signifies modification. Add, on the other hand, means to increase. What the provision envisages, therefore, is that the reply of a petitioner must strictly be confined to the new facts raised in the respondent's reply and must not go over that to attempt to amend or add to the petition. See All Progressive Congress versus People's Democratic Party, Ngadi and Wamako, Adepoju versus Awoduyi Lemi, and Ikoro versus Izunaso, citations on the record. Indeed, in succinctly explaining the new issue which should attract the reply, the Supreme Court had held in Ejesimba versus Onuzuriki as follows, and I quote, a new issue to attract a reply must in law be really new in the sense of being brand and fresh. The issue must be really new, the statement of claim, in that it was not existing therein and was therefore brought into existence or introduced for the first time in the statement of defense by the defendant. The new issue, in both its content and materiality, must be further and additional to the statement of claim. Thus, the mere fact that a defendant states his own side of the case does not necessarily make it new, particularly when the plaintiff has told a contrary story in his statement of claim. In such a situation, the case stated by the defendant amounts to joining issues with the plaintiff, and that does not bear the name of a new issue in law. A new issue arises where the plaintiff did not avert to or touch the contents of the defendant's averments in anticipation. The defendant's averment was introduced pleadings for the first time and therefore unique and novel to his pleading, unquote. A careful examination of the petitioner's petition, the first, second, and third, and the fourth respondents' respective replies, and the replies which the petitioners filed in response thereof, reveals that apart from rehashing what they have already averred in their petition and denying what the respondents have stated in their respective replies, petitioners also introduced new facts in their replies, the respondents' replies, which were not contained in their petition. This is in clear contravention of paragraph 16 sub 1A, the first schedule to the Electoral Act 20. Paragraph 16, 1 to the law as encapsulated in paragraph 16(1)(a) of the first schedule to the Electoral Act quoted above forbids new additions or amendments by a petitioner which are not contained in their petition, because such new additions or amendments will prejudice the respondents and breach the respondents' fundamental right to fair hearing, guaranteed by Section 36(5) of the Constitution of the Federal Republic of Nigeria, 1999. Since the respondents will have no opportunity to respond to those new issues, additions, or amendments. See PDP and another versus INEC, others. Maku and another versus Al Makura and other citations. An examination of the paragraph 4, Roman 3, Roman 4, and Roman 5 of the first respondent's reply shows that the paragraphs has not raised any new issue contrary to the assertion of the petitioners. In paragraph 15 of their reply, the first respondent's reply to the petition. It's only a response to paragraph 7 and 8 of the petition. But the petitioner's argument in the same paragraph 15 that the first respondents officials at the polling units failed to give clear copies of the results of the election from EC8A to the petitioner's agents, as the pink copies given by the petitioner's agents were very faint and unreliable, is a new fact which tends to amend the petition. Paragraph 16, Roman 1, 7, 17, second part of 18, 22, 24 of the first respondent's reply are traverse of paragraphs 21 to 27 of the petition. Hence, paragraph 16 of the petitioner's reply, which purports to respond to new issues in paragraph 17, 18, 19, 20, 21, 22, and 24 of the first respondent's reply, actually contain new facts, which will amount to amendment of the petition. Also, paragraph 17, 18, 19, 24, 25, 27, 28, 29, 30, 31, 32, 34, 35, 36, and 37 of the petitioner's reply, the first respondent's reply are either a rehash of the facts already averred in the petition or contain new facts which will amount to amendment of the petition. In respect of the petitioner's reply to the second and third respondent's reply, the petition, the latter are seeking for an order striking out paragraphs 8 to 42 of the petitioner's reply. However, A careful examination of those paragraphs shows that only paragraph 21 of that reply has raised a new allegation against the first respondent of attempts to manipulate the data uploaded on the back-end server of the AWS. The said paragraph 21 of the petitioner's reply to the second and third respondent's reply is hereby struck. Similarly, petitioners have introduced new facts in paragraphs 16, 17, 18, 20, 22, 23, 24, 25, and 27 of their reply, some of which contain serious allegations of the fourth respondent, which the fourth respondent has no opportunity. In contravention of paragraph 16 sub 1 of the first schedule to the Electoral Act, those paragraphs are also hereby struck. And that indeed is the rulings on the respondents' objections, various objections.
Well, as I was trying to explain earlier before we went for the break, we'll take all the judgments. After that, my learned brothers will now their own order to save time. Because the petitions are consolidated. So now we'll go to the main petition in petition number 3. In bringing this petition, the petitioners who were contestants in the presidential elections held on 25th February 2023 have challenged the declaration return of second respondent as the winner of the election and sought for the declaration and consequential reliefs, which I have reproduced in the beginning of this judgment. The petitioners have predicated their petition on the 3 statutory grounds earlier stated. Although in the ruling of this court on the objections of the respondents, some paragraphs of petition replies have been struck out for stated reasons, this court will take into consideration the entire affirmance in the petition and determine the merit otherwise of the petition in interest of justice. At trial, the petitioners opened their case with tendering from the bar several certified true copies of electoral and other documents which were objected to by all the respondents, who reserved the reasons for their objections to the stage of final address. Said objections were therefore admitted, the said documents were therefore admitted and marked as exhibits without prejudice to the objections of the respondents. The court ordered the respondents file separate addresses on their objections along with their final addresses. Proof of their petition, the petitioners called 13 witnesses who gave evidence as PW1 to PW13. Of those witnesses, only 3 had their witness statements on oath filed along with the petition, while the other 10 were subpoenaed witnesses whose statements were filed separately after hearing in the petition had commenced. The respondents objected to the competence of the subpoenaed witnesses, give evidence and adopt their addresses, witness statements on oath, and reserve the rulings for their objection to the stage of final address. That prejudice to the objection, said witnesses adopted their respective witnesses' statement on oath, after which they were duly cross-examined by all the senior counsel for the respondents. Upon closure of the petitioner's case, the first respondent, as well as the second and third respondents, called one witness each in their defense. Both respondents did not call any witness, but opted to rely on the evidence already adduced by the other respondents and that elicited under cross-examination on behalf of the fourth respondent. At the close of evidence, parties filed and extend their respective final addresses, including separate addresses, support of their various objections which they raised during trial. So we shall now consider the respondents' objections to the competence of some of the petitioner's witnesses and to the documents tendered by them during trial. To save time, we skip the addresses of counsel, go to the resolution of those issues. So the resolution of the respondent's objections to witnesses and documents contained in page 84 of the judgment. On the first segment of the respondent's objection, all the respondents challenge the competence of PW3, PW4, PW5, PW6, 7, 8, 9, 10, 11, and 13. And the respondent's essential contention is that the witness statements on oath, whose witnesses, on oath of those witnesses of the petitioners were not loaded along with the petition, but were only filed during trial, contrary to paragraph 4 of 5D of the pay schedule to the Electoral Act 2020. Section 285 of the 1999 Constitution as amended, which limits the time for presidential election petition, provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the elections. In the same vein, Section 132, sub 7 of the Electoral Act 2022 provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the elections. Paragraph 4 of the first schedule to the Electoral Act 2022 stipulates the contents of an election petition which shall be filed. In particular, paragraph 4.5 of the state schedule mandates as follows. The election petition shall be accompanied by a list of the witnesses that the petitioner intends to call in proof of the petition, b, written statements on oath of the witnesses, and c, copies or lists of every document to be relied on at the hearing of the petition. Paragraph 6 of that paragraph, a petition which fails to comply with the above requirements shall not be accepted for filing by the Secretary. Paragraph 14, sub 2 of the same first schedule, the Electoral Act, then provides as follows. After the expiration of the time limited by A, Section 132, sub 7 of this Act for presentation of the election petition, no amendment shall be made. 1. Introducing any of the requirements of paragraph 44.1 contained in the original election petition file, or 2. Effecting substantial alteration of the ground for or the prayer in the election petition, or 3. Except anything which may be done under subparagraph 2A, Roman 2, affecting a substantial alteration of or addition to statements of facts relied on to support the ground for or sustain the prayer election petition. And sub B, paragraph 12, for filing the reply, no amendment shall be made. 1. Alleging that the claim of the seat or office by the petitioner is correct or false. 2. Except anything which may be done under the provisions of paragraph 2A, Roman 2, affecting any substantial alteration to, in or addition to the admissions or the denials contained in the original reply file or to the facts set out in the reply. The above quoted provisions of the Constitution, Electoral Act 2022, and the first schedule thereto have been thoroughly considered by the Supreme Court in several cases, including Okian, another versus Mimiko and others, Ugumbi JC, Oba and Vincent Rarume and others, Anik, Okuru, Ogi and others, PDP and Okuru and several others listed here. In Oke and Mimiko, the apex court, Ugumbi JC, held as follows on the court. Paragraph 4, 1 and 5 of the first schedule to the Electoral Act, the composite analysis of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive, mandatory, conclusive. In other words, the provisions do not allow for additions, and hence, the procedure adopted by the appellants in seeking for an extension of time is nothing other than surreptitious attempt to amend the This is obvious from the nature and substance of the application, especially where one of the grounds seeks to put in facts which are allegedly not available which were not allegedly not available at the time of filing the petition, but only came into their possession after the statutory time limit allowed for the presidential election petition. Expressly, there is no provision in the legislation which provides for extension of time. What is more, in paragraph 14.2 of the first schedule to the Electoral Act, the appellants by section 134 sub 1 of the Electoral Act had been totally foreclosed from any amendment, which was in fact the hidden agenda promoting the application. The saying is true that even the devil does not know a man's intention. It can only be inferred from the act exhibiting that which is conceived in the heart, mind. The use of the word shall in paragraph 14 sub 2a of the first schedule to the Electoral Act mandatory and places a complete bar to any form of amendment to a petition file, does not allow for an exercise of petition whatsoever. Further still, on a critical perusal of the application, relief 2.6 court seek to all additional witness to which with AEO. It is pertinent to state that at the close of pleadings, parties have submitted the list of witnesses who were to testify together with their depositions. The idea, purpose, and intention of the application is suggestive of nothing more but a clear confirmation seeking for an order of an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions section 285.5 of the Constitution, section 134 of the Electoral Act, close of court. In his concurring judgment in the same case, Nguta, JSC, specifically stated follows, I quote, the additional or further witness depositions sought to be allowed for a just and fair determination of the petition are fresh facts as found by the tribunal, and which finding was endorsed by the lower court. This court will not interfere with a concurrent finding of fact of the two lower courts when the appellants have failed to show a special circumstance for this court to do so. Election petitions are time-bound, and the court will not allow the party to resort to any sort of subterfuge or frustrate the intention of the Electoral Act that petitions be disposed of judiciously. The petitioners in this case have relied on the earlier decisions of this court in Omidiran versus Ete, Lasun versus Awoyemi, Supra, to argue that the supreme witnesses whose witness statements on oath were filed outside the time limited for the presentation of the petition are competent to testify because they are supreme witnesses who do not work for the petitioner. However, it is pertinent to observe that unlike in the present case, the subpoena issued at the instance of petitioner in the case of Omidiran and Ete and Lasun versus Awoyemi were decided under the Electoral Act of 2006, which did not have provisions similar to paragraph 4 sub 5 of the first schedule to the External Electoral Act 2022. Secondly, the subpoenas in the above two cases were issued and served on adversaries, namely the resident electoral commissioners. Again, those two cases were decided before the introduction of section 285 subsection 6 of the 19th Constitution of the Federal Republic of Nigeria 1999, which mandates that an election petition shall be decided within 180 days from the date of filing the petition. Thus, whilst this court in Omidiran and Ete and Lasun versus Awoyemi appeared to have adopted a flexible approach, the Apex Court had taken a strict approach in its latter decision in OK and Mimiko. Indeed, in subsequent following the Apex Court's decision in OK and Mimiko, this court, per Agim JCA, as he then was, now JSC, highlighted this strict position of the law in Ogba versus Vincent at paragraph 46, 48, paragraph 8 to B, wherein he held as follows, I quote, I think that this court in Omidiran and Ete and the Supreme Court in OK and Mimiko adopted different approaches in addressing the issue of whether a tribunal or court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election petition proceeding. Omidiran's case did not strictly enforce the time limits described in section 141 of the Electoral Act 2006. The provision in the first schedule thereto and prohibiting the introduction of additional facts in the proceedings after the period allowed for filing a petition and closure of pleadings in paragraph 1 of the Election Tribunal and Court Practice Directions of 2006 on the content and form of the petition, held that the purpose of the practice direction is to guide and regulate compliance with and observance of the provisions of the first schedule to the Act and the Federal High Court rule where applicable. This elastic application of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the Electoral Tribunal and Court Practice Directions as overriding the rules of court in election court cases. In Mimico, the Supreme Court approached the issue in keeping with the current judicial trend of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The Supreme Court has consistently, in a long line of cases, insisted on this strict and inelastic approach, opposing the electoral laws. The law has laid out systematic juries in Oke and Mimico is that a witness position that is not filed along with the petition within the 21 days allowed for filing the petition cannot be filed in the proceedings. It held thus, if there was an evidence which was fundamental to the determination of the petition, that evidence ought to have been placed willy-nilly before the tribunal within the time limit specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition. Even if it has been withheld by any person, there are several ways to go about placing same before the tribunal. The Evidence Act is very clear on this. The petitioners ought to have restored that procedure, laws of court. The firm position of the Supreme Court, as stated in Okia Mimico and followed by this court in Oba and Vincent Supra, is that by the combined provisions of Section 285.5 of the 1999 Constitution, Section 137, Subsection 7 of the Electoral Act 2022, and paragraph 4, 5, and 6 and 14.2 of the first schedule to the Act, every written statement on oath of the witness which a party intends to call must be filed along with the petition within the time limited by Section 285.5 of the Constitution of the Federal Republic of Nigeria as amended, and Section 132, Subsection 7 of the Electoral Act 2022. Once the time limited for filing of a petition has elapsed, the contents of the petition cannot be added to or amended in any manner or under any guise. Any written statement on oath of a witness filed outside that 21 days limitation will amount to a surreptitious amendment of the petition and a breach of paragraph 14 of the first schedule to the Electoral Act 2022. This is irrespective of whether the witnesses to be called are ordinary or expert witnesses and whether they are willing or subpoena witnesses. Since then, this has been the consistent position of the law followed by this court. Indeed, in Okuru versus Obe, this court says this position, our learned brother Bolaji Yusuf stated that court. From the records, PW3 and PW4 was summoned by subpoena issued by the tribunal and presented as expert witnesses. The question is whether this without more entitled the appellant to file their statements on oath outside the time set for filing the petition. Or a reply to the respondent's reply in answer to the petition. I am of the humble view that whether an expert witness or not, a witness remains a witness. So the proviso to Order 3, Rule 3, Sub 1 of the Federal High Court, Civil Procedure Rules 2009, made applicable to an election petition by paragraph 54 of the first schedule to the Electoral Act, provides that the statements on oath of witnesses requiring subpoena from the court need not be filed at the commencement of the suit. 2. The witnesses who require subpoena or summons shall, at the instance of the party calling them, be served with civil form 1A before the filing of the statements that witness. The application of that rule is with regard to and or subject to the provisions of the Electoral Act, not independent of the Act. Paragraph 54 reads, Subject to the express provisions of this Act, the practice and procedure of the tribunal or the court in relation to an election petition shall be as nearly as possible similar to the practice and procedure of the Federal High Court in the exercise of its civil jurisdiction, and the civil procedure rules shall apply with such modifications as may be necessary to render them applicable having regard to the provisions of this Act, as if the petitioner and the respondent were respectively the plaintiff and the defendant in an ordinary civil action. The provisions of the Electoral Act being a substantive law shall override any rule of court which is contrary to provision. The subsidiary legislation must conform with the principal law, CNNPC and Afamfa Oil Limited. The proviso to Order 3, Rule 3.1 of the Federal High Court Rules 2009 cannot override or affect or whittle down the absolute and mandated provisions of Section 285 of 5 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, which stipulates that an election petition shall be filed within 21 days after the date of the declaration of the result of the elections, and paragraphs 4, sub 1, 5, and 14.1 and 2 of the first schedule to the Electoral Act, which stipulate the content of a petition. It is therefore clear that in law, the provisions of Order 3, Rule 3.1 of the Federal High Court Civil Procedure Rule 2009 cannot provide a platform for filing and using witness statements on oath not filed within the time limit set for presentation of petition, and which time cannot be extended for any reason under any guise. The focus of our decision in Ogba and Vincent Supra was the injustice in allowing a piece of evidence not covered by the pleadings to be presented to the court when the opposing party would have no opportunity to react to it. It is my humble view that the position of the law, as can be gleaned from the Section 2855 of the Constitution, paragraph 4, 14.2, and 16.1 of the First Schedule to the Electoral Act, is that a petitioner cannot be allowed to file and use documents or witness statements on oath filed outside the time set for filing petition, and to which the respondents would have no opportunity to react. To do so will amount to creating an avenue which a petitioner can use for exploit to overreach the respondents. That is the stand of the Supreme Court, Oke and Mimiko, number 1 Supra, followed by this court, Oba and Vincent Supra, those of court. Again, in Ararume and another, but and Anik and others, in which I wrote the lead judgment, they are stated as follows. The law, therefore, is that the deposition of a witness must accompany the petition at the time of filing the petition. In other words, the written statement on oath of an intended witness must be filed along with the petition. Thus, any written deposition of a witness not filed along with the petition will not be countenanced by the court or tribunal. Therefore, means that a written deposition filed by a witness not listed in the petition nor his deposition front-loaded cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. I think that is what the tribunal decided in this case, in line with the decision in Oba and Vincent. The combined effect of paragraph 4.5, Roman 1 and 2, 14.1 and 3 of the First Schedule to the Electoral Act is that no witness can testify in chief before a tribunal if he has not deposed a written statement on oath, which must necessarily have been filed along with the petition. Close of court. From the foregoing judicial decisions, it is clear that in election petition litigation, whether the witnesses which a party intends to call are ordinary or aspire witnesses, and whether they are willing or supine witnesses, their witness deposition must be filed along with petition before such witnesses will be competent to testify before the tribunal or court. It is instructive to observe that one of the leading senior counsel for the petitioners in this petition, Dr. Onyechi Ipiazu, SAN, was the lead counsel to the second respondent in Ararume and another versus Anik and others, wherein he successfully challenged the competence of a supine witness, Ama Ibom Agu, PW2, on the same ground that the witness statement on oath of the same witness was filed on 8/7/2019 long after the time limited for the filing of the petition. Therefore, the petitioners in this case were well aware of the settled legal position on subpoena witnesses in election petitions, favored by the Supreme Court and by this court. Yet they embarked on subpoenaing PW3, PW4, PW5, PW6, PW7, 8, 9, 10, 11, and 13. 10 out of their 13 witnesses, whose witness statements on oath were not front-loaded along with the petition. The petitioners have tried to argue that the said witnesses are witnesses of this court. With respect, this argument is misconceived because the subpoena in respect of those witnesses were issued upon the request of the petitioners. The applications for the issuance of the subpoenas were duly signed by filed at the registry of this court by the Petitioner Council, and the requisite fees paid, including filing fees and service fees as assessed, were duly paid by them before this court approved and issued the subpoenas. Therefore, those witnesses are the petitioner witnesses and not witnesses of this court. Indeed, the procedure for calling of witnesses by the court is by summons as stipulated in paragraph 42, sub 1 of the first schedule to the Electoral Act 2022. By the provisions of that paragraph, the tribunal or court may summon a witness as a witness who appears to the tribunal or court to have been concerned in the election. Clear from the provisions of that paragraph that is a person summoned by the court suo motu in exercise of its powers under paragraph 42(1) that is a witness of the court and not a person subpoenaed at the request of a party to the case. In the instant case, PW3, who was subpoenaed at the request of the petitioners, is a staff of Channels Television who tendered exhibits PBH3 and PBH4, 2 flash drives containing third annex consultative meeting with leaders of political parties held on 26 October 2022, an interview with Mr. Festus Okoye, National Annual Commissioner, held on 12 March 2023, respectively. PW4, a professor of mathematics who was engaged before the election by the petitioners and whom the petitioners presented as a subpoenaed expert witness, stated under cross-examination by the first respondent that he concluded his report on the 19th of March 2023 before the petition was filed. PW5 is the staff of Arise Television who also tendered exhibit PCG2, a flash drive showing the INEC chairman delivering an address at the Chatham House, London, UK, on the preparations for the 2023 elections in Nigeria. PW6 is a staff of African Independent Television, AIT, who tendered exhibit PCH1, a flash drive of the program Democracy Day, anchored on 22nd November 2022, wherein the INEC chairman was shown giving a brief on the preparations for the 2023 general elections. PW7, who claimed to be a cloud engineer and architect working with Amazon Web Services Incorporated, tendered exhibits PCJ3A to F, which are 6 reports of Amazon Web Services AWS health dashboard, which she said she downloaded from the Amazon website. Under cross-examination, however, she not only admitted that she is a member of the second petitioner. Please, let us be serious. This is a serious matter, it's not a laughing matter. She not only admitted that she is a member of the second petitioner, the Labour Party, but she had contested elections as a candidate for the second petitioner for House of Representatives elections, conducted along with the present elections on 25th February 2023. PW8, who claimed to be a cybersecurity expert engaged by the Labour Party on 10th March 2023, stated that he produced his preliminary report on 17th or 18th March 2023 before the petition was filed. He tendered exhibit PCK1, a metadata. PW9, a staff of Women and Child Rescue Initiative, a non-governmental organization, claimed to be an observer in the 25th February 2023 elections, but stated that the subpoena was addressed to him personally and served at his village address. PW10 claimed to be an annual ad hoc staff who acted as a supervisor. He stated under cross-examination that the subpoena was addressed to him personally and not through INEC. PW11, who is a staff in the Legal Services Department of National Information Technology Department Agency, NIDA, stated that the subpoena was addressed to him personally instead of his organization. As for PW13, who claimed to have acted as a presiding officer in the 25th February 2023 elections, he stated that he was on a subpoena. The subpoena, which was admitted as Exhibit PCR, was, however, addressed to him personally and not through INEC. It's pertinent to observe that the above 10 witnesses subpoenaed by the petitioners were all witnesses who were available to the petitioners at the time of filing the petition. They were neither subpoenaed as adversaries nor subpoenaed as official witnesses. It is therefore beyond controversy that the witness statements on oath of those witnesses filed after the time limited for presentation of the petition had lapsed are incompetent, and the same witnesses had no virus to testify in this petition. Their testimonies are embodied in their respective witness statements on oath. Being incompetent are accordingly struck out. With regard to the respondents' objections to the admissibility of documents tendered by the petitioners, the first objection raised by the respondents is to exhibits tendered through PW4, as to exhibits tendered through PW4, 5, 6, 7, 8, and 8. These are exhibits PCD1, PCD2, PCD3, PCE1, PCE2, PCE3, PCE4, and PF2, tendered through PW4. Exhibits PCG1 and PCG2, tendered through PW5. Exhibit PCH1, tendered through PW6. Exhibits PCJ1, PCJ2, PCJ3, A to F, and PCJ4, tendered through PW7, and exhibits PCK1 and PCK2, tendered through PW8. The said exhibits are, I have estimated them in the judgment. The respondents' essential arguments is that since the subpoenaed witnesses and their witness statements on oath are incompetent, the documents tendered through those witnesses cannot be countenanced by the court. By paragraph 41(3) of the first schedule to the Electoral Act 2022, oral examination of witnesses is not allowed. Witnesses are only to adopt their respective written depositions and tender in evidence all disputed documents or other exhibits referred to in their depositions. By paragraph 4(5)(b) of the schedule, such written depositions of the witnesses must be filed along with the petition. Since the above exhibits are documents, including expert reports, which were tendered through the subpoenaed witnesses, whom we have already declared incompetent because their witness statements on oath were filed in violation of the mandatory provisions of paragraph 4(5)(b) of the first schedule of the Electoral Act 2022, the documents admitted through them, which form part of their evidence, are inadmissible and liable to be expunged from the record. In the case of Buhari and INEC, the petitioners have also argued that since the parties have agreed during pre-hearing session that documents properly certified by INEC will not be objected to, and the said documents were tendered from bar pursuant to pre-hearing order of this court of 23rd May 2023, the parties are bound by the order of the court, since same has not been appealed against by the second and third respondents. However, this contention of the petitioners does not represent the position of the law. It is stated that a court is not permitted in any event to admit an act on it's stated that a court permitted to act in any event to admit an act on legally inadmissible evidence, even if such evidence had been admitted by agreement of the parties or under order of court in the course of hearing. Once such evidence is legally inadmissible, the court must reject it when giving its final judgment, even if that will amount to overruling itself by so doing. Ishanu and AfriBank are way for JSC. Indeed, even in the case of Sani and Akwe, relied upon by the petitioners, this court at paragraph 20, paragraph B2A, restated the position of the law that even when pieces of evidence had been improperly received in evidence, trial court as well as appellate court have the power to expunge it from the record and decide the case only on legally admissible evidence. On the objection of the respondents to the admissibility of the documents tendered as expert reports by the petitioners, which were admitted as exhibits PCD1, PCD3, PCE1 to PCE4, PCJ2, PCJ3A to F, and PCK1, the respondent's contention is that they are caught up by the provisions of Section 83 of Subsection 3 of the Evidence Act 2011, having been contrived for the purpose of this petition. It is settled law that, as provided in Section 83, subsection 3 of the Evidence Act 2011, and pronounced upon in several decisions of the appellate court, that a document which is made by a party interested in a pending or anticipated proceeding involving a dispute as to any fact which the document tends to establish is inadmissible in evidence. Thus, in Ladwaja and Ajimobi, where the Supreme Court, Peter Odili, JSC held as follows: our court. In respect of what is referred to as a person interested, I shall refer to the cases of Nigeria Social Insurance Trust versus Cliffco, Nigeria Limited. As regards the phrase, a person interested, I agree with the respondent that the phrase has been examined in the case of Ivan versus Noble, where a person not interested in the outcome of an action has been described as a person who has no temptation to depart from the truth, one side or the other. A person not swayed by personal interest, but completely detached, judicial, impartial, independent. In other words, it contemplates that the person must be detached, independent, and non-participant, and really not interested which way in the context the case goes. Normally, a person who is performing an act in official capacity cannot be a person interested under Section 91 of Section 3, which is now the Section 83. I think the phrase, a person interested, ever more so, has been quite definitely put in the case of Halton and Halton, to mean a person who has pecuniary or other material interest in the result of the proceeding, a person whose interest is affected by the result of the proceedings, and therefore would have no temptation to pervert the truth to serve his personal, private ends. It does not mean an interest in the sense of intellectual observation or an interest purely due to sympathy. It means an interest in the legal sense, which imposes something to be gained or lost. CPC and Ombugadu, when considering and determine who is a person interested under Section 91.3 of the Evidence Act 2011 held thus. By the provision of Section 91.3 Evidence Act, a person interested is a person who has a pecuniary or other material interest and is affected by the result of the proceeding, and therefore will have no have temptation to pervert the truth, serve his personal, private ends. In fact, it is in its most recent decision in Oyetola and Another versus Annex, the Supreme Court, Agim JSC, restated this position. The following words: the other evidence adduced by the appellant to prove their case is the expert analysis report prepared by PW1, who by his own admission is a member of the second appellant and had been a special assistant to the first appellant and was engaged by the appellants to establish the invalidity of the disputed results in Form EC8A for the 744 polling units. It testified further that I made the report as directed by the petitioners and that I am part of those who wrote the petition. By his own testimony, he established that he was not an independent expert, as he had an interest in the subject of his analysis, carried out the analysis from the conclusion that the results were invalid, justified to support the contemplated election petition. It was an analysis from an answer and not from a question. Such a report is not the product of an independent, impartial, detached, and professional analysis. He is clearly a person with the disposition or temptation to depart from the truth. The listing of the expert analysis report in the petition among the documents to be relied on to prove the petition it was made in anticipation of contemplation to be filed. The report having been made by PW1 as a person interested in the subject matter of the petition when the petition was anticipated to establish that the election result was invalid is not admissible evidence by virtue of Section 83(3) of the Evidence Act 2011 as amended. Close of court. In the instant case, EW4, who claimed to be an expert, was contracted by the petitioners before the election to carry out data analysis on the results of the presidential elections held on 25th February 2023. He even tendered his letter of engagement by a second petitioner dated 20th February 2023, which was admitted as Exhibit PCF2. According to him, he produced his initial report on 19th March 2023. His report was made a day before this petition was filed on 20th March 2023. Obviously, the report Exhibit PCD1, PCD3 was prepared in anticipation of this petition. As for PW7, who also claimed to be an expert witness, he admitted that she was not only a member of the second petitioner, but had contested the House of Representatives election under the platform of the second petitioner, which election was conducted the same day with the presidential election on the 25th of February 2023. He also admitted that the report she presented in Exhibits PCJ A to F are public information hosted by Amazon, which she downloaded from the Amazon website, and that the open access information she downloaded in her report cannot be amended by her. This shows that PW7 was clearly not the maker of the said documents. As for PW8, who claimed to be a cybersecurity expert, he stated under cross-examination by the first respondent that he was engaged by the second petitioner as an expert on 10th March 2023, and that he produced a preliminary report on 17th and 18th of March 2023, and final report, Exhibit PCK1, at the end of May 2023, while this proceeding was pending. It is therefore evident from the above that PW4, PW7, and PW8 are persons interested in the outcome of this proceedings. The reports produced by PW4 and PW8 qualify as statements made by persons interested in anticipation or during the pendency of this petition. As for PW7, she is admittedly an interested party, having been a member of and even contested election under the umbrella of the second petitioner. Her interest is further underscored by the fact that she admitted under cross-examination that she was attending court throughout the proceedings prior to her evidence. By virtue of Section 83, Sub 3 of the Evidence Act 2011, the reports tendered by those witnesses which form part of their evidence are inadmissible. In view of the foregoing, exhibits PCD1, PCD3, PCE1 to PCE4, PCF to PCG2, PCH1, PCJ1, PCJ2, PCJ3 A to F, PCJ4, PCK1, and PCK4 tendered through the incompetent PW4, 5, 6, 7, 8 are hereby extended from the record of this court. The second aspect of the respondent's objection is on the ground of improper certification or authentication. On the second respondent's objection to exhibit PBP1 to PBP21, the IRF report for Adamawa State on the ground that no certificate of authentication of those computer-generated documents was filed in compliance with Section 84 of the Evidence Act 2011. Exhibit PCB1 to PCB6 referred to by the petitioners in response to the objection are IRF certificates of compliance for Bayelsa, Benue, Ekiti, Niger, Ogun, and River States. Adamawa State is Admiral said is not included in those exhibits. Exhibit PCC1 to PCC28, which include Adama said are actually Beaver's reports and their certificates of compliance. That of Adama is PCC21. In short, no certificate of compliance was produced by the first respondent in respect of exhibit PBP1, PBP21. The blood IRF report exhibits PCA series in respect of Adama's state. However, since the documents were stated to have been downloaded from ANEX IRF portal and were certified by ANEX as true copies of what they have in their IRF portal, the documents qualify as public documents within the meaning of Section 102 of the Evidence Act 2011, and the certification by ANEX authenticates those documents. Therefore, the provision of Section 84 of the Evidence Act is not applicable in this case. This is the position of the law as espoused by the Supreme Court in the case of Kubo and Dixie, where the Apex Court held that the computers from internet-generated documents printed from the website of a public institution is a public document. Only a copy of such document which is duly certified in compliance with Section 104 of the Evidence Act 2011 admissible. That I've started the victim of Supreme Court by a case ASC court. Exhibits PBP1 to PBP21 having been downloaded from ANEX report and duly certified by ANEX are clearly admissible. As for the fourth respondent's objection to exhibit PCG2, the flash drive tendered by PW5, the staff of Arise TV, it is clear that the said witness had in paragraph 6 to 12 of his witness statement on oath not only stated that he participated in all stages of the recording, production, and packaging of the flash drive, but he had certified the process of his production as required by Section 84 of the Evidence Act. On the fourth respondent's objection to the admissibility of Exhibit X2, on the ground that the Exhibit X2 was obtained by the petitioners from the registrar of this court and not from the custodian of the original copy, we have examined Exhibit X2, which is the European Union Election Observation Mission Nigeria 2023 final report. As rightly observed by the fourth respondent, the photocopy of the document is certified by Secretary of the Presidential Election Petition Court and not any officer of the European Union Election Observation Mission, which is the custodian of the original copy of the document. By Section 104(1) of the Evidence Act 2011, secondary evidence of any public document is only admissible in evidence if it has been certified by a public officer having custody of the original copy of the document, who by that section may give a copy of them to any person who has a right to inspect, together with a certificate written at the foot of such copy that it is a true copy of such document or part of it as the case may be. Under subsection 2 of that section, the public officer is enjoined to certify same by subscribing his name, official title, and date, and where he is authorized to use a seal with his seal. Clearly, the registrar of this court, who is not the custodian of the original copy of Exhibit X2, cannot validly certify that document under Section 104(1) of the Evidence Act 2011. The Omiseri and Arebashola, Manuel vs. Umana, where Mwezi JSC stated that the whole essence of the court's insistence on the scrupulous adherence to the certification requirements of public documents is to vouchsafe their authenticity vis-a-vis the original copies. Since Exhibit X2 has not been validly certified, it is inadmissible in evidence. Accordingly, Exhibit X2 is expunged from the record. The third aspect of the petitioner's objection to the petitioner's document is on the ground that the petitioners failed to plead specific facts to cover the documents objected to. The said documents objected to by the respondents are exhibits. So many they have been listed in this judgment. Get the judgment, you will see them. I have carefully examined the petitioner's pleadings and the documents objected to by the respondents. The petitioners have specifically averred in paragraph 101 of the petition that they will be relying on all the first respondents' electoral and all other necessary documents used for the conduct of the presidential election, including the documents which they listed as items A to PCC, that paragraph. However, election petitions are sui generis, and it is settled that for an averment in an election petition to be competent, material facts relating to complaints made therein must be pleaded. Belgore, Ahmed, Yazu, and Oti. In the latter case of PDP and ANIC, the Supreme Court was categorical on this mandatory requirement of specificity in averments of election petitions when the court held as follows. On whether the affected paragraphs were rightly struck out, I have read the affected paragraphs and found that they relate to allegations of non-voting, several polling points, disruption of election, non-conclusion of election, some printing of ballot papers, falsification of election results, widespread disruption, irregularities and malpractice without providing particulars, or the polling units where the alleged malpractice took place. The lower court was therefore right when it held as follows. Paragraphs above, in my view, are too generic, vague, and lacking in any particulars, as they are not tied specifically to any particular polling unit or any particular number of people who were alleged to be tied. The fact that a party can file further particulars or deny in a reply the averment in the pleading must not be general, it must be specific as to facts. The settled law that a petitioner's obligation to plead particulars of fraud or falsification without which the allegation is a non-starter. I have nothing to add to this statement of law as advanced above. I adopt it as mine. Close of court. That's why allegations of non-compliance and corrupt practices are made, such as in the instant petition. The polling units, wards, or other places where those irregularities and malpractices are alleged to have occurred must be specifically pleaded. The petitioners have argued that the issue of non-compliance by the first respondent to its laws, guidelines, and relevant statutes is a universal complaint because it is an infraction against the Nigerian people and the Nigerian state. However, this contention of the petitioners is not in consonance with the requirement of the law as espoused in Belgore and Ahmed, PDP and INEC. This is more so as the petitioner's allegations of non-compliance is interwoven with allegations of corrupt practice in the same set of facts pleaded forth. In the instant case, the petitioner tendered the following documents, which have been listed in this judgment. However, a look at the entire petition shows that no single complaint was made by the petitioners in respect of any of those states as to make those exhibits relevant to the petitioner's case. For instance, in paragraph 72, which the petitioners referred in response to the objection, the petitioners have alleged that there was overvoting in the states of Oyo, Ondo, Taraba, Oshun, Kano, Rivers, Borno, Katsina, Kwara, Gombe, Yobe, and Niger states. However, the petitioner failed to specify the polling units where the overvoting took place, the total number of accredited voters, the total number of votes cast, and the number of votes to be deducted from the scores of the parties. Similarly, in paragraph 73, which was also referred to by the petitioners in their response to the objection, the petitioners have averred that based on the uploaded results, the votes recorded for the second respondent did not comply with the legitimate process for computation of the result and disfavored the petitioners, and listed the states of Rivers, Lagos, Taraba, Benue, Adama, Imo, Bauchi, Borno, Kaduna, Plateau, and other states of federation. But the petitioner failed to state the scores improperly computed and how they were disfavored. As regards the objection to exhibits PCE1 to PCE4, said to be 18,084 and 88 blurred results downloaded from IREF and contained in 4 boxes, the petitioners have contended that the petitioners' request for the petitioners to specify the 18,088 polling units, which those blood reports relate, is an impossibility because the results are unreadable. The details of most of the polling units are stated in PCD 1 to PCD 3, the expert report tendered by PW4. This contention of the petitioners is, however, misconceived. This is because the petitioners who claim that they could not specify the polling units in the 18,088 blood results because those results are unreadable are the same persons who have stated that the said polling units have been specified in the expert report of PW4, through whom the blood results were tendered. However, PW4 stated under cross-examination that the primary source of the data he used in producing his report was the IRF portal. He did not state how he was able to determine the particular polling units and the impacted votes, accredited voters, and the number of PVCs collected. As I earlier stated, as I earlier noted, PW4's report was concluded on 19th March 2023 before the petitioners filed this petition on 20th March 2023, which means the petitioners were aware of the polling units to which their complaints relate even before they filed the petition. So their theory of impossibility, which they invented around the 18,088 blood results, is misconceived and an obvious misadventure. Again, in paragraphs 7 and 8 of the petition, the petitioners admitted that they have agents in the polling units, and those agents signed and collected duplicate copies of the result sheets. Those paragraphs read as follows. Paragraph 7, the petitioner is a body corporate with perpetual succession and in sponsorship of the first petitioner, and the conduct of the election thereof, acted through its members duly appointed as agents at all stages of the election, namely at the polling units, the ward collation centers, the local government collation centers, the state collation centers, and the ultimate collation center at the federal level in Abuja. Paragraph 8. In the conduct of the election, the agents duly appointed by the petitioners performed their assigned and statutorily designated roles at the election. These roles included observing and monitoring the process of arrival of election materials where they were supplied by the first respondent, and leading to and including the process of accreditation, voting, counting of votes, and announcement of the results of the election. These agents were the election proceeded in due form upon the first respondent agents duly entering the results in the result sheets at the polling units, signed and collected duplicate copies of the result sheets. Having clearly admitted that their agents signed and collected duplicate copies of the result sheets, their contention that they are unable to determine the polling units from which the blood results emanated is untrue. In fact, this admission reinforces the need for the petitioners to specify all the polling units in respect of which they made complaints, since their agents were availed with copies of the results of the polling units. As regards the petitioner's contention that they have complied with paragraphs 4, 5C, and 41.8 of the first schedule to the Electoral Act 2022, I had earlier considered this argument of the petitioner while resolving the respondent objection to petitioner's pleadings, wherein we held that the provision of paragraph 4, 5C of the first schedule to the Electoral Act 2022 only relates to the front-loading of documents to be relied upon by the petitioners as their evidence during trial. It does not obviate the mandatory requirement for pleading materials as stated in paragraph 41.1d and 2 and 41.8 of the same schedule, so as to enable the adverse party to know the exact case he is to meet and to respond to them accordingly. As stated in our my earlier ruling, the reports which the petitioner stated they had detailed the polling units was not filed along with the petition, so as to afford the respondent the opportunity to respond to same, but was merely tendered at trial by which time the respondents had no opportunity to respond. Since the petitioners have failed to specify in the petition the polling units to which exhibits PCA1 to PCA4, the 18,088 ballot results relate, the said documents are clearly inadmissible. Said exhibits hereby discountenance and expunged from the record. We now go to petition objections to the respondents' documents. In the course of trial, the petitioner also objected to the documents tendered by the first and second and third respondents at the hearing of the 4th of July 2023. The first respondent had tendered exhibits RA1, RA2, RA3, RA4, F5, 6, and 7 through his sole witness, Dr. Lawrence Bayode, a deputy director in the ICT department of the first respondent, who gave evidence as RW1. Of those documents, the petitioners had objected to the admissibility of exhibits RA1, RA2, RA6, and RA7. Similarly, at the hearing of the 5th of July 2023, the petitioners had objected to all the documents tendered by the second and third respondents from the bar and through their sole witness, Senator Michael Opeyemi Bamidele, who testified as RW2. The petitioners had reserved their reasons for the objections to be adduced at the stage of final address. Pursuant to the order of this court, that parties should file separate addresses on their objections. The petitioners have filed separate addresses in support of their objections to the documents of the first respondent and those of the second and third respondents. A written address in support of the objection of the first respondent's documents was filed on 23rd July 2023, while that in support of the objection to the second and third respondent documents was filed on 20th July 2023. In the written address in support of the petitioner's objection to the first respondent document, Dr. Livy Uzoku, learned senior counsel for the petitioners, essentially raised the sole issue of whether, having regard to the pre-hearing report of 23rd May 2023, paragraph 41, sub 3 of the first schedule to Electoral Act 2022 and other relevant provisions of the Act and decided cases, exhibits R8, 1, 2, 6, and 7 are inadmissible and liable to be exchanged from the evidence. Similarly, in the address in support of the objection to the second and third respondent documents, the petitioners raised the sole issue of whether, having regards to the said pre-hearing session report and paragraph 41.3 of the first schedule and decided cases, the documents tendered by the second and third respondents are inadmissible and liable to be expunged from evidence. Planisel pointed out that Exhibit RA1 is a private document emanating from the third respondent and argued that in the absence of the narrow exceptions to the maker of the document, being the person to tender the document, the witness of the first respondent, thus RW1, cannot tender same in evidence. He relied on Main Street Bank Limited and General Steel Mills Others Limited. National Council also submitted that Exhibit RA2 is inadmissible because the first respondent cannot appropriate at the same time. Since Exhibit RA2, the first respondent is trying to deny another letter received by it from the fourth respondent on 15 July 2022, which he had also certified. So we just go direct to the resolutions. So by virtue of the provisions of Section 102B of the Evidence Act 2011, public documents include public records kept in Nigeria of private documents. In the case of Onwuzurike and Idoziem and others, where the Supreme Court, by Onogen JSC, held, as it then was, held that a private document sent to the police form part of the record and of the police, and is consequently a public document within the provision of Section 109 of the All Evidence Act, now Section 102 of the Extant Evidence Act 2011. It also tried that a public document duly so satisfied is admissible in evidence, notwithstanding that it is not tendered by the maker. Indeed, a certified true copy of a public document can be tendered by a person who is not a party to the case. See the case of Maranro Adebisi, Dagashan Bulama, Mustafa Ketima, and others versus Alhaji Bukar Customs. Exhibits RA1 and RA2, being in the public record of the first respondent, are public documents and are therefore admissible in evidence, having been certified by the first respondent under Section 104 of the Evidence Act 2011. On the petitioner objection to exhibits RA6 and RA7, the record of proceedings of this court of 4th July 2023 shows that contrary to the assertion of the petitioners, the said exhibits RA6 and RA7, which are the cloud trail log and certificate of compliance to Section 84 of the Evidence Act, respectively, were not tendered from the bar, but through RW1. Indeed, the record shows that the petitioners consented to the said documents being taken as read and demonstrated, so therefore have no hesitation in discountenancing the petitioner's objection to those documents. On the whole, the petitioner's objection to exhibits RA1, RA2, RA6, and RA7 tendered first respondents unmeritorious, it is hereby overruled. Now go to objection to the petition objection to the second and third respondents' documents. We consider the the resolution of that objection. On the petition objection to exhibits RA8 and RA9, an examination of the petition shows that in paragraph 28, they have challenged the second respondent qualification to contest the election on the ground that he was fined a sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division. As rightly submitted by the second and third respondents, they have countered this allegation of the petitioners in paragraph 46 to 53, and particularly pleaded in paragraph 50 that the United States of America, through its embassy in Nigeria, had by a letter dated February 4, 2003, addressed to the then Inspector General of Police, and confirmed that upon their record checks of the Federal Bureau of Investigation, National Crime Investigation Center, NCIC, the centralized information center that maintains records of every criminal arrest and conviction within the United States of America. There were no record of any form of criminal arrest, warrants against the second respondent. The respondents shall found and rely upon a copy of the said letter of February 4, 2023, signed by Michael M. Bonner. Yes, the date is wrongly stated, corrected. From the foregoing, it is obvious that issues were joined by the parties on the indictment alleged by the petitioners, and exhibits RA8 and RA9 are clearly relevant. As for the argument of the petitioner over the custody of the documents, exhibit RA8 is a letter of inquiry written by the Inspector General of Police to the Consulate General of the United States Embassy in Nigeria, inquiring as to whether the second respondent had any criminal record in the United States of America, while exhibit RA9 is the reply to exhibit RA8 by the United States Embassy in Nigeria. Both letters form part of the record of the Nigerian police and are therefore public documents under Section 102E of the Evidence Act. Certification by the Nigerian Police Force is a confirmation that exhibits RA8 and RA9 are true copies of those documents which are in their custody. Onwuzurike and Idoziem, Abaje and Koka With regard to the petition objection to the relevance of Exhibit R10, the record shows that the petitioner's challenge to the qualification of the second respondent was confined to allegations of double nomination of his running mate, third respondent, and the alleged fine of the second respondent of the sum of $460,000 by a United States court. The educational qualifications of the second respondent were never challenged by the petitioners in this petition. It was the second and third respondents who introduced the educational qualifications of the second respondent in their reply, and the petitioner have not joined issues with the second and third respondents in their reply to the second and third respondent reply. That the court of law adjudicates only on matters over which parties are in dispute. The Adedeji and Olosho and another Trade Bank PLC versus Benelux Nigeria Limited. Since there is no controversy or dispute between the parties as it relates to the second respondent educational qualifications, Exhibit RA10 is not relevant to determination of this petition, hereby discountenance. Our examination of Exhibits RA11 to RA16, which are data pages and visa pages in the second respondent Nigerian passport, show that contrary to the assertion of the petitioners that the documents are not relevant, the petitioners have alleged in paragraph 28 to 32 of the petition that the second respondent was fined $460,000 for an offense involving dishonesty, namely narcotics trafficking. And in response to this allegation, the second and third respondents have denied same in paragraph 46 to 53 of their reply, and specifically pleaded those documents in paragraph 52 of their reply to the petition to show that the second respondent enjoyed an unrestricted right of ingress and egress to the United States of America, and up till now, he still enjoys an unimpeded right of access to the United States of America. It is therefore a considered view that Exhibit RA11 and RA16 are relevant to these proceedings. It is no objection to them, hereby discountenance. As for Exhibits RA17 and RA18, the petitioner's reason for objecting to them has nothing to do with the admissibility of the documents. The second and third respondents, having raised objection to the first petition's locus standi to present the petition in paragraphs 1A to M of their reply to the petition. However, we have already considered and determined the issue of the petitioner's locus standi whilst resolving the respondents' preliminary objections. We have already resolved them in favor of the petitioners. Therefore, this objection has been overtaken by our ruling preliminary objection. On the petitioner contention that Exhibit RA19, the report of the committee on the location of the federal capital Nigeria, is not relevant, we have examined the pleadings and the said exhibit. It is apparent to us that while the petitioners have averred in paragraph 81 of the petition that a presidential candidate must score 25% of the votes in FCT before he can be declared and return elected, the second and third respondents have averred in paragraph 86 of their reply that the FCT does not enjoy a special status over the other states of the Federation, and that Abuja is still inhabited by Nigerians who are deemed equal to Nigerians in any other part of Nigeria, and residents of Abuja are not conferred with any privilege and advantage that is not accorded to citizens of other communities or states in Nigeria. We are therefore of the view that facts have been pleaded which rendered Exhibit RA19 relevant and admissible. On the petitioner's objection to the admissibility of Exhibit RA22, we observe that the document is the same as Exhibit RA2, which we have already found to be admissible, having been certified by ANIC as a copy of document in their possession. Standard of Exhibit RA22, which is not even certified, is therefore a surplusage, thereby discountenance. With regard to the objection to admissibility of Exhibits RA24 and RA25, which are CTCs of pages 28 and 29 and 27 of Nigerian Tribunal newspapers, respectively. The reasons advanced for the objection of the petitioners are not legal grounds for challenging admissibility of a document. We have no hesitation in discounting the objection, contrary to the arguments of the second and third respondents' counsel that Exhibit RA27, the ECOWAS preliminary declaration, is a private document. said document forms part of the official record of the Economic Community of West African States, ECOWAS, an official body established under ECOWAS Treaty. An agreement made by member states of the ECOWAS community, and the treaty was signed by heads of states and government of the 16 member states. It's undoubtedly a public document within the meaning of Section 102 of the Evidence Act 2011. However, we observe that Exhibit RA27 is not certified as required by Section 104 of the Evidence Act to render same admissible. Not being so certified, Exhibit RA27 is hereby expunged from the record. As for the objection to Exhibit RA28 being the American Bar Association membership card of RW2, which was tendered by RW2 under cross-examination by the fourth respondent, it's clear to us that the document was neither pleaded nor listed or referred to in the statement of PW2. RW2, sorry. As rightly argued by the petitioners, Exhibit RA28 is inadmissible. Accordingly, it is hereby expunged record. Now we go to the merit of the petition. Having disposed of the various objections to witnesses and to some of the documents tendered in this petition, we now proceed to consider the merit of the petition. The parties filed, exchanged, and adopted their respective final written addresses starting with the respondents. The respective final addresses of the first, second, and third, and fourth respondent were filed on the 14th July 2023, respectively. On the 23rd of July 2023, 20th July 2023, and 23rd July 2023, the petitioners filed 3 separate final addresses in response to the final addresses of the first, second, and third, and fourth respondents, respectively. In reaction to the petitioners' final addresses, the first, second, and third and fourth respondents filed their reply addresses on 28th July 2023, 21st July 2023, and 28th July 2023, respectively. The first respondent and the second and third respondent also filed lists of additional authorities on the 28th and 31st of July 2023, respectively. On the 1st of August 2023, the parties adopted their respective final addresses. In his adopted final written address, Learned Senior Counsel for the first respondent, A.B. Mahmoud SN, distilled the following 5 issues for determination. A, whether having regard to the provision of Section 131 and 137 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the evidence before the court, the second and third respondents were qualified to contest the presidential election 25th February 2023. B, having regard to Section 47, subsection 2 and 3 of the Electoral Act 2022, paragraph 38 and 92 of the regulations and guidelines for the conduct of the election 2020, the inability of the first respondent to transfer or transmit the results of the presidential election to the IRF portal real time amounted to non-compliance to Electoral Act, whether such non-compliance substantially affected the outcome of the election. 3, whether by the totality of evidence adduced, the petitioners have proven that the election of the second respondent was invalid by reason of corrupt practices and non-compliance with the provisions of the Electoral Act 2022. D, whether in the absence of any proof of lawful and unlawful votes to be added to the scores of the petitioners and or unlawful votes to be deducted from the second respondent's scores at the election, the petitioners have proven that the second respondent was not elected by a majority of lawful votes cast. E, whether having regard to the declared results of the election and the provision of Section 134, subsection 2B of the Constitution of the Federal Republic of Nigeria 1999 as amended, the second respondent ought to have been returned as duly elected after having scored the highest number of votes cast with 25% of the votes cast in over 2/3 of the state's federation. The land senior advocate for the second and third respondents, Chief Wale Olanipekun, formulated the following 4 issues for determination. 1. Having regard to the relevant provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, salient provisions of the Electoral Act 2022, judgment of Federal High Court, and FACA BJCS 1454/2022, Labour Party and INEC delivered on 23rd January 2023, which is X1, as well as admissible evidence on record, whether the election of the second respondent into the office of President of the Federal Republic of Nigeria on 25th February 2023 was not in substantial compliance with the principles and the provisions of the Electoral Act 2022. 2. In view of the clear provisions of the Constitution of the Federal Republic of Nigeria 1999, the Electoral Act 2022, and plethora of judicial precedents on the criteria for qualification of candidates for election to the office of President, coupled with the unreported decision of the Supreme Court in SC/CV/501/2023, People's Democratic Party vs. Independent National Electoral Commission (INEC), delivered on 26 May 2023, Exhibit RA23, whether the second and third respondents were or are not eminently qualified to contest the presidential election of 25th February 2023. 3. Upon a combined reading of sections 134 and 299, as well as other relevant sections of the Constitution of the Federal Republic of Nigeria 1999 as amended, Section 66 of the Electoral Act 2022 and other relevant statutes, whether the second respondent has not satisfied the necessary constitutional and statutory requirements to be declared winner of the presidential election of 25th February 2023 and returned as President of the Federal Republic of Nigeria. 4. Considering the constitutional petition and the task evidence adduced, whether this honorable court can accede to the reliefs being claimed by the petitioners. Prince L.O. Fabemi SN, Senior Counsel for the fourth respondent, also nominated 4 issues for determination as follows. 1. Whether having regard to the issues joined and the evidence led on the nomination of the third respondent as vice presidential candidate of the second respondent and the annual civil forfeiture of the alleged civil forfeiture of the sum of $460,000 to the United States by order of the district court in case number 93C-4483. The petitioners have established that the second respondent was not qualified to contest the presidential election held on 25th February 2023 as provided for in the Constitution of the Federal Republic of Nigeria 1999 as altered. 2. Whether having regard to the relevant and admissible evidence led by the parties, the conduct of the presidential election held on 25th February 2023 election was vitiated by non-compliance that was substantial enough to have affected its outcome and justified nullification of the election as emphasized by the applicable provisions of the Electoral Act 2022. 3. Whether the burden of proving that first petitioner and not second petitioner scored majority of lawful votes cast in each of at least 2/3 of all states of the Federation and the Federal Capital Territory to be declared and returned as the winner of the presidential election held on 25th February 2023 has been discharged by the petitioners. 4. Whether having regard to the totality of the evidence led by the parties and the applicable law, the petitioners are entitled to succeed on any of the relief sought in the petition at all, or that the petition ought to be dismissed in favor of the respondent. On the part of the petitioners, their lead senior counsel, Dr. Livy Uzoku SN, still the following 3 issues in the petitioner's final address in response to the final address of the first and fourth respondents. 1. Whether the second and third respondents are qualified to contest the presidential election by reason of the unchallenged facts and circumstances arising under Section 137, Subsection 1D, 142, Subsection 1 and 2 of the 1999 Constitution, Section 35 of the Electoral Act 2022. 2. Whether from the documentary evidence before the Honorable Court read and examined together with the unchallenged expert and technical evidence of the petition witnesses, the petitioners proved that the non-compliance by the first respondent with the relevant provisions of the Act 2022 and the subsidiary legislation made thereunder substantially affected the outcome of the questioned presidential election held on 25th February 2023. In response to the second and third respondent final address, the petitioners adopted issues 1 to 3 of the issues for examination with the earlier filed on 18th May 2023 during the hearing session. These are: 1, whether the second respondent at the time of the presidential election held on 25th day of February 23 was not disqualified to contest the said election by virtue of the provision section 1371D of the Constitution of the Federal Republic of Nigeria amended. 2, whether the third respondent at the time of the presidential election held on 25th February 2023 was qualified to contest the said election as the vice president candidate to the second respondent. If answered in the negative, whether this did not invalidate the qualification of the second respondent to contest the said election. 3, whether the presidential election held on 25th February 2023, wherein the second respondent was declared and returned by the first respondent as the winner, was not invalid by reason of non-compliance with the provisions of the Electoral Act 2022 and any guidelines and regulations for the conduct of the election 2022 made pursuant to the Act. From the pleadings, the evidence adduced, and the submissions of counsel of the parties, it is a considered view that the following are the issues which will effectively determine this petition. 1, whether having regard to the provisions of Section 137 of the Constitution of the Federal Republic of Nigeria 99 as amended, Section 35 of the Electoral Act 2022, and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 25th February 2023. 2, whether having regard to the evidence adduced by the parties, the petitioners have established that there was substantial non-compliance with the provisions of the Electoral Act 2022 and that the non-compliance substantially affected the results of the election. 3, whether from the totality of the evidence adduced, the petitioners have proven that the presidential election held on 25th February 2023 was invalid by reason of corrupt practices. 4, whether from the evidence adduced by the petitioners have established that the second respondent was not duly elected by a majority of lawful votes cast at the election. Well, we stated earlier, we have summarized the submissions of counsel. We didn't want it of reading them out. The first issue is whether having regard to the provisions of Section 137 of the Constitution of the Federal Republic of Nigeria as amended, Section 35 of the Electoral Act, and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 26 February 2023. Well, I think issue of qualification on this issue has been resolved in petition number 4. It's the same issue that has been raised here. So we stand by our resolution, this issue. The only exception is the allegation on the issue of the second allegation made by the petitioners in ground one, which is contained in paragraphs 28 to 30 of the petition, is that the second respondent is disqualified from contesting the presidential election because is stated in paragraph 28 of the petition as follows. The petitioner further pleaded that the second respondent was also at the time of the election not qualified to contest for election to the office of president, as he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C4483 between United States of America plaintiff versus funds in account of 263226 held by First Heritage Bank in the name of Bola Tinubu. Funds in accounts 39483134, 39483396, 4650279566, held by Citibank NA in the name of Bola Tinubu or Compass Finance and Investment Company. Funds in accounts number that are held by Citibank International in the name of Bola Tinubu defendants. The petitioners have pleaded and relied on the order of the U.S. Court in Exhibit P5, which they tendered from the bar and which was subsequently identified by PW2 and PW12 in their evidence earlier summarized. The petitioners have centered their contention on the provisions of Section 137, subsection 1D of the 1999 Constitution, which reads as follows. A person shall not be qualified for election to the office of president if he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or sentence of imprisonment or fine for any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed by him by any court, tribunal, or substituted by a competent court, by competent authority, or any other sentence imposed on him by such court or tribunal. A careful examination of the above provision shows that the operative words of that paragraph of the section are sentence, imprisonment, or fine, and for any offense. Black's Law Dictionary 6th edition at page 1081 defines offense as, quote, a felony or a misdemeanor, a breach of the criminal laws, violation of law for which penalty is prescribed. The word offense, while sometimes used in various senses, generally implies a felony or a misdemeanor, infringing public as distinguished from mere private rights, as unpunishable under the criminal laws, though it may also include the violation of a criminal statute, which the remedy is merely a civil suit to recover the penalty, an act clearly prohibited by the lawful authority of the state, providing notice through public laws, close of court. Also, the Supreme Court, in the case of Abdullahi Umar and the state, held that an offense is an act which is clearly prohibited by law and which may be a crime or a civil offense. Sentence, on the other hand, has been defined by the same Black's Law Dictionary at page 1362 as follows. The judgment formally pronounced by the court or judge upon the defendant after his conviction in a criminal prosecution, imposing the punishment to be inflicted, usually in the form of a fine, incarceration, or probation. Again, this court also defined sentencing in Yakubu and the state as follows. A judicial determination of a legal sanction to be imposed on a person found guilty of an offense. It means the prescription of a particular punishment by a court to someone convicted of a crime. It is discernible from the above that the fine referred to in paragraph E of section 137(1) quoted above is one which emanates from a sentence for a criminal offense involving dishonesty or fraud. The words for imprisonment or fine also presupposes The defined envisaged under the section is one which is imposed as an alternative to the imprisonment. In other words, Section 137, subsection 1D relates to sentence of death or sentence of imprisonment or fine imposed as a result of a criminal trial conviction. Indeed, in considering the offense that can amount to disqualification under Section 1371 of the Constitution, the Supreme Court held in Action Congress versus ANIC as follows. The disqualification in Section 137, subsection 1 clearly involves a deprivation of right and a presumption of guilt or embezzlement or fraud in derogation of the safeguards in Section 36, subsection 1 and 5 of the Constitution. The trial and conviction by a court is the only constitutionally permitted way to prove guilt, and therefore the only ground for the imposition of criminal punishment or penalty for the criminal offenses of embezzlement or fraud. Clearly, imposition of the penalty of disqualification for embezzlement or fraud solely on the basis of an indictment for those offenses by an administrative panel of inquiry implies a presumption of guilt, contrary to Section 36 of Section 5 of the Constitution of the Federal Republic of Nigeria 1999, whereas conviction for offenses and imposition of penalties and punishment are matters appertaining exclusively to judicial power. See also the cases of Amici and Anis Omuwaye versus Attorney General of a state, Karim and others versus Shinkafi. A careful perusal of P5 relied upon by the petitioners show that the case number 193 CV04483 was in the civil docket of the U.S. District Court, Northern District of Illinois, and it was a civil forfeiture proceeding against funds in specified accounts with First Heritage Bank and Citibank NA. Exhibit N5 is actually an action in rem against the funds with First Heritage Bank and Citibank. It is not an action in personam against the second respondent. In Jonathan versus Federal Republic of Nigeria, citation supplied, the Supreme Court held inter alia that Section 17 of the Advanced Fee Fraud and Other Related Offences Act 2006 provides for the power to make an order of forfeiture without conviction or for an offense, and that an order of forfeiture under the section shall not be based on conviction for an offense under the Act or any other law. The Apex Court further held that there was no need to prove any crime in forfeiture of property under Section 17 of the Advanced Fee and Other Related Offences Act. A civil forfeiture is a unique remedy which rests on the legal fiction that the property, not the owner, is the target. Therefore, it does not require conviction or even a criminal charge against the owner, as it is not a punishment, nor is it for criminal purposes. See also the cases of Lawari Furnitures and Baths Limited versus Federal Republic of Nigeria, Alison Madueke versus ESCC. From the legal definitions and judicial authorities cited above, it is clear that the sentence of imprisonment or fine for any offense involving dishonesty or fraud envisaged in Section 137, subsection 1D of the Constitution is one imposed upon a criminal trial and conviction. In the instant case, the petitioners have failed to show evidence that the second respondent was indicted or charged or arraigned, tried and convicted, and was sentenced to any term of imprisonment or fine for any particular offense. On the part of the second and third respondents, they have contended that the second respondent was never fined for any offense and has no criminal record in the United States. In proof of their assertion, they have tendered exhibits RA8 and RA9 from the bar and called RW2 to give evidence and identify the said exhibits as documents he referred to in his adopted statement of oath of 12 April 2023. In paragraph 45 to 52 of his statement on oath, RW2 has stated that the second respondent was never convicted or fined for any criminal offense in the United States as alleged by the petitioner. In particular, RW2 stated as follows in paragraph 46, 47, and 49. 46 say in case number 93C4483 at the United States District Court, Northern State District of Illinois, Eastern Division, which was pleaded by the petitioners. 1, no criminal charge was filed against the second respondent. 2, the second respondent was not arraigned and did not take or make a plea to any count in the charge of allegations of crime. 3, the second respondent did not go through a criminal trial. 4, the second respondent was not convicted of any crime or any criminal activity. 5, no sentence of imprisonment was imposed on the second respondent. 6, no sentence of fine was imposed on the second respondent. 7, no form of sentence was imposed on the second respondent. 8, case number 93C4483 was a civil suit in respect of which the court exercised civil jurisdiction under 18 U.S.C. 981 and 28 U.S.C. 1345 and 1355. In paragraph 47, he said, I also note that in case number 93C4483 at the United States District Court, Northern District of Illinois, Eastern Division, no impersonal criminal sentence was imposed on the second respondent. 49, the second respondent was not convicted in case number 93C4483, United States District Court, Northern District of Illinois. The United States of America, through its embassy in Nigeria, had, by a letter dated February 4, 2003, addressed to the then Inspector General of Police, confirmed that upon the record checks for the Federal Bureau of Investigations, National Crime Investigation Center, NCIC, a centralized information center that maintains the record of every criminal arrest and conviction within the United States of America, there were no records of any form of criminal arrest, warrants against the second respondent. I shall rely upon a copy of the said letter of February 4, 2023, signed by Michael M. Bonner. Under cross-examination by the fourth respondent, RW2 has stated that as a practicing attorney in the United States, he knows that there cannot be a conviction unless there is an indictment. He also stated that exhibits RA8 and RA9 gave the second respondent a clean bill of health as far as criminal conviction is concerned. When cross-examined by the petitioner's counsel, RW2 has stated that the American court relied on Section 981 of the American Money Laundering Law, which is a civil and not Section 982, which is criminal, and which the petitioner stated in their petition. He further stated that in the US, even a minor traffic infraction will be reported, so that if someone has a criminal record, the general record will show it. He added that a general search was conducted in respect of the second respondent. A look at exhibits RA8 and RA9 tendered by the second and third respondents showed that upon receipt of exhibits RA8 written by Nigeria's Inspector General of Police to the Consular General of the United States Embassy in Nigeria, inquiring of the criminal record of any of the second respondents, the U.S. Embassy had replied with the exhibit RA9 and stated as follows, quote, in relation to a letter dated February 3, 2003, reference number SR 3000, IGP SEC, ABJ volume 24 to 87, regarding Governor Bola Ahmed Tinubu, a record check of the Federal Bureau of Investigation, National Crime Information Center, NCIC, was conducted. The results of the checks were negative for any criminal arrest records, warrants for Bola Ahmed Tinubu, POB 29, that's date of birth, March 1952. For information of your department, NCIC is a centralized information center that maintains the record of every criminal arrest and conviction within the United States and its territories. Apart from the above, Section 249 of the Evidence Act 2011 has stipulated how previous criminal convictions outside Nigeria can be established. Section 249, subsection 1 and 2 provides a previous conviction in a place outside Nigeria may be proved by the production of a certificate purporting to be given under the hand of a police officer in the country where the conviction was had, containing a copy of the sentence or order and the fingerprints of the person or photographs of the fingerprints of the person so convicted, together with evidence that the fingerprints of the person so convicted are those of the defendant. 2, a certificate given under subsection 1 of this section shall be prima facie evidence of all facts set out in it, without proof that the officer purporting to sign it did in fact sign it and was empowered to do so. It is instructed to observe that when cross-examined by the fourth respondent, PW1 had admitted that there was no certificate under the hand of a police officer in the United States of America where a crime was alleged to have been committed by the second respondent. It is significant to state that this petition is a declaratory action in which the petitioners are seeking inter alia that this court declare the second and third respondents as unqualified to contest the election. The petitioners who have made the allegation have the burden to prove the allegation on the strength of their own case, not on the weakness of the respondents. The Okereke vs. Umahi, Minike vs. PDP, Omushore vs. Rebushola, Ucha and Elechi. The petitioners have evidently failed to establish the allegation that the second respondent is disqualified from contesting the presidential election under Section 137, subsection 1D of the 1991 Constitution, because he was fined the sum of $460,000 by District Court, Northern District of Illinois. As shown above, the order of forfeiture in Exhibit PA5, on which the petitioners have relied, does not qualify as a sentence of fine for an offense involving dishonesty or fraud within the contemplation of Section 137 sub D of the 1999 Constitution. As regards whether paragraph E of Section 1, as regards whether paragraph E of Section 137(1) will be read together with paragraph D of that subsection, the settled rule of interpretation of the Constitution or statute is that where the court is faced with two or more differing provisions over the same subject matter, the judicial attitude is to treat the special provision as overriding the general provision, on the principle that by enacting a separate provision for a part of the general class intends that the said part shall not be treated the same with the general class. The Uchuku Nada versus Attorney General Anambra State, Martin Freuder and others versus Major and Co. Nigeria Limited, as FMBN versus Olo. In both paragraph D and E of Section 137, subsection 1, a sentence for the offense of involving dishonesty is mentioned, but in paragraph E, a limitation of 10 years has been introduced. Then it means, in respect of the sentence for offense of dishonesty, the two paragraphs must be read together, such that for conviction and sentence for an offense involving dishonesty, it must be within a period of less than 10 years before the date of the election, in order for such a conviction and sentence to be used for disqualifying a presidential candidate from contesting the election. It is also a cardinal principle interpretation of the Constitution that relevant provisions must be read together and not disjointedly. Abegunde and the State House of Assembly. From all the foregoing, it is clear that having regard to the provisions of Section 137 of the Constitution of Federal Republic of Nigeria 1999 as amended and the evidence laid before this court, the second respondent was not disqualified from contesting the presidential election held on 26 February 2023. Consequent issue 1 is hereby resolved against the petitioners and in favor of the respondent. Issue 2 is whether, having regard to the evidence adduced by the parties, the petitioners has established that there was substantial non-compliance with the provisions of the Electoral Act 2022 and that the non-compliance substantially affected the results of the election. Then we shall skip the submissions of counsel. Well, the appropriate starting point for the resolution of this issue is to first consider the objection of the first respondent to ground 2 of the petition, which they raised at preliminary stage, but which we deferred to this stage because it touches on the substance of the petition. The first respondent objection is that the petitioners are stopped from relitigating the issue contained in paragraph 2, paragraphs 33 to 79, as well as reliefs 5.1 and 2 of the petition, as is released to electronic transmission and collation of the election results in view of the subsistent judgment of the Federal High Court in suit number FHC ABS CS 1454/2022, Labour Party Independent Electoral Commission, delivered 23rd January 2023. A certified true copy of which they attached to their petition as Exhibit A, and which was later tendered in evidence at trial as Exhibit X1. The first respondent particularly referred this court to paragraph 55 and 74 of the petition and submitted that the facts alleging non-compliance with the Electoral Act, which are set out in paragraph 33 of the petition, are hinged on the same issue of electronic transmission of results, which was resolved against the second petitioner in the said suit number FHC ABSC 1454/2022, to the effect that there is no mandatory requirement for the first respondent to electronically transmit results of the election. Reliance was placed on Begin and others was Oriare, Oyeroba, and another was Laupa. An examination of petitioner petition and Exhibit X1 shows that in their petition, specifically paragraph 37, 45, and 45, the petitioners have averred as follows. The petitioners aver that at the conclusion of the election and at each polling unit, the presiding officer was mandatorily required to electronically transfer the result of the polling unit directly to the collation system of the first respondent. In addition, the presiding officer was also mandatorily required to use the beavers to upload a scanned copy of the Form EC8A to the first respondent's result viewing portal, RF, in real time. 45, the petitioners aver that apart from the importance of the beavers in the capture of accreditation at polling unit in an election, the beavers is also mandatorily to be used in the process of uploading the information or data imputed into it by the first respondent's presiding officer at each polling unit, who shall, upon completion of voting and due recording and announcement of result, 1, electronically transmit the result of the polling unit directly to the collation system as described by the first respondent. 2, use the beavers to upload or a scanned copy of the Form EC8A to the annual result viewing portal area as prescribed by the first respondent. And 3, take the beavers and the original copy of each of the forms in tamper-evident envelope to the registration area reward collection officer in the company of security agents. The polling agents may accompany the presiding officer to the registration area reward collection center. In Exhibit X1, the certified true copy of the judgment of the Federal High Court in suit number FHC ABJ CS 1454/2022 Supra, which the first respondent is contending to constitute estoppel to ground 2 of this petition. The sole question presented for determination in the originating summons is as follows. Whether, having regards to combined effect of sections 47(2), 52, 64, 65, and 62(1) and 2, and other relevant provisions of the Electoral Act 2022, the respondent can still insist on manual collation of results in the forthcoming general election. Upon determination of the above questions, the plaintiff, which is the second petitioner herein, sought for the following reliefs. 1, a declaration that the respondent has no power to opt for manual method other than electronic method provided for by the relevant provisions of the Electoral Act. 2, an order of this honorable court directing or compelling the respondent to comply with the Electoral Act 22 on electronic transmission of results in the forthcoming general election. In its judgment in Exhibit X1, the Federal High Court held as follows. In view of the foregoing, can the act of the defendant in collecting and transferring election results manually in the forthcoming 2023 general election is said to be contrary to the relevant provisions of the Electoral Act 2022? The answer can only be in the negative, as there is nowhere in the above cited section where the Commission or any of its agents is mandated to only use an electronic means in collecting or transferring of election results. If any, the Commission is only mandated to collect and transfer election results and number of accredited voters in a way or manner deemed by it. In view of the above, I'm finding that by the provision of sections 52 and 65 of the Electoral 2022, the correct interpretation of said statute is that the defendant, Independent National Electoral Commission, is at liberty to prescribe the manner in which election results could be transmitted and are so called. Consequently, this matter is hereby dismissed. Clause of court. It is tried law that for a judgment of a court to conclude estoppel in a subsequent action, it must have finally decided the same issue in contention between the same parties or their previous. The Anchorage Leisures Limited and others versus Eco Bank Nigeria Limited. And Adebayo versus Babalola and others. From the averments contained in the petitioner's petition, which I have earlier reproduced above, it is clear that the petitioner allegation of non-compliance averred in paragraph 2 of the petition is hinged on the contention that ANIC was mandatorily required to electronically transmit or transfer the results of the polling units directly to the collation system of the first respondent, and also mandatorily required to use the beavers to upload a scanned copy of the Form EC8A to the first respondent result viewing portal, IRF, in real time. First, it is evident that in both this petition and in Exhibit X1, the parties are the same. In that second petitioner herein was the sole petitioner plaintiff in Exhibit X1, while the first respondent herein was the sole defendant in Exhibit X1. Secondly, from the above referred averments in this petition and the relief sought by the petitioner in second petitioner, in Exhibit X1, it is clear that the issue in both cases is whether the first respondent herein is mandatorily required to electronically transmit or transfer election results from the polling unit direct to the collation system. With the judgment of the Federal High Court in Exhibit X, the excerpt of which has been reproduced above, it is evident that the Federal High Court had decided the issue against the petitioners herein by holding that the first respondent cannot be compelled to electronically transmit election results. There is no evidence before this court that the second petitioner against whom the judgment in X1 was given has appealed against that decision. It is settled law that an appeal decision of the court remains subsisting, binding on the parties. The Abba versus Abba Aji, Jegede and INEC, Alexander and others versus Lone Star Drilling Company Limited. It is also tried that the doctrine of issue established is that where an issue has been decided by a competent court, the court will not allow it to be relegated by the same or different parties. It is also pertinent for us to state that in the final address of the first respondent, our attention was drawn to the recent decision of the Lagos Division of this court in appeal number CA/LAG/CV/332 of 2023, APC and Labour Party and 42 others, wherein this court set aside the decision in suit number FHC/L/CS/370/23, Labour Party and others versus ANIC. Another case, forum shopped by the second petitioner at the Lagos Division of the Federal High Court after losing at the Abuja Division of the same court in Exhibit X1. In the judgment in appeal number CALG-CV-332/2023, this court had upheld the decision of the Federal High Court in Exhibit X1 and construed same against the petitioners as issue estoppel in relation to the petitioner contention which they are making in this petition, that ANIC is mandatorily required to electronically transmit election results. By virtue of Section 122, subsection 2 of the Evidence Act, this court is entitled to take judicial notice of the decision in appeal number CALG-CV-332/2023, APC versus Labour Party and 42 others. Not only that, This court is by the doctrine of precedent bound by that decision. Since the above judicial pronouncements have decided that under the Electoral Act and admin regulation guidelines for the conduct of elections, the first respondent cannot be compelled to electronically transmit election results, the petitioners are clearly stopped by those decisions from contending in ground 2 of this petition that the first respondent is mandatorily required to electronically transmit the election results to the election system. As a court of first instance, in this petition, we shall, notwithstanding our above finding, proceed to determine the merit of ground 2 of the petition relating to non-compliance. It is observed that in their petition, the petitioners have alleged the same set of facts in paragraph 33 to 79 as constituting both non-compliance and corrupt practices. On a careful perusal of the petition, however, it seems to us that the allegations of non-compliance are contained in paragraph 33 to 56 and 59 of the petition, while specific allegations of corrupt practices were made in paragraph 60 to 78, even though them were also founded on the same facts of non-compliance alleged by the petitioners. The gravamen of the petitioner allegations of non-compliance are as encapsulated in paragraphs 37, 45, 50, 51, and 55 of the petition, which are reproduced below. I've produced. The respondents, particularly the first respondent, denied the allegations of non-compliance made by the petitioners in their respective replies to the petition. In particular, the first respondent denied that there was any collation system of the first respondent to which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer, and stated that the prescribed mode of collation of results is as stipulated in paragraph 50 to 55 of the regulations and guidelines for the conduct of elections. He further stated that the prescribed mode of collation was manual collation of the various forms EC8A, EC8B, EC8C, EC8D, and EC8E of the presidential election. See paragraph 31 of the first respondent's reply. He also stated that the BVAS is designed to upload the accreditation data at the end of the accreditation process and transmit the result of the election at a polling unit through the e-transmission system, which is uploaded to the first respondent's result viewing portal, IREF. The first respondent further averred that the upload of data or images captured and automatically restored on the BVAS device requires data service, and where there is no such data service, where the service is poor, the BVAS service is designed to work offline, and the upload of data will occur when data service is available. He also stated that polling unit results were duly uploaded on the first respondent e-transmission system by the respective presiding officers at the end of the election, but some of the results were not visible on the IREF portal due to the technical glitch experienced on the election day. In specific response to the petitioner's allegation of failure, refusal, and neglect to instantly transmit and upload the results electronically from the BVAS to the IREF, the first respondent stated in paragraph 55, Romans 7 and 10 as follows. Immediately after the election of 25th February 2023, polling unit results were uploaded and received by the e-transmission system whilst using the BVAS. There was a temporary failure of communication between the e-transmission system and the IREF portal for the presidential election. In this regard, the e-transmission system returned an HTTP 500 error, which is an application error such that transmitted results, though received on the in-transmission application hosted on the AWS, the in-transmission could not organize and push the results instantly to the presidential module on the IREF portal because it could not map the results uploaded for the presidential election to any state. The first respondent pleads and shall rely on the AWS CrowdTrail logs indicating patches deployed to fix the error of technical glitch on the election day. Upon resolution of the HTTP 500 error, the results which were delayed in the e-transmit system were eventually organized and pushed to the IRF portal. The results are available as generated in their original form from the polling unit using the beavers. The first respondent stated that the technical glitch did not in any way affect the result of the presidential election. However, in paragraph 37 of their reply to the first respondent reply, the petitioners denied that there was any technical glitch experienced on election day as contended by the first respondent, and stated that the failure of the first respondent to upload the presidential election results using the beavers to the average was a ploy to manipulate the actual results of the election. As indicated in their pleadings and submissions of counsel, the petitioner's allegation of non-compliance with the Electoral Act 2022 and the regulations and guidelines for the conduct of elections 22 is anchored on the provisions of sections 47.2, 61, 2 and 5, 64.4a and b, 64.5 and 73.2 of the Electoral Act, and paragraph 38.1 and 2, 48a, b, c, 55, Roman 5, 7 and 20, 51.2, 54.12 and 55.12, 93 of the regulations and guidelines. I have carefully considered the submissions of the parties on this issue of non-compliance with the Provisional Electoral Act and the paragraphs of the regulations and guidelines for the conduct of the election 2022. The Independent National Electoral Commission, the first respondent herein, is established by Section 153, subsection 1F of the Constitution of the Federal Republic of Nigeria 1999, and part of its functions are stated on paragraph 15 in Article F, Part 1 of the third schedule to the State Constitution, is to organize, undertake, and supervise elections, including election to the office of the President and Vice President, among other political officers listed. In a creation of the Constitution, INEC is empowered by Section 160, subsection 1 of the Constitution to make its own rules or otherwise regulate its own procedure, and in so doing, it shall not be under the control of the President. Indeed, by Section 158, subsection 1 of the Constitution, INEC shall not be subject to direction or control of any authority person. By Section 4 of the 1999 Constitution, the legislative powers of the Federal Republic of Nigeria is vested in the National Assembly, which in the exercise of that power has enacted the Electoral Act 2022 to regulate the conduct of elections in the federal, state, and area councils of the Federal Capital Territory. Section 47, subsection 2 of the Electoral Act, relied upon by the petitioners, mandates every presiding officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Also, under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of accredited voters and the results of the ballot, in a manner as prescribed by the Commission. Section 62 sub 1 of the Act specifically provides that after the recording and announcement of the result, the presiding officer shall deliver same along with the election materials under security and accompanied by the candidates or their agents where available to such person as may be prescribed by the Commission. Further, Section 64.4 states that the collation officer or return officer at an election shall collate and announce the results of an election subject to his or her verification and confirmation that A, number of accredited voters stated on the collected results are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under Section 47, subsection 2 of the Act, and B, the votes stated on the collected results are correct and consistent with the votes or results recorded and transmitted directly from the polling units under Section 60, subsection 4 of the Act. At this stage, it should be noted that Section 47, sub 2, referred to in Section 64.4a, relates to the procedure for accreditation of voters by the presiding officer using the technological device prescribed by the Commission. As for Section 64, referred to in Section 44b of the Act, It only mandates the presiding officer to count and announce the result at the polling unit. In fact, subsection 5 of Section 60 goes ahead to mandate the presiding officer to transfer the result, including total number of accredited voters and the results of the ballot in a manner prescribed by the Commission. The Act also provides in Section 64(5) that the collation officer or returning officer shall use the number of accredited voters recorded and transmitted directly from polling units under Section 47(2) of the Act, and the votes or results recorded and transmitted directly from polling units under Section 64 of the Act to collect and announce the result of an election if a collected result at his or her lower level of collection is not correct. From the aforementioned sections, it is clear that while subsection 4 of Section 64 provides for what the collation or return officer will use to verify and collect the results, subsection 5 also provides for what the collation or return officer will use to collect the results. Subsection 6 of the same section provides for what the collation or return officer will use to determine the correctness of disputed result where there is a dispute. These are A, the original of the disputed collected result for each polling unit where the election is disputed, which in our view means the physical or hard copy of the disputed result. B, the technological device used for accreditation of voters in each polling unit where the election is disputed. C, the data of accreditation recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 47, subsection 2 of the Act. And D, the votes and result of the election recorded and transmitted directly from each polling unit where the election is disputed and as prescribed under Section 64, sub 4 of the Act, which requires only the counting and announcement of results polling unit. A careful examination of the above sections, that opened by the petitioners, show that the Electoral Act had used the words deliver in Section 62, subsection 1, transfer in Section 60, subsection 5, and transmitted directly in Section 50, sub 2, 64, 4, 5, and 6 of the Electoral Act 2022, in stating how results of election should be handled under those provisions. A look at the definitions of those words in the Black's Law Dictionary 6th edition shows that the word transfer is defined at page 1497 as to convey or remove from one place, person, etc. to another, or to pass or hand over from one to another, or to specifically to change over the possession or control. The word transmit, on the other hand, is defined by the same law dictionary to mean to send or transfer from one person or place to another, or to communicate. In my view, the Electoral Act 2022 has used the words deliver, transfer, and transmitted directly, interchangeably, to describe how the results of the election shall be moved from one stage to another until the results are finally collected and declared. In all these, the Electoral Act 2022 has not specifically provided that the result of the election shall be electronically transmitted. It is in the exercise of its powers under Section 160, subsection 1 of the 1991 Constitution, and Section 148 of the Electoral Act 2022 that the first respondent does annex herein made the regulations and guidelines for the conduct of elections 2022, as well as annex manual for election officials 2023. In paragraphs 14A and 18A of the regulations, the first respondent prescribed the bimodal voter accreditation system, BVAS, as the technological device for the purpose of accreditation and verification of voters in the 2023 general elections. The petitioners have also hinged their allegation of non-compliance on paragraph 38(1) and 2, 48A, D, C, 55 and 7 and 20, 51(2), 54(7), 55(7), and 93 regulations and guidelines. Paragraph 38 of the regulation provides as follows. Extensive, get a copy of the guidelines you see. There we have to produce it in this judgment. From the foregoing provisions of the regulations and guidelines relied upon by the petitioners, it is clearly evident to me that although the Electoral Act has provided in Section 62, subsection 1, for the delivery by the presiding officer of the result along with other election materials under security and accompanied by candidates or their polling agents were available, such a person as may be prescribed by the first respondent. The first respondent has, by paragraph 38 of the regulations and guidelines quoted above, introduced electronic transmission to a collation system, in addition to the physical transfer of the election results to the registration area of ward collation officer. As stated earlier, the technological device as prescribed by ANIC in the conduct of the 2022 election is the bimodal voter accreditation system, BVAS. The function of the BVAS, as stated in paragraph 14A and 18A, is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or her fingerprints or face, facial recognition, thus accrediting the voter to vote at the election and storing the data and number of such accredited voters. By paragraph 38, 2 and 3 of the regulation, the BVAS is also to be used by the presiding officer to upload a scanned copy of the EC8A to the ANIC results viewing portal, IREF, after which the presiding officer shall take the BVAS and the original copy of each of the forms to the registration area from ward collation officer. From the above functions of the BVAS, it is clear to me that apart from using the BVAS to scan the physical copy of the polling unit results and upload same to the IREF, there is nothing in the regulation to show that the BVAS was meant to be used to electronically transmit or transfer the result of the polling unit direct to collation system. It should be noted that the ANIC results viewing portal, RF, is not a collation system. The Supreme Court in Oyetola and ANIC 2023, ANIC 23 LPELR, has explained the difference between the collation system and the IRF. In that case, AGIM JSC held as follows court. As their names depict, the collation system and the ANIC result viewing portal are part of the collation process, the election process, and play particular roles in that process. The collation system is made of the centers where results are collected at various stages of the election. So the polling unit results transmitted to the collation system provides the relevant collation officer the means to verify a polling unit result as the need arises for the purpose of collation. The results transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results on the election day. The community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of elections 2022, and the ANIC Manual for Election Officials 2023 show that the Electoral Act provides in Section 62, subsection 1, that after recording and announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their polling agents to such persons as may be prescribed by the Commission. The regulations and guidelines, as well as the ANIC manual, also state that hard copies of election results shall be used for the collation, and it is only where no such hard copies of the election results exist that electronically transmitted results or results from the IRF will be used to collect results. The petitioners who contend that ANIC was mandatorily required to electronically transmit the election results to the collation system have called PW2 as an expert witness who stated that he is a software engineer. He stated that he was aware that ANIC was mandated to electronically transmit or transfer the result from the polling unit direct to the collation system as prescribed by ANIC. He stated that the IRF portal is part of the technological architecture developed or deployed by ANIC for the storage, management, display, and uploading of polling unit results to be accessed by the public. However, under cross-examination, he admitted that he was not familiar with the operations and application of the Beavers machine, and that his investigations and findings were on the INEC portal. He also agreed that it was only INEC that could prescribe the method of transmission of election results. PW4 was also called as an expert witness by the petitioners, even though he stated that part of his brief by Labour Party was to determine INEC compliance with the Electoral Act 2022 and the INEC regulations and guidelines for conduct of the elections 2022. He prevaricated under cross-examination by the first respondent when he first stated that INEC at the IRF portal is an electronic collation system, but later recanted and said the IRF portal is not capable of collating and or tabulating the results of an election. The witness also stated under cross-examination by the second and third respondents that it is the image of Form EC8A that will be transmitted to IRF, while the hard copy of the Form EC8A will be taken to the Ward Collation Center. As for PW7, also called as expert witness by the petitioners, our evidence was basically in respect of the health status of Amazon Web Service, which hosted the INEC IRF portal. The testimony of PW8, the cyber security expert, also called by the petitioners, also related to the INEC IRF portal. On the part of the first respondent, RW1, Dr. Lawrence Bayode, the Deputy Director in the ICT Department of the first respondent, has testified that contrary to the assertion of the petitioners in paragraph 37 of the petition, there was no collation system of the first respondent to which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer. He stated that the prescribed mode of collation was manual collation of the various forms EC8As, EC8Bs, EC8Cs, EC8Ds, and EC8Es for the presidential election. He explained that the Beavers machine was designed to upload accreditation data at the end of the accreditation process and scan and transmit the results of the polling unit results through the e-transmission system to the IRF portal. Even as this witness was cross-examined by the petitioner's counsel, he was not cross-examined on his evidence that INEC has not established any collation system which results will be electronically transmitted from the polling unit. Thus, his testimony on that fact remained unchallenged and uncontroverted. It is settled law that the court has a duty to act on unchallenged and uncontroverted evidence. The Bromwen Energy Trading Company Limited, OAN Overseas Agency, Ogunyade versus Oshunke, and others. In addition, RW2, called by the second and third respondents, had testified that the first respondent, through its chairman, made clarifications on 23rd of February 2023 that raw figures of election results will not be transmitted electronically by the first respondent, as such transmission was susceptible to hacking. He identified exhibits R24 and RA24 and RA25 as documents he referred to in his statement. These are the certified true copies of pages 28 and 27 of Tribunal newspapers of 23rd February 2023, wherein the chairman made the said clarification. As indicated in our ruling on objections to documents, the petitioners did not object to the contents of exhibits RA24 and RA25, but only stated that they were objecting to the heading, but not the contents. We overruled that objection in our ruling because the reason advanced by the petitioners' counsel did not amount to a proper objection to those documents. Although also noteworthy that the petitioners never cross-examined RW2 on his oral evidence and the said exhibits in support of his oral evidence. In exhibit RA24, the INEC chairman was reported to have stated that raw figures will not be transmitted because the law does not allow for electronic transmission of results and because it is susceptible to hacking. He stated that only scanned copies of polling unit results will be uploaded to the RF for public view. From the evidence led by the parties on this issue, it is clear that apart from testifying that the first respondent failed to transmit scanned copies of polling unit results to the RF portal. None of the witnesses called by the petitioners had given evidence of the existence of any collation system to which the results shall be electronically transmitted by the presiding officers of the first respondent. Contrary to the contention of the petitioners that under the regulations, it will not be possible to collect the presidential election results without verifying them with the electronically transmitted results. Paragraph 92 of the same regulations categorically provides that at every level of collation, where the annex copy of collected results from the immediate lower level of collation exists, it shall be adopted for collation. In addition, paragraph 48C of the regulations provides that if no result has been directly transmitted electronically for a polling unit or any level of collation, the provision of clause 93 of this regulation shall apply. The said clause 93 of the regulations, which I had earlier quoted, provides that where the annex hard copy of collected results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the RF portal to continue collation. And where none of this exists, the collation officer shall ask for the duplicate copies issued by the Commission to the Nigerian police or to the agents of political parties in that order. The foregoing provisions of the Electoral Act and the annex regulations clearly show that it is not correct, as contended by the petitioners, that results of the election cannot be validly collected without the electronically transmitted results. Indeed, the regulations primarily provide for manual transmission or transfer and collation of results. There is nothing in the Electoral Act or the annex regulations and guidelines to show that an electronic collation system was prescribed by the Commission, which results will be electronically transmitted. Thus, the petitioners were unable to establish the assertion that the first respondent is mandatorily required to electronically transmit the polling unit results to a collation system. The first respondent, on the other hand, has adduced unchallenged evidence that apart from the annex RF portal, no collation system was established by the first respondent to which the result of the presidential election must be electronically transmitted for collation. It is therefore my finding that both the Electoral Act and the regulations and guidelines provide for manual collation of election results, and the electronic transmission to a collation system apparently introduced by the first respondent in the regulations and guidelines are not mandatory as contended by the petitioners herein. Also, my finding based on the evidence adduced that the only collation system put in place by the first respondent in the conduct of the presidential election is comprised of the physical collation centers in the registration areas or ward collation centers, local government area collation centers, state collation centers, and the national collation centers elaborately stated in paragraphs 47, 50, 53, 54, and 55 of the regulations and guidelines for the conduct of elections 2022. With regard to the petitioner's contention that the first respondent deliberately failed to upload the presidential election results to the annex results viewing portal, RF real time, the petitioners averred in paragraph 53, 97, 98, the petition that the petitioner also 53. The petitioner also contend that in manifest violation of the first respondent regulations and the Electoral Act 2022, the results of the presidential election held in the polling units were not fully uploaded on the RF as at the time of the purported declaration of the second respondent as the winner of the presidential election, which gave room for manipulation of the said results by officials of the respondent. 97. The first respondent, via a written communication, sought to excuse the manifest non-compliance with the requirements of the Electoral Act 22 and the regulations by claiming that there were glitches in the electoral system which prevented it, that's first respondent, from uploading the results of the presidential election from the polling units to the RF portal on the day of the election. The said written communication is hereby pleaded. 98. The petitioner shall contend that the alleged glitches in the electronic system installed and managed by the first respondent were a ploy invented by the first respondent to to credit unlawful votes to the second respondent and thereby wipe out a clear advantage which inured to the petitioners following the lawful exercise of voting rights by the electorate. In response to the above allegation, the first respondent adverted in paragraph 59, 55, 7, 8, 9, and 10 of their reply to the petition that I will produce them here. In paragraph 37 of their reply to the respondent's reply, the petitioners have again denied that there was any technical glitch and maintained their assertion that the failure to upload the results on the IRF was a ploy by the first respondent to manipulate the results. They stated that they will rely on the server logs and server contents of the IRF hosted on the AWS cloud platform to show that the results of the election were uploaded on the IRF portal, but the first respondent attempted to delete or remove the uploaded results. It is stressed that a petitioner who alleges non-compliance with the Electoral Act has the legal burden to establish that non-compliance and show how the non-compliance substantially affected the result of the election. Ladoja and Ajimobi, Shinkafi, and Yari. In proof of their assertion, the petitioners subpoenaed PW7 and PW8 as expert witnesses, but the respondents challenged their competence to testify because their witness statements on oath were not front-loaded, along with the petition, as mandatorily required by paragraph 45 of the first schedule to the Electoral Act. In my ruling at the earlier part of this judgment, I had upheld the respondents' objection and set out the evidence, which include their witness statements on oath and the documents and or reports tendered through them. These are exhibits PCJ-A to F, PCJ-4, 6 reports of AWS health dashboard status and certificate of compliance tendered through PW7, and exhibit PCK1, metadata admitted through PW8. However, notwithstanding that position, I shall proceed to consider the evidence of PW7 and PW8 and the other witnesses called by the petitioners. PW7 claimed to be a cloud engineer or architect, an employee of Amazon Web Services. She stated that she is not only a member of the Labour Party, the petitioner is herein, but she contested election as a candidate for member House of Representatives for Ogoja, Rogyala, Federal Constituency of Cross River State. She stated that for an IT application, the SDLC includes requirement gathering, analysis, and design. Collation centers to and design, yes. The development from implementation, testing the code, staging the software and development and deployment. She stated that she was aware that at the process of testing and staging the software code and problems or challenges, any problems or challenges with the software will usually show and or be flagged. She stated that each function is supposed to be tested and any issues flagged ought to be remedied before deploying the software. He stated that if a software from application has any glitch, such a glitch will pop up, that is flagged at the testing stage. He stated that from her preliminary review of the public viewing facing the RF website, she is aware that the polling unit results images are stored in Amazon S3 and AWS storage service. He stated that as an employee of AWS, the AWS has a service level agreement, SLA, with its customers, which is accessible to the public on docs.aws.amazon.com, and that by the SLA for S3 service, it is designed to provide 99.999% durability and 99.99% availability of objects stored over a year. He said this is accessible to the public on http://docs.aws.amazon.com, Amazon S3 latest user guides from data durability.html. He stated that the AWS code servers are hosted in 33 regions. The health status of AWS cloud service for all regions for the past 12 months from date is accessible to the public on http://health.aws.amazon.com. health status. It stated that the health status of each service in each region on February 25, 2023 indicated that there were no glitches on any of the AWS cloud servers. It stated that from the post-event summary PAs by AWS, the last time a significant outage occurred on the AWS cloud servers was on December 10, 2021, which was an internal connectivity issue that affected EC2, API, and Container API, among other services access issues affecting only one region. He said this is available to the public. EWS7 stated that she was aware that a glitch in the software means a malfunctioning, as a result of which the application is not able to perform properly, and that fixing a glitch in a software application by the creation of patches refers to a series of changes made into the system by writing small code, which is imputed into the software, change its current state and thereby function properly. On cross-examination by the first respondent, PW7 admitted that she missed production maintenance, which is an important element of software development lifecycle. He denied that glitches occur at post-production maintenance stage and stated that it appears at the testing stage. He stated that she was aware of personal health dashboard, but stated that the first respondent's personal health dashboard is not before the court. He admitted that the EWS adopts a shared responsibility model in which AWS plays its part while the customer plays its own part when it comes to security. He admitted that the report that only shows the health status of all AWS services in all regions in terms of the infrastructure and not security. He admitted that in order to know what happened on applications deployed on AWS infrastructure by a customer, it is not necessary to get a technical report. EW7 also stated that she is familiar with AWS Cloud Trail, and there is a Cloud Trail for every AWS account and for every API action made on that account. She admitted that she did not produce the Cloud Trail for any deployed application before the court. He denied that the Cloud Trail is the best account of what transpired on any deployed application, but did not state the best way to know what transpired. He stated that it is highly unusual for glitches to occur for primary functions of applications in production. He stated that she was not aware that glitches happened with the Central Bank of Nigeria e-money project, or the one that happened with the MTN Mono PSG. He admitted that she was a candidate for the Labour Party at the last election. He also admitted that the subpoena under which she came to court was served on her personally and not on Amazon Web Services. Also on cross-examination by the second and third respondents, EW7 admitted that exhibit PCJ2, which she presented as her employment verification letter, was not signed by anyone, but insisted that there is the name of Employment Resource Center written on it. He also admitted that she had been attending the court and watching the proceedings before the day of her testimony. He admitted that the report she presented before the court is public information posted by Amazon, and that it is available and accessible to the public. He, however, insisted that the report is hers because she was the one who downloaded it, brought them to the court. PW7 also admitted under cross-examination that she won primary election for her constituency under Labour Party, the second petitioner, and that she even filed an action against ANIC because she was not placed on the final list of candidates published by ANIC. She admitted that her complaint was because she tried several times to upload her information on ANIC's site, but all her efforts failed because of network failure. She admitted that network failure can happen to either end of an application, even as she disagreed that there was a glitch on Annex side. She admitted that in her affidavit. She stated that Annex site crashed. EW7 also stated that she was aware that EWS experienced outage of several hours on Tuesday, 28 February 2017, and that as at 2021, EWS also was reported to have suffered more than 27 outages. He also admitted that what was sent to RF was the image of the form EC8A. On cross-examination by the fourth respondent, PW7 stated that she did not know about password protocols and cannot speak about password protocol to modify the applications of ANE. She admitted that the open cross-access information she downloaded in her report cannot be amended by her. In fact, she admitted that she was not representing Amazon Web Services in this case. However, insisted that she is an expert. She stated that she was aware of glitch which affected Japan brokers in September 2021, but stated that the last one she was aware of was in December 2021. As to whether glitches can happen again, he stated that anything is possible. In his evidence, PW1, Dr. Chibike Ugoike, another expert witness called by the petitioners, stated that he is a cybersecurity and risk advisory consultant and that he was approached by the Labour Party to provide expert evidence in this petition. He said he had read the Electoral Act 2022 and the ANEG regulations and guidelines for the conduct of elections 22 and the ANEG Manual for Election Officials 2023, with particular attention to the relevant provisions dealing with uploading and transmission of election results from the polling units using the beavers to IRF portal. He stated that he has also read the petition as well as the reply to the petition filed by the first respondent. He stated that from his reading of those documents and processes, when a software application undergoes the required minimum testing for deployment, any functionality error or bug will be flagged. He stated that the purpose of testing is to remedy or resolve such errors before the application is deployed to production. On cross-examination by the first respondent, PW stated that he was approached on 10th March 2023 and he finished his work sometime in May 2023. He said that he did his preliminary report on 17th and 18th March. On 17th and 18th March 2023 and concluded the final report at the end of May 2023. PW stated in paragraph 14 of this, his adopted written witness statement that he read the petition and the first respondent replied to the petition in doing his work, stated that he could not recall whether he read the petition. But when his attention was drawn to paragraph 14 of his statement, he agreed that he had read those pleadings. He admitted that it is not impossible for errors to occur after deployment of technology or application. When referred to paragraphs 22 and 23 of his statement, he stated that he referred to the metadata on the IRF in 3 polling units. He established that it is possible to show metadata. He stated that there were errors in those polling units and he did not have to examine the physical copies of the forms EC8A of those polling units. He stated that from the tabulation of the metadata, he could not tell that whether the results stated in those polling units were collected. He stated that all the work he did was on his computer. He confirmed that the AWS security model is a shared responsibility model between AWS and the client. He stated that he was aware of the cloud trail and confirmed that the cloud trail will explain the availability of the application of ANEC on the AWS infrastructure. AWS, who insisted that there was an electronic collation system, only pointed to an upload at the last paragraph of exhibit ECK2 and stated that it means an electronic collation system. When cross-examined by second and third respondents, PW denied that it was part of his brief to assist the Labour Party to respond to the respondent's reply. He admitted that he did not inspect any of the beavers' machines and did not interrogate Festus Okoye, whose statements he referred to. He confirmed that Exhibit A, which he attached to his report, is the metadata of 23 pages showing multiple uploads. He denied that it contains information which are coded and not explained, and insisted that the information he provided are decrypted and readable. He admitted that he supplied some links in some paragraphs of his report, but stated he did not expect the court to go and browse, access, and download the information contained from those links. When cross-examined by the first respondent, PW admitted that he downloaded the 12 polling unit results he attached to his report from the IREF, and he did not interact with the presiding officers of those polling units and did not see the hard copies of those results. He could not also tell whether those results have been collected. Starting with the evidence of PW7, there's evidence that she is a person who has an interest to serve in this petition, being a member of the second petitioner, under whose platform she contested election for House of Representatives. Her interest in this petition is further underscored by her admission that she had been attending court and watching the proceeding prior to making her statement on oath and testifying as a witness. Her testimony, therefore, was essentially a demonstration of her support and loyalty to the second petitioner. Her claim to being an employee of Amazon Web Services is also suspect, as she produced no credible evidence to that effect. Exhibit PCJ2, which is the paper she presented as evidence of her employment by AWS, is obviously a worthless paper. It has no author, although she insisted that the author is Employee Resource Center. The paper was also not signed. Her evidence adds no value to the petitioner case because she stated that her evidence relates to the health status of AWS in terms of infrastructure and not terms of security. She had admitted that the expert report in Exhibit PCJ 3A to F, which she brought to court, are actually documents publicly available on Amazon website, which she downloaded. And her only claim to its ownership is that she was the one who downloaded it and brought it to court. She even admitted that she could not add or subtract anything from the reports. Those reports are obviously not her own. She also admitted that the health status of the first responders application posted on the AWS is not before the court. Her conclusion on the totality of this witness is that it is devoid of any probative value. As for PW8, he has demonstrated that he worked to an answer. Not only did he admit that he read the petition and reply of the first respondent in the course of his commission work, he also stated that he read the Electoral Act and annual regulations and manual for election officials. On the authority of Ladoja and Ajimobi, the evidence of this witness is also not of any probative value. Apart from the above, the other witnesses or petitioners, especially PW4, PW9, 10, 12, and 13, all stated that they voted and everything went well in their respective polling units. In particular, PW4, PW10, and 13 all stated that their polling unit results were taken to collation centers. Therefore, even the evidence of the petitioner witnesses showed that the polling unit results were physically taken to the registration areas for work collation centers. The petitioners have left no evidence to establish the existence of any collection center to which the potential election results were to be electronically transmitted for collation. On the part of the first respondent, RW1 testified that the failure to upload some of the results of the presidential election to the IREF portal real time on 25th February 2023 was due to a technical glitch experienced on their e-transmission system. RW1, through whom the first respondent tendered exhibits RA6 and RA7, stated that at the end of the polls, in some polling units, on 26 February 2023, it was observed that the first respondent that polling unit results being uploaded to the annex e-transmit system by the presiding officers were pushed to the Senate and House of Representatives modules on the IREF but the results of the presidential election were not being pushed to the presidential model on the RF. That based on threat levels and reports by security agencies that the first responder servers may be subjected to attacks on election day, the first responder first course of action was to investigate whether the servers were being attacked. The preliminary investigation showed that there was no attack, but the issue was a HTTP 500 error from which the application, within the application, which are mostly errors due to problems of configuration, permissions, or failure to create application resources correctly. That a thorough investigation revealed that the e-transmission was unable to map the uploaded results of the presidential election to any specific state, and that the presidential folder structure, which was meant to organize the uploaded result sheets in order of election, state, local government, area, ward, polling unit, was causing the application to crash and return as server error whenever it tried to create the folder structure for the presidential election. RW1 explained that creating a folder structure to organize the uploaded results in the hierarchy of election, state, local government, ward, and polling unit was a new feature introduced as an improvement in the transmission system. And that the old system randomly saved uploaded results by timestamps, making it difficult to upload results sheets by election or by state. He stated that the deficiency was observed after the Ocean State governorship election 2022. RW1 stated that during the election of 25th February 2023, the application was able to query and detect the base states for the senatorial districts and federal constituencies based on the mapping of all central districts and federal constituencies to their respective states. And that this mapping still exists in the database. And the upload was successful because it was able to identify the state and build the folder hierarchy for the results organization. But for the presidential election, the application crashed because the presidential election does not belong to any state on the first respondents database. And any attempt by the application to build a folder structure to organize the election results failed with a HTTP error response. RW1 stated that since these were live servers that were being used for the election, extra care was taken not to cause a complete outage, and four application patches or updates were created and deployed immediately with the aim of fixing the HTTP error. He stated that the first presidential election results were successfully uploaded at 8:55 p.m. on the 25th February 2023. He further stated that to confirm that the glitch actually happened, as well as the time that all patches to fix the error were created and deployed, can be viewed on AWS Cloud Trail and AWS functionality that allows enabling operational and risk auditing. He added that all actions taken to fix the error are recorded as events in the Cloud Trail logs. He stated that the technological glitch experienced on the e-transmission system was not a ploy to manipulate the election, and the glitch did not affect the results of the election. He then tendered RA6 and RA7, the Cloud Trail log, and his certificate of compliance to Section 84 of the Evidence Act 2007, and identified same as the documents he referred to in his witness statement on oath. Under cross-examination by the petitioners, RW1 confirmed that testing was carried out on the e-transmission system, the first respondent, on the 4th February 2023, before it was deployed and a report was issued. When shown a report produced on subpoena, he identified same as a report on vulnerability assessment and penetration testing data dated 22nd February 2023, but stated that it was not the report of testing carried out on the e-transmission system, 4th February 2023. Petitioners then tendered the report of vulnerability assessment and penetration testing through its witness, which was admitted as X1. From the evidence adduced on this point, it is clear that the petitioners are unable to substantiate their contention, the burden of proof of which was on them by virtue of Section 131, subsection 1 of the Evidence Act 2011. They have failed to establish that the first respondent had deliberately failed to upload the results of the presidential election to the IRF in order to manipulate the results in favor of the second respondent. The first respondent, on the other hand, has offered credible evidence in the form of Exhibits RA6 and RA7 to show that its e-transmission application posted on the Amazon Web Services, which is supposed to upload the results of the presidential election to the IRF, has suffered a glitch on the election day on 25th February 2023. On the preponderance of evidence, I am convinced that the petitioners have failed to establish their assertion that the first respondent had deliberately failed to upload the results of the presidential election to the IRF in order to manipulate the results in favor of the second respondent. As I stated earlier, the electronic transmission system of electronic transmission of results of an election is not expressly stated anywhere in the Electoral Act, but was only introduced by the first respondent, that is ANIC, in its regulations and guidelines 2022, and in the ANIC Manual for Election Officials 2023. By Section 134, subsection 2 of the Electoral Act 2022, only an act or omission which is contrary to the Electoral Act 2022 can be a ground for questioning an election. Thus, complaints relating to non-compliance with provisions of the regulations and guidelines or the manual of election officials are not legally cognizable complaints for questioning an election. Interpreting Section 138, subsection 2 of the Electoral Act 2010, which is similar to Section 134.2 of the Electoral Act 2022, the Supreme Court held in Newsom and Peterside as follows. Quote, the above provisions appear to be quite clear and unambiguous. While the Electoral Commission is duly conferred with powers to issue regulations, guidelines, or manuals for the smooth conduct of elections, by Section 138.2 of the Act, so long as an act or omission regarding such regulation or guideline is not contrary to the provisions of the Act itself, it is not of itself a ground for questioning the election. See also JGD and INEC. Since, as shown above, the electronic transmission of election results is not specifically provided for in the Electoral Act 2022, but was only provided for in the regulations and guidelines for conduct of elections 2022 and INEC Manual for Election Officials 2023, the failure to electronically transmit election results cannot be made a ground for challenging an election under Section 134, subsection 1B of the Electoral Act 2022. The petitioners also allege in paragraph 59 of the petition that the first respondent failed to record in the prescribed forms the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials on the prescribed forms EC 25A, EC 25A1, EC 8B, and EC 8B1. That is to say, electoral materials received for local government areas, electoral materials distribution for registration areas, electoral materials received for local government areas, electoral material distribution for RAs, electoral materials received, reverse logistics, and polling unit materials in respect of states where the respondent is purported, where the second respondent purportedly won. The petitioners further allege that following the order of court for inspection, they applied through their campaign organization and lawyers for the forms, but the first respondent refused to give or issue those forms and refused to allow the inspection of the forms despite the order. In response to the petitioner's allegation, the first respondent countered that its officials duly recorded in the prescribed forms the quantity, serial numbers, and other forms, other particulars of the result sheets, ballot papers, and other sensitive electoral materials in the prescribed forms EC 25A, EC 25A1, EC 8B, EC 8B1, in respect of the states where the second respondent duly won the election, as shown in the states where the petitioner won the election, as the procedure adopted in the election across all the states of the Federation are uniform and the same. The first respondent further stated that he duly complied with the order of inspection granted by the Honorable Court, and the petitioners were not denied access to the EC forms EC 25A, EC 25A1, EC 8B, EC 8B1 as alleged by the petitioners. It was the subordinate senior counsel that with regard to the state of the pleadings and the issues of fact in contention. The onus is on the first respondent to prove that there was indeed due compliance with the provisions of Section 73, subsection 2 of the Electoral Act, since petitioners are asserting the negative, while the respondents are asserting the positive. We relied on the decision of this court in First Bank Nigeria PLC, Adjacent Business Investments, and Royal United Nigeria Sterling Bank PLC, submitted that the first respondent did not leave any evidence in proof of their positive assertion there was compliance with the state provision of Section 73, subsection 2 of the Electoral Act. Learned Counsel submitted that on the part of the petitioners, they have led evidence through PW12 that the petitioners obtained order of this court for inspection of documents, but the first respondent had refused to produce the forms, despite several letters demanding the forms from the petitioners, which were tendered as exhibits PCQ1 to PCQ6. He added that the petitioners have also served subpoena duces tecum on the first respondent to produce the said forms, but the officer of the first respondent, the deputy director, certification, complaints, and legal drafting, who came to court in answer of the subpoena on 20th June 2023, failed to bring the forms. Counsel asked the court to invoke the provision of Section 167E of the Evidence Act against the first respondent and hold that the forms, if produced, would have been unfavorable to the first respondent. He further submitted that the non-compliance with Section 73(2) of the Electoral Act has been established, which has invalidated the election in those states which the second respondent was declared to have won, namely Benue, Borno, Ekiti, Gawa, Kogi, Kwara, Niger, Ogun, Ondo, Oyo Rivers of Zamfara states, which are shown in the form EC8DA, admitted in evidence as exhibit PBF. He pointed out that Section 135, Section 1 of the Electoral Act 2022 only deals with non-compliance generally, but Section 73, subsection 2 of the Act has provided a specific effect of non-compliance with provisions. Relying on Crown's Townsend Organization for the National Institute of Policy and Strategic Studies, he urged the court to hold that substantial non-compliance has been established by petitioners. Arguing per contra, learned senior counsel for the first respondent referred the court to Section 135(1) of the Electoral Act 2022 and submitted that the petitioner complained of non-utilization of prescribed forms, even though not proved, cannot without showing the effect on the election be a basis to avoid an election. He submitted that the attempt by the petitioners to exclude Section 73, subsection 2 of the Act from the ambit of Section 135, Section 1 is a non-starter because the non-compliance referred to in Section 135(1) is for the provisions of the Act, and no part of the Act was excluded by the section. He posited that for non-compliance with Section 73 of the Act to avoid an election, it must have substantial effect on the election, and the petitioners have neither proved such non-compliance nor shown that it has substantially affected the result of the potential presidential election, as the court to so hold. Petitioners had contended that since they are alleging that the first respondent failed to record in the prescribed form the quantity and particulars of the materials used in the election, they are alleging the negative, and as such, the burden is on the first respondent to establish that they have duly complied with the provisions of Section 73 sub 2 of the Electoral Act. They have relied on the decision of First Bank of Nigeria versus Adjacent Business Investment Limited, Royal United Nigeria for Sterling Bank. While it is true that the burden of proof is generally on the party that asserts the affirmative for an issue and not on the party who asserts the negative, there is an exception to that general principle. Where a negative assertion forms an essential part of the party's case, the burden is on him to establish that fact. This position was clearly stated by the Supreme Court in the case of Buhari and Ani, where Toby JSC stated held thus, quote, a negative allegation must not be confounded with the mere traverse of an affirmative one. The true meaning of the rule is that where a given allegation, whether affirmative or negative, forms an essential part of a party's case, the proof of such allegation raised on him, loss of court. Again, this court in Dashi and others versus Druven and others espoused this legal position when Ugo JCA held as follows. Quote, I am in no doubt that this argument of appellants about negative and positive assertion is misconceived. For while it is true that the burden of proof is generally on the person who substantially affirms the positive of an issue and not on the person who makes a negative assertion, there is a caveat to that principle to the effect that where a negative assertion forms an essential part of a plaintiff's case, as it evidently is the case of the appellant, the burden of proof of such allegation rests on him. The law on this point was lucidly stated by Bowen LJ. Abrath was a Northeast Railway Company, 11 Queens Bend Division 440 at 457, when he said that, quote, in an action for malicious prosecution, a plaintiff has the burden throughout of establishing that the circumstances of the prosecution were such that the judge can see no reasonable and probable cause for instituting it. In one sense that it is the assertion of a negative, and we have been praised with the proposition that when a negative is made out, the onus of proof shifts. That is not so. If the assertion of a negative is an essential part of a plaintiff's case, the proof of the assertion still rests on the plaintiff. The terms negative and affirmative are, after all, relative and not absolute, loss of court. In the instant case, the petitioners have made their allegation of non-compliance with Section 73(2) of the Electoral Act 2022 by the first respondent as an essential part of their case in challenging the results of the election declared by the first respondent. Not only are the petitioners statutorily required by Section 135, subsection 1 of the Electoral Act to establish substantial non-compliance with the provisions of the Act, they are required to show how such non-compliance has substantially affected the result of the election. As rightly observed by the learned senior counsel for the first respondent, the non-compliance that will not invalidate an election under Section 135(1) unless it is shown to be substantial and to have substantially affected the result of the election encompasses non-compliance with all provisions of the Electoral Act, including Section 73, subsection 2 thereof. In other words, Section 73, sub 2 is not derogated from the ambit of Section 135, section 1 of the Act. Indeed, in Buhari and Anip, Toby Joyce, while considering Section 145(1) of the old Electoral Act, similar to Section 135(1) of the Eastern Electoral Act 2022, had held at page 48, paragraphs B to D that, quote, a petitioner who files a petition under Section 145(1) of the Electoral Act has the burden to prove the ground or grounds. This is because he is the party alleging the grounds and he has a duty to prove the affirmative. He is the party who will lose if no evidence is given on the grounds. If the party does not prove his case under Section 145(1) of the Act, the action fails. Therefore, the petitioners who have alleged non-compliance with the Section 73, subsection 1 up to, as part of their course of action, have the burden to establish that non-compliance in accordance with the requirements of Section 135(1) of the Act. The petitioners have also relied on the evidence of PW12 and on exhibits PCQ1 to PCQ6, also tendered through PW12. The exhibits are acknowledged copies of letters dated 6 March 2023, 14 March 2023, 15 March 2023, and 20th March 2023, all written by the petitioners or their solicitors to the chairman of the first respondent, demanding for inspection of documents and for certified true copies of the electoral forms. The petitioners also relied on subpoena duces tecum served on the first respondent to produce the said form. In his testimony at paragraphs 58 to 60, of his adopted written statement on oath, PW 12 merely stated that the petitioners made several applications through his campaign organization and solicitors for certified copies of election documents and data relating to the presidential election, but they were denied by the first respondent, and that the first respondent had failed to record in the prescribed forms the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials. The record of proceedings of this court also shows that at the instant of the petitioners, subpoenas dated 30th May 2023 and 13th June 2023 were issued on the chairman of the first respondent to produce some documents. The record also shows that on the 20th June 2023, one Olufunmilayo Taiwo, the Deputy Director of Certification on Complaints and Legal Drafting with ANIC, appeared on behalf of the first respondent in answer to the subpoena Duchess Tekum. While she produced some of the documents required of the first respondent in the subpoenas, she informed the court that the documents listed in the subpoenas as listed E, C, D, and E are in the states. And since the subpoena was served on them just before the previous day, it will take some time for the first respondent to get them. An examination of exhibits PCQ to PCQ6, which were tendered by the petitioners through PW12, showed that all except exhibit PCQ are letters addressed to the chairman or the first respondent by the petitioners and their solicitors requesting for inspection of documents and for certified copies of those documents. Exhibit PCQ4 is a cover letter addressed to the resident electoral commissioner, Benue State, from the law firm of Dr. Onyechi Piazzo, SAN and Co., notifying the respondent, the resident electoral commissioner, of subsequent action on the solicited letter by the national chairman, ANIC headquarters, Abuja, dated 6 March 2023. It is instructive to observe that Section 74(1) of the Electoral Act 2023 mandates the resident electoral commissioner in a state where an election is conducted within 14 days after an application is made to him by any of the parties to an election petition, cause a certified true copy of such document to be issued to the said party. Subsection 2 of that section even provides that any resident electoral commissioner who fails to comply with subsection 1 commits an offense and is liable on conviction to a maximum of 2 million naira or imprisonment for a term of 12 months or both. A look at the letters exhibits PCQ1 to PCQ6 showed that they were all addressed to the chairman of ANIC instead of the resident electoral commissioners in the states, as required by the petitioners by section 74, subsection 1 of the Electoral Act 2023. It is therefore clear that the petitioners have failed to follow the clear legal procedures of requesting for those documents. More so, when the record shows that the subpoenas, which they claim to have served upon the first respondent, were also served on the chairman of the first respondent, and as stated by the officer who answered the subpoena, same was served only the previous day for her appearance in court. From his evidence, PW12 had stated that apart from voting at his polling unit 04 at Dawaki, Abuja, the only role he played in the 25th February 2023 general election, presidential election, was that he was a member of the second petitioner's special room. And on cross-examination by the respondent, he stated that he was neither a polling agent nor a collation agent. His evidence that the first respondent had failed to record in prescribed forms the quantity, serial numbers, and other details of the electoral materials can only be hearsay evidence, which has no probative value. Also, the mere production of exhibits PCQ1 to PCQ6 cannot establish an allegation of non-compliance with section 73(2) of the Electoral Act. The Electoral Act 2022. Apart from the evidence of PW12 and exhibits PCQ1 to PCQ6 tendered through him, the petitioners have produced no other evidence to substantiate their allegation that the first respondent failed to comply with the provisions of Section 73, Subsection 2 of the Electoral Act 2022. Rather, PW team, Efas Ia, the supervisory presiding officer for Madagali Ward in Adamawa State, who was subpoenaed by the petitioner to testify on their behalf, has stated in paragraphs 4 and 5 of his witness statement on oath that as a presiding officer, he reported to the local government area INEC offices in Gulam, Madagali local government area in Adamawa State, on the 24th February 2023 to collect the sensitive and non-sensitive materials for the 25th February presidential election and National Assembly elections, and that after collecting the materials, he proceeded together with security agents and other INEC officials, which consisted of presiding officers, assistant presiding officers 1, assistant presiding officer 2, and assistant presiding officer 3 to Madagali Ward that evening to the registration area. This evidence was also to the effect that on the day of the elections, everything went well, and after sorting and counting the votes, the presiding officer did the entry and snapped the results with beavers for the upload and transmission of the results to the INEC portal, but were unable to upload. And when they complained to him, he requested them to come to the registration area. It is therefore clear from the above that the petitioners were unable to establish the allegation of non-compliance by INEC with Section 73(2) of the Electoral Act 2023. The evidence PW2 and exhibits PCQ1 to PCQ6 have not been able to rebut the presumption of regularity, which inures to the first respondent under the law, which can only be rebutted with cogent and credible evidence, PAPC and Sheriff, and others. From the totality of the evidence adduced on this issue, I am of the considered view that petitioners have failed to prove substantial non-compliance with the provisions of the Electoral Act 2022. 2 is therefore resolved against the petitioners and in favor of the respondent. Issue 3 is whether from the totality of the evidence, the petitioners have proved that the presidential election held on 25th February was invalid by reason of corrupt practices. Here again, we have considered the submissions of counsel. So in their petition, the petitioner made allegations of suppression of scores, unlawful reduction and inflation of results, uploading of fictitious results, misrepresentation and manipulation of results where no election took place, overvoting and wrong computation of results. These allegations are contained in paragraph 60, 78 for the petition. In paragraph 60, 61, 62, 64, 65, 68, and 69 of the petition, the petitioners allege that due to the first respondent's refusal and neglect to upload and transmit the result of the election to the IRF on the day of the election, the first respondent suppressed the actual scores obtained by the petitioners. According to them, the suppression of the first respondent scores, which occurred in 18,088 polling units, was orchestrated by the first respondent, deliberately uploading readable and blurred forms EC8S on the IRF, and thereby suppressed the lawful scores obtained by the petitioners in the said polling units. They further alleged that in Rivers State, during the collation exercise, the first respondent announced scores of the petitioners as 175,071 votes, and the second and third respondents as having 231,591 votes, when in actual fact, the petitioners' lawful votes are 205,110, while that of the second and third respondents ought to be 84,108. They similarly allege that in Benue State, the first respondent suppressed the lawful votes obtained by the petitioners when it announced their votes as 308,372, and that of the second and fourth respondents as 310,408, when the actual votes of the petitioners were 329,000 and that of the second and third respondents at 300,421. The petitioner also alleged that the first respondent was purporting to upload the result of the presidential election on the IREF, embarked on massive misrepresentation and manipulation by uploading fictitious results in polling units where there were no elections, as well as uploading incorrect results. They stated that if the results of polling units, votes, local government states are properly tabulated and calculated as required by the Electoral Act and the regulation and guidelines for the election, the overall results of the election and the percentages scored by the political parties will show that the petitioners won the presidential election of 25th February 2023. He stated that the petitioner should rely on a report of inspection of the electoral materials. In the earlier ruling of this court on the preliminary objections raised by the respondents on the propriety of the environments contained in the petition, we held that apart from the allegations of inflation and reduction of votes in Rivers and Benue states, where the petitioners have stated the figures alleged to be inflated and reduced, the other allegations of the petitioners were nebulous and bereft of material particulars. We held that the said environments contain no particulars of the polling units where the alleged infractions took place or the figures alleged to have been inflated or reduced. We had struck out those paragraphs for offending paragraph 41D2 of the first schedule to the Electoral Act 2022. Indeed, apart from the strict requirement of stating material particulars in election petitions, it is also tried that in civil litigation, including election petitions, whenever fraud or any other crime is alleged, material facts of such allegation of fraud or other crime must be pleaded and clearly set out. The Omoborio and others was adjusting, Yeso Limited and Honey Legion, Lorin and others versus Tangolana, others. The petition allegations of suppression of votes, inflation and reduction of votes, massive misrepresentation and manipulation by uploading fictitious results all amount to falsification of those of an election. This versus Ukur. The Supreme Court held that allegations of inflation with non-existing votes is another way of alleging falsification of results. Indeed, in Haruna and Modibo, the Supreme Court held that where a petition is based on allegation of incidents of fraudulent acts, manipulation of results, or falsification of results, that allegation is criminal in nature, and evidence required in proof thereof must be clear and unambiguous. In other words, the proof must be beyond reasonable doubt. This section 135 sub 1 of the Evidence Act and cases of Buhari and Obasanjo, Emmanuel Umana, Ipiazu, Oti, Abubakar, and others for Yaradua, Omishore, Ali Bashola, Magaji, and All Progressive Congress. In order to establish falsification of election results, the petitioner must produce in evidence two sets of results, one genuine and the other false. In the cases of Kaki and PDP, Mobodo and Ono, Adewale and Olaifa. Also Chima Anoze versus Dr. Ken Obichere and others. And Joseph Olujimi Kolawole Abaje versus Babatunde Raju Fashola. The Okichuku and another versus Onyebu. To prove their petition, the petitioner also, who indicated during pre-hearing, they will call 50 witnesses, call only 13 witnesses. They are mentioned here. Of the above 13 witnesses, only 3 had their witness statements on oath filed along with the petition. These are PW1, PW2, and PW12. In our ruling on the respondent's objection to the competence of the petition witnesses at the beginning of this judgment, we had struck out the evidence of PW3, 4, 5, 6, 7, 8, 9, 10, 11, and 13 on the ground that their witness statements on oath were not filed along with the petition as mandatorily required by paragraph 45D of the first schedule to the Electoral Act. However, even if the statements of those witnesses of the petition were to be considered, the question is, are those testimonies cogent and credible to establish the petitioner's allegations stated above? PW1's testimony was only on the alleged double nomination of the third respondent and Pecho proceeding, which we have already determined above. Even as he stated that he voted in his polling unit during the election, he stated that he did not play any other role in the election beyond exercising his civic responsibility. As for PW2, who said he was a software engineer, he stated that upon his reading of the relevant provisions of the Electoral Act and annual regulations, he is aware that the presiding officer in the polling unit is mandated to electronically transmit or transfer the result of the election direct to the to the collation system as prescribed by ANIC, and to also use the beavers to upload a scanned copy of the polling unit result sheet to the ANIC result viewing portal area prescribed by ANIC. He said, from his knowledge of software engineering and computer operations, RF is a server and is accessible to the public. He said he was aware that the information or data generated or inputted in the beavers were operating online or offline, were transmitted to the ANIC servers, including virtual servers hosted on AWS cloud. On cross-examination with his respondent, however, the witness admitted that his opinion was based purely on his reading of the Electoral Act and ANIC guidelines, and that he was not familiar with the applications and operations of the beavers machine. He stated that he did not play any role in the election. Indeed, as admitted by the witness, the statement, particularly paragraph 10 to 13, is a virtual reproduction of Section 38 of the Electoral Act 2022. On cross-examination by the fourth respondent, he admitted that he did not state his educational or professional qualification or experience in his statement on oath. He also stated that his investigation was based on publicly available application program interface, API, and collected information through it, like from EC8S. He said he did not have the documents and forms he used, and that everything was in laptop. Contrary to the speculation of the petitioners that ANIC was not prepared to conduct the promised credible, authentic, and transmitted election, or that it deliberately or mischievously allowed the compromised IT infrastructure to be deployed for the conduct of the presidential election, PW2 confirmed that Amazon Web Services is the most secure service providers in the world, and that it is used by corporations, companies, individuals, and governments that are most concerned with security. In his entire evidence, PW2 did not talk about the contents of any result. Instead of supporting the petitioner's allegations, the evidence of this witness supports the case of the first respondent. As for PW3, PW5, and PW6, he merely tendered flash drives containing speeches of the ANIC chairman, Mahmoud Yakubu, and ANIC National Commissioner, Festus Okoye, wherein they gave assurances that results of the election will be transmitted to the RF for public viewing. Being mere assurances, the evidence of these witnesses had no utilitarian value in establishing allegation of corrupt practices made by the petitioners in this case. In his evidence, PW4 tendered exhibits PCD 1, 2, and 3, which he claimed to be the report of his analysis of the presidential election. The witness also tendered 4 boxes containing what he called 18,088 blood polling unit results downloaded from the RF portal, which were also admitted as exhibits PCE1 to PCE4. However, in the earlier ruling of this court on the respondent objection, we have struck out exhibits PCD 1, 2, 3, as well as exhibits PCE 1 to 4, along with the witness statement on oath of PW4, which was not filed along with the petition since the documents were tendered through the incompetent witness. The witness claimed in his evidence that from his investigations, the scores on forms EC8S of 39,556 polling units were inaccessible as they contain uploads not connected with presidential election, and that the number of accredited voters affected by the 18,088 blood result was 2,565,269, while the number of voters who collected their PVCs was 9,165,191. According to him, this signified that the votes of 5,533,553 accredited voters were discountenanced by the first respondent. He added that 23,119,298 registered voters collected their PVCs in those 39,546 polling units, and concluded that both the number of accredited voters of 5,553,553 and number of voters who collected their PVCs of 23 million plus polling units far exceeded the margin of lead from the first respondents' announced result of 1,807,206 over the first runner-up and 2,693,193 over the second runner-up. PW4 also stated that in Benue State, neither the results he obtained from the RF nor the CTCs of Forms EC8As matched the results of the first respondent. He stated that the annex CTCs of Forms EC8As showed that LP got 272,468 votes and APC got 256,852 votes, while the results from the RF portal showed that LP got 260,796 votes, while APC got 268,630 votes. He added that the annex announced result showed that LP got 308,372 votes and APC got 310,468 votes. He concluded that by adding uncovered votes and deducting votes affected by overvoting, manipulation, alteration in Benue State, LP got 281,426 votes, while APC got 258,683 votes. A look at the 18,088 blood polling units results, which the witness claimed to have downloaded from the RF portal, show that they were not certified by the first respondent. Being secondary evidence of public documents, they are clearly inadmissible. See Section 89E and 90B of the Evidence Act 2011, case of Emeka versus Ipiazu, others. Of note is that PW4 admitted under cross-examination by first respondent that the primary source of the data he used in his investigation is from the RF portal. This clearly means that he based his investigation on inauthentic data, since the essence of certification of public document is to ensure authenticity of public documents. See the cases of Ebwe and Araka and Emmanuel Basmana. Also under cross-examination, PW4 stated that his reference to Form EC8A and the result on RF portal are not the same thing, and that Form EC8A is a paper, while the result on RF is a copy of it. He particularly admitted that by his reference to blood Form EC8As on the RF, he was not suggesting that the hard copies of Form EC8As are also blood. This admission by PW4 also dealt a death knell to the allegation made by the petitioners in paragraph 60 of the petition that the first respondent suppressed the first respondent's cause to 18,088 polling units by deliberately uploading unreadable and blood forms EC8As on the RF. In fact, PW4 had under cross-examination completely rubbished his own report when he admitted that the RF portal is not capable of collecting and tabulating the election results, and that it is the image of the Form EC8A that is transmitted to RF, while the hard copy of Form EC8A is taken to the collection center, which he stated is collected at what local government, state, and national collection centers. He also admitted that since the result in the Form EC8A is taken to the collection centers, a failure to transmit its image in RF or that image transmitted its blood will not change the result already entered in Form EC8A. Again, the witness admitted under cross-examination that his report in exhibits PCD1, PC2, and PCD3 only covered the two states of Rivers and Benue, and that he worked on only available data, that if he had more data in his report, it would have been different. He further admitted that his report, exhibits PCD1, 2, and 3, is not a product of expertise, as any secondary school student can do the simple arithmetic involved in it. These admissions by PW4 effectively rubbishes his entire report as inconclusive and manifestly unreliable. In the whole, the evidence of this witness, even if it were to be considered void of any probative value. As for the evidence of PW7, we had earlier analyzed and evaluated her testimony and found that she was not only a person interested in this petition. The report in Exhibit PCJ 3A-F, which she brought to the court purportedly as an expert witness, was merely downloaded by her from AWS site, which was openly accessible to the public. Her evidence is also of no probative value. With regard to the evidence of PW8, I have earlier analyzed and evaluated his evidence while resolving issue 2. Suffice it for me to state that I had found that PW8, having admitted that in the course of his commission to work, he had read the petition and the first respondent's reply, as well as the Electoral Act and annual regulations and manual, and that he finished his final report in May 2022 during the hearing of his petition. PW8 had practically worked to a predetermined answer, and his evidence was of no probative value. PW9, who gave evidence as an accredited observer of the election, had stated that everything about the election in the polling unit, which he observed when as accreditation and voting took place, the votes were counted and the results were announced and recorded on Form EC8A, but was not uploaded on the RF at the polling unit. Under cross-examination by the respondents, he stated that from his observation, the election went on smoothly in his polling unit and that the election officials complied with the ANEC regulations. He stated that the result was taken to the collation center by the election officials. Rather than support the petitioner's case, the evidence of this witness actually reinforced the response case that the election was conducted in substantial compliance with the Electoral Act and ANEC regulations guidelines. PW10 stated that he acted as an ad hoc supervisory presiding officer for Madagali Ward, and that on election day he collected the materials with security agents and other ANEC ad hoc presiding officers. He stated that voting went on well until 6:30 p.m. and all voters who were on queue by 2 p.m. duly voted at Unit 004 DISA. He stated that after sorting and counting of the votes, the presiding officers did the entry and snapped the results with the beavers, but were unable to transmit and upload same to the RF portal after the result of the National Assembly election was uploaded. He stated that when the presiding officers complained to him, he asked them to come to the registration area, where he requested them to meet the registration area center tech, who asked them to submit the beavers to him for transmission, but was unable to upload. On cross-examination by the First Respondent Council, PW8 stated that apart from the small issue between agents of APC and PDP, which was satisfactorily resolved, everything went well and the results were entered in Form EC8S in the units and were properly announced. And added that the physical copies of the Form EC8S were taken to the Ward Collation Center. Cross-examination by second and third respondents, the witnesses have confirmed that notwithstanding the difficulty in uploading the results, the collation of Forms EC8A took place in the ward. The evidence of this witness also supports the case of the respondents rather than of the petitioners. PW11, head of the Legal Services National Information Technology Development Center, NIDA, merely stated that he was subpoenaed, produced, and tendered the following documents. A, correspondence of documents, letters, emails sent by him, sent by or from Independent National Electoral Commission, the National Information Technology Development Agency, requesting for the IT clearance approval of the IT infrastructure to be deployed and or deployed by ANEC for the conduct of 2023 general election. B, the certificate of clearance approval issued by NIDA to ANEC pursuant to any request in A above. C, the report submitted by ANEC to NIDA containing certification for the testing review of the IT infrastructure deployed for the conduct of the 2023 general election. It stated that they don't have any of the documents in their office. under cross-examination by the second and third respondents, he stated that the NIDA Act does not contain cybersecurity standards. He also stated under cross-examination by the fourth respondent that their supervisory ministry is Ministry of Communication and Digital Economy, and that the minister stated that there were 16 million attempts to hack the INEC IT infrastructure on the day of the election. The evidence of this witness is of no assistance to the petitioners. PW12, the petitioner's star witness, whose evidence was merely a copy of the averments in the petition, stated that on the day of the election, he voted at his polling unit at Dawaki, Abuja, after which he went to the situation room of his party. Second petitioner, he stated that apart from his polling unit and the situation room, he was not present physically at any other place on the day of the election. He stated that he was not a collation agent or polling agent in any polling unit or collation center. His evidence in chief was therefore mostly laced with hearsay, settled that hearsay evidence is inadmissible and has no probative value. Apart from his evidence in chief being inadmissible hearsay, Exhibit X1, a certified true copy of the judgment of Federal Court Abuja, suit number FHC ABGCS 1454-2022, was tendered through him under cross-examination by the first respondent, and he read out a portion of the judgment of the court, which was to the effect that the first respondent was under no mandatory obligation to electronically transmit or collect results of the election. He also admitted that he did not state in his statement on oath any figure unlawfully ascribed to the second respondent and third respondent by the first respondent. He also stated that his party had agents throughout the federation with over 133,000 votes. When asked by the second and third respondents' council to state the score of the of the Labour Party, the witness stated that he will not know scores of the Labour Party because the results are being uploaded on the IREF. He added that he will not know the unlawful votes accredited because he is not an expert, and that the wasted votes are part of the statement made by the expert. When cross-examined by the fourth respondent, PW12 said he was not aware that INEC chairman had given a statement that INEC will not transmit results electronically. When confronted by the fourth respondent's counsel, he confirmed that his statement on oath wherein he stated that he will rely on the evidence of forensic experts was made on 20th March 2023, while the final expert report he was relying on was made in May 2023. Clear that PW12 relied on an expert report that was not in existence at the time he made his statement. Obvious that the evidence of this witness lacks credibility and is therefore manifestly unreliable. PW13 was the only presiding officer called by the petitioners in this petition. His evidence was that in his polling unit 035 at Open Field Ward 04, Ikun local government area in Kaduna State, the election went well, and that thereafter all efforts to upload the presidential election results as captured in Form PC8A failed except the National Assembly results. That when all efforts failed, he proceeded to the collation center with other ad hoc staff. When cross-examined by first respondents' counsel, he stated that he recorded the results manually, and the only problem he had that day was the uploading of the result. That when he could not upload the result, he called his supervising officer, who told him to take the result to the ward collation center, which he did. On cross-examination by second and third respondent counsel, he confirmed that after recording the result manually, he signed and the party agents also signed. When cross-examined by the fourth respondent, he stated that after signing the result, he gave copies to party agents. The evidence of this witness actually supports the case of the respondents that the election was conducted in substantial compliance with the Electoral Act 2022. In Buhari and INEC and others, the Supreme Court clearly stated law as follows. Quote, a petitioner who contests the legality or lawfulness of votes cast in an election and the subsequent result must tender in evidence all the necessary documents by way of forms and other documents used at the election. He should not stop there. He must call witnesses to testify to the legality or unlawfulness of the votes cast and prove that the illegality or unlawfulness substantially affected the result of the election. The documents are amongst those in which the results of the votes are recorded. The witnesses are those who saw it all on the day of the election, not those who picked the evidence from an eyewitness. No, they must be eyewitnesses too. Both forms and witnesses are vital for contesting the legality or lawfulness of the votes cast and the subsequent result of the election. One cannot be a substitute for the other. It is not enough for the petitioner to tender only the documents. It is incumbent on him to lead evidence in respect of the wrongdoings or irregularities both in the conduct of the election and the recording of the votes. Wrongdoings and irregularities which affected substantial result of the election. Proving an election petition or proof an election petition is not as easy as the Englishman finding coffee on his breakfast table and sipping it with pleasure, particularly in the light of Section 146(1) of the Electoral Act. The petitioner has a difficult, though not impossible task, close of court. See Mohammed and another versus Anladi and others. In this petition, where the petitioners have labeled several allegations against the first respondent, such as suppression of votes, lawful reduction, and inflation of results, uploading of fictitious results, misrepresentation, manipulation of results, where no election took place, and wrong computation of results, it is evident from the above that the petitioners have not laid any credible evidence to substantiate those allegations. Of the 13 witnesses recalled, only 2 are presiding officers who were present at the polling, who are present at their polling units. Hence, the petitioners have not been able to establish any of those malpractices which they allege. The evidence of the witnesses which the petitioners call as experts to try to establish that the first respondent is mandatorily required to transmit election results for the purpose of collation or to link the delay in the upload of the presidential election results to average by the first respondent. Any of the malpractices which they allege are devoid of any value. The petition allegations have remained mere speculations and unfounded accusations. The petitioners have failed to establish beyond reasonable doubt the corrupt practices which they allege as required of them under Section 135(1) of the Evidence Act 2011. On the petitioner's allegation of overvoting, Learned Counsel for the first respondent contended that to prove overvoting, the direct record of accredited voters in the Beavers machine are required alongside the voters register of the affected polling units. He pointed out that the petitioners failed to produce the Beavers machines and the voters register. He submitted that the petitioners want this court to rely only on the expert opinion of PW4, which is not credible. He submitted that when PW4 was confronted with the results in polling unit 002 of Ward 7 of Degema, LGA, River State, which was part of his report on overvoting. In exhibit PCD2, he stated that there was no overvoting, as the number of votes cast was 40, while the number of accredited voters was also 40. He relied on Oetella and INEC at this court to discountenance PW4's evidence of voting. The petitioner's allegation of overvoting is contained in paragraph 72, 76, and 77 of the petition, which have been produced here. In the earlier ruling of this court, the respondents' various perennial objections to the competence of the above affirmed petitioners' allegation of overvoting were upheld, and the court had struck out the said paragraphs for being vague, nebulous, and imprecise, having failed to disclose the specific polling units in the state where the overvoting is alleged to have occurred, the number of votes affected, the alleged margin of lead, etc. Indeed, in that ruling, we had observed that the forensic report containing the details of the polling units and other information which the petition said they have incorporated to the pleading by reference were not filed along with the petition as to be part of the pleadings. Proof of their above allegation of voting, however, the petitioners solely relied on the evidence of PW4, the subpoenaed expert witness, as well as the forensic report made by him, which is contained in Exhibit PCD 1, 2, and 3. Exhibit PW4's evidence was basically that from his investigation in Exhibit PCD 1, 2, and 3, he discovered that there was overvoting in 4,407 some polling units, which affected 2,317,129 voters who had collected their PVCs. He stated that this also exceeds the margin of lead over of 1,807 million to 1,807,206 over the first runner-up. He also stated that from his analysis of River State results, the first respondent announced results which were inconsistent with those uploaded on the RF portal. PW4 also stated that from the Forms EC8As downloaded from the RF portal, there is evidence of manipulations and alterations in favor of APC and against the Labour Party LP. He stated that from the results on the RF portal, LP got 208,564 votes, while APC got 118,999 votes in River State, as against 175,071 votes for LP and 231,591 votes for APC. Concluded that when the unlawful votes are deducted, it will amount to 205,110 votes for LP and 84,108 votes for APC. In the ruling on objections to witnesses and documents made in the earlier part of this judgment, the witnesses stated on oath, the witness statement on oath of PW4 was one of those struck out for offending paragraph 45B of the first schedule to electoral 2022, them not having been filed along with the petition. With the statement of PW4 struck out for being incompetent, exhibits PCD 1, 2, and 3, the forensic report tendered by him were also struck out for being inadmissible. As stated earlier, the oral evidence of PW4 contained in his witness statement on oath and his report in exhibit PCD 1, 2, and 3 are the only evidence adduced by the petitioners to establish the allegation of overvoting. With the witness statement on oath of PW4 having been struck out for being incompetent, and the forensic report in exhibits PCD 2, 1, 2, and 3 also struck out for being inadmissible, there was no other evidence to substantiate the petitioner's allegation of overvoting. The petitioners have therefore failed to prove their allegation of overvoting. Issue 3 is also resolved against the petitioners. So based on the Based on all the foregoing, it is evident that the petitioners have failed to establish their allegations of corrupt practices and overvoting. In consequence, issue 3 is also resolved against the petitioners and in favor of the respondents. Issue 4 is whether from the evidence adduced by the petitioners, the petitioners have established that the second respondent was not duly elected by a majority of lawful votes cast at the election. This issue deals with section 134, subsection 2 of the Constitution, the issue of 25% votes, Abuja. Whatever it is. Well, the resolution of this issue basically borders on the interpretation of section 134, subsection 2B of the 1999 Constitution. The appropriate starting point for the resolution of this issue, therefore, is to reproduce, for ease of reference, section 134(2)A and B of the Constitution of the Federal Republic of Nigeria, 1999, as amended, the interpretation of which is in contention. It reads thus. A candidate for an election to the office of president shall be deemed to have been duly elected, where there being more than 2 candidates for the election. A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states in the Federation and the Federal Capital Territory. The contention is as to the interpretation to be accorded to paragraph B of subsection 2 of section 134 quoted above. In particular, the contention is whether or not by the wordings in that paragraph, a candidate must, in addition to scoring not less than 1/4 of the votes cast in at least 2/3 of the states in the Federation, also score 1/4 of the votes cast in the Federal Capital Territory, Abuja, before he can be deemed to have been duly elected. In other words, whether in determining 2/3 of the states of the Federation in the Federal Capital is to be included and regarded as one of the states of the Federation, or his status is to be regarded as distinct from the other states of the Federation, such that scoring 1/4 of votes in the FCC is a mandatory requirement for a candidate to be deemed duly elected as president. It is pertinent to state that unlike interpretation of statutes, the interpretation of the Constitution has its own guiding principle. We'll look at the principles as stated in Federal Republic of Nigeria versus Ganjua, reported in the electronic law report, where the Supreme Court succinctly reviewed cited cases on interpretation of the Constitution and outlined these principles, guiding principles as follows. A, in interpreting the Constitution, which is the supreme law of the land, mere technical rules of interpretation of statutes will be avoided so as not to defeat the principles of government enshrined therein. Hence, a broader interpretation should be preferred unless there is something in the text or in the rest of the Constitution to indicate that a narrower interpretation will best carry out the objects and purpose of the Constitution. B, all sections of the Constitution are to be construed together and not in isolation. C, where the words are clear and unambiguous, a literal interpretation will be applied, thus according to words, their plain and grammatical meaning. D, where there is ambiguity in any section, a holistic interpretation would be resorted to in order to arrive at the intention of its framers. E, since the draft person is not known to be extravagant with words or provisions, every section should be construed in such a manner as not to render other sections redundant or superfluous. F, if the words are ambiguous, the lawmaker's intention must start first in the Constitution itself, then in the other legislation and contemporary circumstances by resort to the mischief rule. D, the proper approach to the construction of the Constitution should be one of liberalism, and it is improper to construe any of the provisions of the Constitution as to defeat the obvious ends which the Constitution was envisaged to achieve. See the case of Nafiu Rabiu and the state, Bendel State was Attorney General Federation, Buhari, Obasanjo, Savannah Bang, Ajilo, Abia State was AG Federation. In finding appropriate answer to this issue, are we to observe first that, with all due respect to counsel to the petitioners, their interpretation of Section 134, subsection 2B of the Constitution, founded principally on a fixation that the word "and" appearing between the phrases, it has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states of the Federation. The Federal Capital Territory Abuja is completely fallacious, if not outrightly ludicrous. Even their recourse to the case of Abubakar and Yaradua does not help their argument because Toby JSC made it clear that a purposive rule of interpretation will not be appropriate where the intention of the lawmaker is clear, precise, and unequivocal. So much so that a person can say, yes, this is what the lawmaker has in mind. Thus, in the interpretation of the Constitution, the principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the purpose and scope of its provision. Global Excellence Communication Limited, Donald Duke, AG Bendel State AG Federation, Saraki versus FRN, Sky Bank PLC, Yugu, Kelim versus Guabank. That this is the position is not at all open to doubt. In Bronic Motors Limited versus Wema Bank Limited, Nnamani JC or Blessed Memory, speaking from the Upper Court, confirmed it when, after a painstaking analysis of the cases on the point, said at pages 30 to 32 that, quote, a constitution is a living document, not just a statute, providing a framework for the governance of a country, not only for now, but for generations yet unborn. In construing it, undue regard must not be paid to merely technical rules. Otherwise, the objects of its provisions, as well as the intention of the framers of the Constitution, will be frustrated. As stated in Minister of Home Affairs versus Fisher, the constitutional requirement should not necessarily be construed in a manner according to rules which apply to acts of parliament. Although the manner of interpretation of constitutional instrument should give effect to the language used, recognition should also be given to the character and origins of the instrument. Such an instrument should be treated as sui generis, calling for principle of interpretation of its own, suitable to its character, without necessary acceptance of all the presumptions that are relevant to legislation or private law. It has also been accepted by all our courts that a broad and liberal interpretation should prevail in interpreting the provisions of our Constitution, although one has constantly to bear in mind the object which such provisions were intended to serve. Udo Udoma, JSC, very aptly stated this in National Review and the State, where the learned justice said, my lords, it is my view that the approach of this court to the construction of the Constitution should be, and so it has been, one of liberalism, probably a variation of the theme of the general maxim, ut res magis valeat cum periat. I do not conceive it to be the duty of this court to construe any of the provisions of the Constitution as to defeat the obvious ends the Constitution was designed to serve, where another construction, equally in accordance with the words and sense of such provisions, will serve to enforce, to protect such a clause of court. Some years down the line, in Global Excellence Communications Limited versus Donald Duke, Onogian JSC, later CJN, reiterated the relevant principle of the implementation of the Constitution, which his lordship saying, among others, at page 19. Followed. The principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the scope and purpose of its provisions. The words of the Constitution are therefore not to be read with stultifying narrowness. Clause of court. All these were further followed by this court recently. The Federal Republic of Nigeria versus Muhammadu Maigari Dingyadi in the following ways at the 33 of the court. One main guiding post is that the principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the purpose and scope of its provisions. See Global Excellence Communication, other cases. There is always a need for the fulfillment of the object and true intent of the Constitution. Therefore, the Constitution must always be construed in such a way that it protects what it sets out to protect and guide what it's meant to guide. The Adeleke or your State House of Assembly. In interpreting the Constitution of a nation, it is the duty of the court to ensure the words of the Constitution preserve the intent of the Constitution. Every Constitution has a life and moving spirit within it, and it is this spirit that forms the raison d'etre of the Constitution, without which the Constitution will be a dead piece of document. The life and moving spirit of the Constitution of this country is captured in the preamble. It has been held that when a constitutional provision is interpreted, the cardinal principle is to look to the preamble to the Constitution as guiding star, and the directive principles of state policy as the book of interpretation, and that while the preamble embodies the hopes and aspirations of the people, The direct principles set out the proximate grounds in the governance of the country, the Thakur and Union of India. In other words, in interpreting the words of Section 212(1)A of the 1999 Constitution as amended, the court should be guided by principles upon which the Constitution was established, rather than by direct operation or literal meaning of the words used in the provision. And where the literal meaning of the words used are not in consonance with the guiding principles, literal interpretation must be jettisoned to another approach that accords with the guiding principles of the Constitution. The interpretation that would serve the interests of the Constitution and best carries out its objects, purpose must always be part. Close of court. Following these well-settled principles, our first port of call in unlocking the argument of the petitioners is the preamble to the 1999 Constitution and the direct principles of state policy contained therein, all of which embody the principles of the Constitution. The preamble to the 1999 Constitution loudly proclaims equality between citizens as its cornerstone, among others. Thus, we, the people of the Federal Republic of Nigeria, having firmly and solemnly resolved and to provide a constitution for the purpose of promoting the good government and welfare of all persons in our country on the principles of freedom, equality, and justice, and for the purpose of consolidating the unity of our people. Do hereby make and give to ourselves the following constitution. For those who are not used to reading preambles, the Constitution, still in its fundamental objectives and directive principles of state policy, contained in Chapter 2 of the Constitution, which this court aptly described as the road to construction, the Federal Republic of Nigeria and Dingedi repeats this equality principle. Under its social objectives provision of that chapter in Section 17 thereof, it again proclaims that 1. The state social order is founded on ideals of freedom, equality, and justice. 2. In furtherance of the social order, every citizen shall have equality of rights, obligations, and opportunities before the law. Equality of rights in every citizen, as stated in this provision, cannot by any means be read to exclude equality of the weight and value of their votes. No, it includes it. Even more so, when the issue here is the right of every such citizen to elect with their votes their president, whose policies are supposed to and will affect all of them equally, regardless of which part of the country they reside or live. So even stopping here, the futility and hollowness in the argument of the petitioners that the votes of the voters in the FCT, Abuja, have more weight than other voters in the country, to the extent of their votes purportedly have a veto effect on other votes, is rendered bare. That notwithstanding, let us still proceed to consider for whatever it is worth their interpretation of Section 134, subsection 2B of the same 1999 Constitution, which incidentally centers around the word "and," that provision. In the first place, the settled position of the law is that in interpreting a constitutional provision of the court should be guided by the principles upon which the Constitution was established, rather than by the direct operation or literal meaning of the words used in the provision. And where the literal meaning of the words used are not in consonance with the guiding principles, literal interpretation must be jettisoned for another approach that accords with the guiding principles of the Constitution. It is quite clear that a calm reading of Section 134(2)B of the Constitution will leave no one in doubt that the use of the word "and" by the framework between the words all states in the Federation and the Federal Capital Territory Abuja indicates nothing more than that the framers understandable desire for consistency in referring to the Federal Capital Territory by that name, as it is done all through the Constitution whenever reference is made to the Federal Capital Territory. The words and Federal Capital Territory Abuja do not by any means imply the meaning imputed to it by the petitioners. In any event, Section 299 of the Constitution dispels any lingering doubt that may still be existing in anyone's mind by stating that the provisions of this constitution shall apply to the Federal Capital Territory, Abuja, as if it were one of the states of the Federation, then ABC. This provision states most unequivocally that the entire provisions of the Constitution shall apply to the Federal Capital Territory as if it were one of the states of the Federation. It is noteworthy that the punctuation mark employed by the framers immediately after the part of that provision ending with Federation, emphasized by me, is a semicolon, whose function is in a sentence is to separate independent clauses of a compound sentence. The Merriam-Webster's online dictionary, which defines semicolon as a punctuation mark used chiefly in a coordinating function between major sentence elements, such as independent clauses of a compound sentence. Wikipedia also explains its use thus. In the English language, a semicolon is most commonly used to link two independent clauses that are closely related in thought, such as when restating the preceding idea with a different expression. The point being made here is that, contrary to the position of the petitioners, by the express provisions of Section 299 above, the provisions of the entire Constitution shall apply to the Federal Capital Territory as if it were one of the states of the Federation. This means that Section 134, Section 2B of the same Constitution, requiring a president candidate to poll at least 1/4 of the votes cast in 2/3 of the states of the Federation in order to be returned elected, means nothing more than that the Federal Capital Territory shall be taken into account in calculating the state 2/3 of states of the Federation. In other words, the FCT is no more than one of the states of the Federation for the purpose of that calculation. Nothing more than that can be implied or inferable from Section 134, subsection 2B of the Constitution. If anything, this position is confirmed in the cases of Bakari and Ogundipe, where it was said by the Apex Court that by virtue of the provision of Section 299 of the Constitution, it is clear that the Federal Capital of Nigeria has the same status of a state. It is as if it is one of the states of the Federation. And in Ibori versus Uboru, where it was confirmed by this court that the Federal Capital Territory, Abuja, is to be treated like a state by virtue of Section 299 of the Constitution. If the Federal Capital Territory, Abuja, is to be treated like any other state, then it is not superior to or inferior to any other state in Nigeria. It is also my considered view that if the framers had wanted to make scoring 1/4 of votes cast in the Federal Capital Territory, Abuja, a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly separate the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. As expressly stated in Section 299 of the Constitution, for the purposes of fulfilling the requirements of Section 134, subsection 2B of the Constitution, for return of a presidential candidate as duly elected, the Federal Capital Territory, Abuja, is to be treated as one of states in the calculation of 2/3 of the states of Federation. Thus, that if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the Federation, FCT Abuja inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to score 25% of the votes cast in the Federal Capital Territory, Abuja, as the second respondent. In conclusion, I hold without any equivocation that in a presidential election, polling 1/4 or 25% of total votes cast in the Federal Capital Territory is not a separate precondition for a candidate to be deemed as duly elected under Section 134 of the Constitution. In consequence, issue 4 is also resolved against the petitioners and in favor of the respondents. It is right, Lord, that there is a rebuttable presumption of regularity with respect to election results, and it is for a petitioner who challenged that result to rebut that presumption with credible evidence. This settled principle was stated by the Supreme Court in Buhari and Anil, and Nyesom and Peter cite others. Also in Udom Gabriel Emmanuel versus Umana Okon Umana and others. All citations are right. I have also referred to Abubakar and Eradua Louis versus Anik, Kiriko, Duluma Hop versus Barrister Joseph Ella and others. From the foregoing, it is clearly evident that the petitioners have failed to discharge the burden of proof placed on them by law. They have failed to prove any of the three grounds contained in paragraph 20 of this petition. They have not been able to lead any cogent, credible, and acceptable evidence to rebut the legal presumption of correctness of the result of the presidential election held on 25th February 2023, declared by the first respondent. Having resolved all issues, in this petition against the petitioners, this petition is clearly unmeritorious. As I stated earlier, it's a consolidated petition. So when we examine that of petition number 4, our learned brothers state their own position. And number 5, sorry.
My Lord, sir, I'm very sorry again, sir.
Yes.
Even if your lordships are going to say, your brethren are going to say their piece later on, sir, at least you all, my Lord, well, you all should be arrested by saying it's either dismissed or is allowed. Huh? I was wondering if your lordship would not pronounce that it's been dismissed. So that.
What are you saying?
I'm sorry, but I don't want to be confused, sir. I've listened to your lordship's eloquent judgment.
Sorry, please, Leonard Senior. You don't have to interrupt judgment. We are delivering judgment and we are still on. Please leave the judgment where it is.
My Lord, I'm very sorry, sir.
If you are confused, when you get the judgment, you read it.
No, my Lord, I'm not confused at all.
Okay, then please.
I'm making a suggestion.
You don't have to suggest to us how to deliver judgment.
I'm sorry.
So you seriously think that all 5 of us wouldn't know that?
Lord,
wouldn't know what you want to do?
I apologize.
Better we proceed. Well, we now proceed on petition number 5. The motions in that petition will be read by my learned brothers, by my extreme rights.
This is an election petition by the 2 petitioners against the first, second, and third respondents. The first petitioner, Abubakar Atiku, was a candidate at the presidential election held in Nigeria on the 25th day of February 2023. He was sponsored by the second petitioner, People's Democratic Party. The first respondent, INEC, was established as one of the executive bodies created in Section 135 of the Constitution of the Federal Republic of Nigeria, 1999, with power to, among others, organize, undertake, and supervise all elections to the offices of the President and Vice President and others. On Saturday, the 25th of February 2023, the first respondent conducted election to the office of the President and the Vice President for the Federal Republic of Nigeria and the National Assembly simultaneously. Petitioners and the second, third respondents, along with 16 others, participated in the election. At the conclusion of the election, the first respondent declared the results by which it is indicated as follows. We show the results for out of the 2 contestants here we are concerned with. The APC of Tinubu Bola Ahmed, and Tinubu Bola Ahmed scored
were declared to have polled 8,794,726 votes, and Atiku and the PDP 6,984,520 votes. Petitioners were aggrieved by the outcome of the election, so they filed jointly this petition to challenge this election. The grounds of the petition were four, and these were stated as follows. One, that the election of second respondent is invalid by reason of non-compliance with the provisions of the Electoral Act 2022. The election of the second respondent is invalid by reason of corrupt practices. The second respondent was not duly elected by a majority of lawful votes. The second respondent was at the time of the election not qualified to contest the election. The petitioners are seeking the following relief: that it may be determined that second respondent was not duly elected by the majority of lawful votes cast in the election, and therefore the declaration and return of the second respondent as the winner of the presidential election of the 25th of February 2023 is unlawful, wrongful, unconstitutional, undue, null and void, and of no effect whatsoever. B, that it may be determined that the return of second respondent was by the first respondent was wrongful, unlawful, undue, null and void, having not satisfied the requirements of the Electoral Act and the Constitution of the Federal Republic of Nigeria, which mandatorily requires the second respondent to score not less than 1/4 or 25% of the lawful votes cast at the election in each of at least 2/3 of the states in the Federation, and they put the "and" in capital letters, and the Federal Capital Territory, Abuja. See, that it may be determined that the second respondent was at the time of the election not qualified to contest the said election. See, that it may be determined that the first petitioner having scored the majority of lawful votes cast at the presidential election of Saturday, 25th February, be returned as the winner of the said election and be sworn in as duly elected president of the Federal Republic of Nigeria. In the alternative, another directing the first respondent to conduct a second election runoff, in brackets, between the first petitioner and second respondent. In the further alternative, that the election to the office of the President of Nigeria held on 25th February be nullified and a fresh election rerun be ordered. G, any such further others as the Honorable Court may deem fit to make in the interest of justice. Upon being served the petition, the respondents joined issues with it by filing their respective replies, incorporating preliminary objections and made other applications. Some of the applications filed by the parties were heard and rulings delivered at the pre-hearing stage, while some were heard and rulings on them reserved till the time of the judgment of the court. We now proceed to consider them. 7 applications were filed and argued by the respondents during the pre-hearing session of this petition. 2 each of the said applications were filed by the first and second respondents, while 3 were filed by second respondent. First respondents' 2 applications were filed on the 19th of April this year and the 9th of May. The first of his 2 applications dated and filed on the 19th, which also largely reflect the position of second respondent in his first 2 applications and third respondent in his first application. First respondent sought an order striking out paragraphs 92. We gave the paragraphs of the petition on the grounds of their vagueness. Several paragraphs which you get there as you get your the judgment, for being generic, imprecise, and lacking in specificity to elicit a reply from it. B, an order striking out paragraphs 129 and 138 of the petition for failure to join necessary parties. Among other grounds, the 2 necessary parties are Yaya Bello and one Adevo, the chairman of a local government in Kogi State. 3, another striking out the ground of the petition that second respondent did not score majority of lawful votes as contained in paragraph 16C of the petition for incompetence and lacking in specificity and materials in the pleading for a sustenance. Consequent upon 1 to 3 above, another striking out paragraphs A and B and D are sought in paragraph 130 of 150 of the petition, and another striking out the ground of the petition that the election is invalid by reason of non-compliance. Consequent upon 5 above, another striking out the ground of the petition alleging that the election of the second respondent is invalid by reason of corrupt practices as contained in paragraph 16B of the petition for lacking specificity and material parts in the pleading for a sustenance. 7, another striking out the ground of the petition that the second respondent was at the time of the petition not qualified to contest the election as contained in paragraph 16A of the petition for lacking specificity. 8, another striking out the ground of the petition that the second respondent was at the time of the election not qualified to contest the election. 9, consequent upon 1 to it above another, striking out and dismissing the petition for being incompetent. Frivolous, vexatious, abusive. In the alternative to the above another, striking out paragraphs, prayers A, B, C, and D of the petition are sought in paragraph 150 for being incongruous, contradictory, and self-defeatist. The grounds of the petition were stated there, and we set them out, which you get. Second respondent also filed a similar preliminary objection, application for a preliminary objection, seeking striking out of the petition or portions of it. A single prayer on the application is an order of the court striking out jointly and or severally paragraphs 14 and 15, 19 to 81, 87 to 104, 108 to 128, and 133 to 150 of the petition for being fundamentally defective. The third respondent on this part in his first application on the same issue filed, we gave the date, sought similar prayers like first and second respondents. All three respondents also had issues with the replies petitioners served on them in response to their own replies. Their main complaint this time is that the said replies went beyond the ambit of replies and raised new issues and facts like particulars of the non-qualification of second respondent for the election and his dual citizenship of Republic of Guinea, all of which, according to the reply of the petitioners, impacts on his qualification as a candidate for the election. Those new facts, the complaint tended to amend or reconstruct the petition and so overreach them, even as they do not have any further opportunity to join issues petitioners on them. Other paragraphs of the replies, they said, did not raise new issues, but merely repeated averments already contained in the petition, and so have no place in the reply. For these same reasons, they sought striking out with additional statements, witness statements on oath, and list of documents that accompany the said replies. Besides the above, second respondent had a third application that was peculiar to it. In the said application, which was also filed on the 13th of May 2023, second respondent again sought the striking out of the entire petition, this time on the following four grounds. The entire petition constitutes a gross abuse of the process of court by reason of an originating summons in suit number LCCV 354-2023, filed by the Attorneys General of Adamawa, Akwa Ibom, Delta, Edo, and Sokoto states. All of them controlled by the second respondent, as he put them, as he called them, as second respondent put it, at the Supreme Court of Nigeria against the Attorney General of the Federation, where the said plaintiffs raised against the Attorney General of the Federation the same issue here of first respondent's failure to transfer or transmit polling unit results from his BVAS to his result viewing portal IREV in the 25th February 2023 general elections. The plaintiffs wherein first respondent mentioned sought in their suit declarations that the 2023 elections were fundamentally flawed and so invalid, null and of no effect, which is what petitioners also seek here. So this petition constitutes gross abuse of process. There were other grounds for that application, as I shall show later when considering it. All 7 applications were supported with affidavits and written submissions of applicants, which were in turn countered by the petitioners with counter affidavits and written submissions of their own. I shall now proceed to consider the merits of the applications. For ease of reference, I shall group the 3 sets of applications into groups A, B, and C. I start with the first 3 applications of respondents that attacked the validity of the petition, and now its paragraph relieves claims and grounds on which it was sought. First respondent's first application, that is the one filed on 9th of April. I start with that one. First respondent set out the following issues for determination in his 9th April 2023 application. Set them out. It argues its issues 1 and 3, you get it, so there's no point arguing it, time is going. It argues its issues 1 and 2 above separately and took issues 3 and 4 together. In seeking the striking out of paragraphs 9, 2, 3, 93, all set out there, of the petition on grounds of their vagueness, imprecision, and lack of specificity to elicit a reply from it, first respondent, that is INEC, relied principally on paragraph 4.1, sub 1 of the first schedule to the Electoral Act, which states as follows, says, an election petition under the Act shall state clearly the facts of the election petition and the grounds on which petition is based, and the relief sought by the petitioner. Relying on Ugu and Ararume and the number of cases all set out there, counsel on first respondents have argued that paragraph 4.1, the said paragraph 4.1 of the first schedule of the Electoral Act implies compulsion and makes it mandatory for petitioners to plead the facts of their petition. They submitted that an election petition that is vague, imprecise, omnibus, nebulous, or generic is contrary to the provisions of paragraph 4.1d of the Electoral Act and so liable to be struck out. Let counsel then carefully took on each of the said paragraphs and advanced reasons why they are vague, generic as a complaint. Counsel also argued that the petitioners in paragraphs 129 and 130 of their petition made allegations of unlawful acts allegedly carried out by one Honorable Friday Adejo, Governor Yaya Bello of Kogi State, and some unnamed persons in the course of the presidential election. Yet those persons were not joined to the petition, so those two paragraphs are also liable to be struck out. Also cited Bambe and Adetunji, Olori Ode versus Oyebi, and Babatola and Alade Jono to say the court large jurisdiction to enter judgment or make orders against persons that are not before it. Responding to the first limb of first respondent's contention, that the said paragraphs of the petition are vague and imprecise. The senior counsel to the petitioners argued that the said paragraphs were pleaded in support of the second ground of the petition, alleging that the presidential election was bedeviled by corrupt practices. Prime among those practices, they said, are suppression of votes, manipulation of beavers' machines, and destruction of electoral materials and ballot boxes. Specific instances of these corrupt practices that took place in various states and local governments, they argued, were laid bare in the petition with particulars of the allegation. They argued that first respondent, instead of considering the paragraphs of the petition holistically, seems to have considered them in isolation and apparently hence its wrong conclusion that the petition was vague, imprecise, and without necessary further particulars. While admitting that the names of polling units were not specifically stated in the petition, petitioners' counsel submitted that petitioners stated in different paragraphs of the petition that the polling units affected were to be contained in the statistician's report to be relied upon at the hearing of the petition. They cited the cases of Oluwedu Vasajayi, Awolaja, and others, as of Citrate and East Horizon Gas Limited versus Afiok and others. To submit that petitioners have by that pleading incorporated by reference the said statistician's reports. On the argument of the first respondent that the petition did not disclose any reasonable cause of action and so constituted abuse of process, petitioners' counsel argued that first respondent was by that argument trivializing matters of high constitutional importance raised by petitioners in the petition. Submitted that a petition that touches on correct interpretation of section 133(2)b of the Constitution of this country, vis-a-vis the return of second respondent and the qualification or disqualification of second respondent, regulated solely by sections 131 and 137 of the Constitution, cannot by any means said to disclose no reasonable cause of action. On first respondent's contention that petitioners' failure to join Honorable Adejo and Governor Yaya Bello and unnamed thugs against whom they made allegations of criminal misconduct in paragraphs 129 and 133 of their petition made those paragraphs of the petition incompetent and liable to be struck out. Counsel to the petitioner submitted that section 132 of the Electoral Act has specified the persons who may be joined as petitioners or respondents in an election petition. That Honorable Friday Adejo and Governor Yaya Bello having not participated in the election or returned, petitioners are not in violation of the Electoral Act or any rule of law in not joining them. Besides, they also argued, no relief was claimed against the said two men, so they cannot be said to be affected in any way by the eventual outcome of the petition. Now, this is the way we resolve this. My Lord, resolve this. Now, paragraph 4.1 of the first schedule of the Electoral Act, as amended, states thus: 2020 states thus: an election petition under this act shall state clearly the facts of the petition, and the ground or grounds on which the petition is based and relief sought by the petition. This provision is so clear and direct that it does not require any aid in its interpretation. It simply restates in mandatory terms the first rule of pleading that claimants, in this case a petitioner, shall state clearly, quote and unquote, the facts of the election petition, end quote again, and the ground or grounds on which the petition or claim is brought. This requirement / duty to plead one's complaints and facts clearly in the statement of claim / petition, not reply, is a basic rule of pleading even in ordinary civil proceedings. Nemeka Agu in JSC, Natonda versus Ajani, put that point across most forcefully when he said that, and I quote, he said, "It appears to me that the rule which required every fact upon which a party intends to rely at the hearing of the pleading, at the hearing to be pleaded, goes to the fundamentals of justice. For no one, and defend the unknown. If one has to defend or counter a fact made by his adversary, the one must have due notice of that fact to enable him prepare for his defense. That is the very essence of pleading. As it goes to the very root of the rule of audio alteram partem, one of the twin pillars of justice, it would be misconception to describe it as mere technicality or regularity. It's a matter which cannot be waived. Indeed, by a long line of decided cases, it has been long settled that any evidence on the fact that ought to have been pleaded but is not, goes to no issue at all at the trial and ought to be disregarded, end quote. Now, the complaint of first respondent is that the petitioners in their petition did not state their case as clearly as required by section 4.1d of the Electoral Act 2002, It complains that petitioners' complaints were vague, imprecise, and lacking in particulars. It does not appear to me that this complaint can by any means be waved away as idle. If anything, even the petitioners seem to have admitted that they did not plead those necessary facts. But their response to that contention, as shown earlier, is that they pleaded a statistician's report, which contains the required details of the polling units where the corrupt practices they alleged took place. Incidentally, the said report, a very voluminous four-part document, the later tendered through his maker, Mr. Samuel Oduton, PW1, during the trial, shows on his face that it did not even exist at the time they filed their petition, and so was not served on respondents along with the petition to enable them exercise their constitutionally guaranteed right of responding fairly to the corrupt practices, quote and unquote, alleged particularized in it, and if necessary, also engage their own expert to reply to it. Engage their own expert to reply to it. Yes, the principle of incorporation, by reference relied on by them, that is petitioners, is part of our adjectival law and is supported by a fairly long line of cases, including MMA versus NMA, Ekpemupolo versus Edremoda and others, DFS Investment versus Brawalai Limited, Elo versus Idaosa, Abode Brothers Limited versus Niger Construction Company Limited, and another. But that principle cannot by any means override the fair hearing trial provisions of Section 36 of the 1999 Constitution of this Constitution, which also underpins the rationale for exchange of pleadings by parties. See once again the dictum of Naimeka and Atonda and Ajani already quoted. A statistician's report that is supposed to contain missing particulars in a petition, that which was only filed in the middle of hearing of the same petition, long after the time for exchange of pleadings had closed and even after petitioners had called as many as 16 witnesses in proof of their case, as happened in this case, cannot serve that purpose of audi alteram partem, let the other party also be heard too. In short, the tactics employed by the petitioners in this case as regards their pleadings, and the petitioners and the statistician's report referred in it, is to say the least most unfair and definitely negates the current practice regime that emphasizes front-loading of processes. Such dishonorable practice can only be likened to the unlawful boxing tactic of hitting one's opponent below the belt or from behind, which in the sport of boxing is penalized promptly with deduction of points. It cannot be different here. The said statistician's report, which is exhibits PAH1, PAH2, PAH3, and PAH4 in this proceeding must be and is hereby discountenanced. That conclusion should make the resolution of this issue of imprecision of the petition fairly easy. I shall nevertheless want to exercise caution and still consider the paragraphs of the petition attacked by first respondent, that it shall only be as they stand in the petition. In that regard, I am satisfied that paragraph 92 of the petition, where the petitioners allege wrongful calculation of polling unit results in various local governments of Sokoto State is lacking in particulars of the particular polling units affected and so liable to be struck out. Paragraphs 93 and 94 of the petition, where petitioners allege that first respondent officials failed to properly fill election forms in Kano State, I think sufficiently meets the requirements of paragraph 41D of the first schedule to the Electoral Act 2022. Paragraph 95 of the petition, where the petitioners allege that results in unspecified polling units in some local government areas of Kogi State were, quote, manipulated through and by the inflation of the second respondent's votes and depletion of the petitioner's votes, end quote, is in my opinion bad for vagueness, not only as to the polling units where the alleged manipulation occurred, but also as to the actual lawful votes of petitioners and second respondents allegedly depleted and inflated respectively. The need to plead the exact figures of votes affected by the alleged manipulation becomes even more crucial, in my opinion, when account is taken of paragraph 15 of the first schedule of the Electoral Act, stating that, and I quote, this is what that paragraph 15 says, when a petitioner claims a seat alleging that he had the highest number of valid votes cast at the election, which is what the petitioners are doing here, the party defending the election or return shall set out clearly in his reply particulars of the votes, if any, which he objects to, and the reasons for his objection against such votes, showing how he intends to prove at the hearing that the petitioner is not entitled to succeed. Second and third respondents can only properly exercise their right under this provision, requiring them to, quote, give particulars of the votes claimed by the petitioners that they object to and the reasons for the objection against such votes, after petitioners have themselves set out clearly the lawful votes depleted by the manipulation alleged by them. Paragraph 97 of the petition, in my opinion, are matters of proof at the hearing, even more so as the petitioners have stated. In those two paragraphs, that the disruption of elections in Adavi and OKE local government areas of Kogi State by agents of second and third respondents alleged hearing was captured in video recording, which they petitioners would lead evidence in proof. Paragraph 98 of the petition, where petitioners alleged that elections in 10 polling units were disrupted and there were no results from the said polling units, end quote, is bad for vagueness and specificity, insofar as it does not specify the affected 10 polling units. It is therefore also liable to be struck out. I'm also of the opinion that paragraphs 99 and 100 of the petition, also attacked by first respondent, has to do more with proof, which is a matter for the substantive hearing, especially as infractions complained of in them were again, according to petitioners, captured in a video recording which they promised to rely at the trial. Paragraph 101 of the petition, where the petitioner simply complained of failure of first respondents officials to properly fill election material, seems to me sufficient pleading. Paragraph 102 of the petition, where the petitioner simply alleged that infractions occurred in polling units unidentified in various local government areas of Kogi State, and what these failures enabled the results of the polling units in the said LGAs to be manipulated through and by the inflation of second respondents' votes, and the depletion of petitioners' votes is bad and vague as to the particulars of the specific polling units and votes of petitioners and respondents affected by the said manipulation of inflation and deflation. It fails to meet both the requirements of clear pleading of facts of the petition and paragraph 15 of the first schedule of the Electoral Act aforesaid. In fact, the following dictum of the lead judgment of Tabai GSC in Belgora and Ahmed clearly should say so, my lord. We have already produced all these things in CA03, and we don't intend to read. In any case, you get it and you see it. See also PDP versus INEC. For the same reasons, I am also of the opinion that paragraph 103 of the petition, where the petitioner simply averred generally that, quote, first respondent wrongly entered incorrect results for the petitioners in Borno State, is bad insofar as the polling units in Borno State affected by the incorrect results are not stated. I am, however, of the view that paragraphs 104, 105, and 106 of the petition sufficiently plead necessary for us to elicit appropriate response from respondents, even more so as paragraphs 104 merely alleged bypass by first respondent of beaver elections. The presidential election in Benue State, while paragraphs 105 and 106 simply stated the petitioner's ground that second respondent was not elected by majority of lawful votes. In respect of paragraph 104 of the petition, first respondent complains that the petitioners there contended that the entire results of the presidential election were wrong. Yet they did not plead the results they perceive to be correct, so it is also vague pleading. I am of the view that that complaint is better considered while considering the merits of the petition. That is even more so as it appears to us that paragraph 104 seems averred to by petitioners to meet the provisions of paragraph 4 sub 1 C of the first schedule of the Electoral Act that requires them to state in their petition, among other, the scores of the candidates in the election. To that extent, paragraph 104 cannot be faulted by application at this stage, let alone sought to be struck out in limine. Paragraph 105, 109, 110, 11, 12, and 113 of the petition merely pleaded facts as to whether second respondent, who by first respondent's own showing did not poll up to 25 of the total votes of the Federal Capital Territory, was properly returned by first respondent having regards to the provisions of section 134P of the 1999 Constitution of the Federal Republic of Nigeria and other relevant statutes. It is therefore in order. I am afraid paragraph 114 of the petition, 115 and 116, and paragraph 4, where they said purported results from 6,418 polling units have and indicate zero accreditation, and paragraph 118, where they have that critically, paragraph 118 and 119 are all bad for lack of particulars of necessary facts. As for the statistician's report, again referenced by them for the said particulars, I hereby reconfirm my earlier finding and conclusion on it. Paragraph 120 of the petition is not challenged by first respondents, so I shall overlook it, at least for now. The petitioners in paragraph 121 of the petition allege that first respondents, presiding officers of polling units, failed to properly fill and countersign alterations in election forms, including forms E, C, 8B, and blah, 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 but they did not mention the polling units, what local government and state said infractions took place. They simply reference the same statistician's report. This paragraph is bad for imprecision and so also liable to be struck out. Paragraph 122 to 125 of the petition are not challenged by respondents, so I shall skip them. In paragraph 126 of the petition, the petitioners complained that all over Nigeria, there were manifest cases of overvoting. The total of the affected polling units in the various states are set out in the statistician's report, pleaded and relied upon by the petitioners. This pleading is also, end quote, sorry. This pleading is also bad for vagueness. My earlier position on the statistician's report referenced by the petitioners is also reaffirmed. Paragraph 127 and 128 of the petition are not challenged by first respondents, so they are also skipped. I do not share the view of first respondent that paragraphs 129, 130, that's INEC, that paragraphs 129, 130, 131, and 132 of the petition are bad for lack of imprecision. Petitioners in those paragraphs carefully pleaded the specific polling units and numbers of votes therein that they claim were affected by the cancellation of elections complained by them. I am, however, of the opinion that the second complaint of first respondent against paragraph 129 of the petition, that is also deserves to be struck out for petitioner's failure to join Honorable Adejo, chairman of Oloma Boro local government of Kogi State, accused by them of having led thugs at gunpoint to force electoral officers in named polling units in Oloma Boro local government to declare concluded elections in the said units cancelled is well made. The petitioner's response that not only was no relief claimed by them against Honorable Adejo, he did not even participate, quote unquote, in the election, neither was he returned, so it's not a petition contemplated by Section 132 of the Electoral Act to be joined to an election petition. It's not a valid response. Section 133 of the Electoral Act only deals with the issue of which contestant of an election ought to be joined in an election petition by a co-contestant. It has nothing to do with the issue of joining of third parties against whom allegations of electoral infraction are made by practitioners, as in this case. Such petitions must be joined to the petition if the court is not to be exposed to the risk of infringing their fundamental right to fair hearing guaranteed by the Constitution. It is also of no moment that no relief was claimed against such persons in the petition. What is important is that allegations of electoral malpractice, which will require the court to make findings, including condemnation of the alleged conduct, where necessary, are made in the petition. Support for that position can be found in Wankwo and Yaradua, where Muntaka Kumasi JSC, after reproducing the provisions of the then newly enacted Section 1441, sub 2 of the Electoral Act, which is now Section 1332 of the Electoral Act 2022, and confirming that that provision had done away with the old regime of the Electoral Act that required petitioners to join all relevant electoral officers of INEC that conducted an impugned election. In addition to INEC, said, this is what his lordship said, unless the conduct of a petitioner who is not an agent, or the conduct of a party who is not an agent of the commission is an issue, it will then be necessary to join such party as a necessary party to the petition in order to afford such party a fair hearing, end quote. As regards the consequence of failure to join such necessary parties on the petition itself, his lordship Kumasi again said as follows. However, where such a party is not made a party, it will not result into the whole petition being struck out. And the particular allegation against such party is liable to be struck out, end quote. That is the fate of paragraph 129 of the petition, where allegations of electoral malpractice were made by the petitioners against Honorable Adejo, yet he was not cited in the petition. Incidentally, this is also one of the main reasons the Supreme Court gave in dismissing the appeal of the petitioners in the Odo State governorship case of Eitai Ojegede and another versus INEC, where allegations were made by the petitioners in that case against the then National Caretaker Committee chairman of the present head respondent APC, Governor Mai Malabuni of Yobe State, yet he was not joined to the petition by the petitioners. Paragraph 129 of the petition must therefore suffer striking out. For the same reason, paragraph 133 of the petition, where similar allegations of an alleged gun-toting Governor Yahaya Bello of Kogi State didn't talk to compel cancellation of concluded elections in polling stations were made, yet he was not joined to the petition, must also be struck out. Paragraph 135 and 136 of the petition were not challenged by first respondents, so they are hereby skipped. I consider this a convenient point to consider paragraphs 137 and 142 of the petition, which learned senior counsel to INEC further complained was also bad for non-joinder. Counsel's argument this time was that the petitioners were also seeking in those two paragraphs to avoid the entire results of the presidential election in Lagos and Kano states, as declared by INEC, where Mr. Peter Obi of the Labour Party and Rabiu Musa Kwankwaso of the New Nigeria Post Party scored the majority of lawful votes. Yet Peter Obi of the Labour Party and Rabiu Musa Kwankwaso were not joined to the petition, so those paragraphs were also bad and liable to be struck out. I consider this argument misconceived. In fact, it seems to overlook Section 134, sub 4 of the 1999 Constitution, stating expressly that, and I quote, for the purposes of an election to the office of president, the whole of the federation shall be regarded as one constituency, end quote. That is the position as it relates to a presidential election. Percentages of votes polled by presidential candidates in any of the 36 states of the federation or even the federal capital territory only become of consequence when the issue verges on whether the candidate return also satisfied the provisions of Section 131B and 2 of 1999 Constitution, as amended, requiring him to poll 25% of votes cast in at least two-thirds of the 36 states and the Federal Capital Territory. Outside of that, how many votes a presidential candidate polled in any of the states of the country is of little significance in an election petition challenging return in a multi-party presidential election. It certainly has no bearing on the question of who an aggrieved party challenging a presidential election return should join to his petition among the candidates that contested the election with him. By Section 133 of the Electoral Act, the only other candidate in the election the petitioner can properly join to his petition, the person returned as the winner of the election. See further on this, the cases of Buhari and another versus Yusuf, Yusuf versus Obasanjo and 50 others, Obasanjo and Yusuf versus others, particularly Buhari and another versus Yusuf, where it was said by, and I quote, by the Supreme Court, where it was said that, and I quote, an unsuccessful candidate in an election cannot be made a party to an election petition against his will, end quote. We also do not agree with first respondent that paragraphs 141, 41, and 142 of the petition were vague or imprecise. I do not, sorry. I am rather of the view that facts necessary to elicit an appropriate response from the respondents of the electoral infractions complained of by the petitioners have been pleaded in those paragraphs. I, however, agree with first respondent that paragraph 142 of the petition, where the petitioner simply complained that first respondent deliberately entered wrong results. For 22 name states therein, paragraph 44, where they averred that there were discrepancies on very large scale at the various local governments, various levels of recording and collation of results, particularly between the polling units and the ward polling centers, without specifying the said polling units and ward collation centers, where these said quote and unquote large scale discrepancies took place. And paragraph 144, where petitioners gave notice that they would rely on their same flawed statisticians' report, among other documents they did not front load, are bad and liable to be struck out for vagueness. Paragraph 142 of the petition, where petitioners simply stated as ground of their petition that the petitioners aver that second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, quote and unquote, that is all they said. It's also imprecise and vague as it gives no particulars of any of the several qualifying and disqualifying factors set out in sections 131 and 137 of the Constitution. The main purpose of pleadings, as further fortified by paragraph 4 sub 1b of the first schedule of the Electoral Act, we repeat, is to properly and clearly inform the adverse party of the case is coming to meet, so that he can respond appropriately to it. That is fair hearing. That requirement of the law does not permit parties to keep their cards face down, as petitioners did in paragraph 146 of their petition, when they simply aver generally that second respondent was not qualified to contest the 25th February presidential election, without revealing in what form he was not qualified or disqualified for the election. That paragraph of the petition falls far short of the requirements of paragraph 41B of the first schedule of the Electoral Act, and so liable to be and must be struck out. Conclusion on issue 1 of first respondent, the sum total of all the foregoing is that while paragraphs 129 and 133 of the petition are liable to be struck out for non-joinder, to which Mrs. Adejo and Governor Yahaya Bello of Kogi State accused the petition of committing electoral malpractices, paragraphs 92, 95, 98, 11, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack particulars, and so fall short of the requirements of paragraph 41B. They are all therefore ordered struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 100, 111, 112, 113, 114, 115, 16, 118, 19, 120, 122, 125, 130, 134, 138, 139, 140. On the other hand, are in order and properly pleaded. Now, issue 2 of first respondent in this same application reads whether having regard to the mandatory provisions of paragraph 41B of the first schedule of the Electoral Act, a reasonable course of action has been disclosed in respect of grounds of the petition contained in paragraph 16A, B, and D of the petition to warrant further or any adjudication on same. Counsel on behalf of first respondent this time anchored the arguments principally on the grounds on which petitioners founded their petition. Counsel reproduced paragraph 16A, B, and C of the petition where the petitioners alleged we let them out. The next reference, section 134 of the electoral act, stating that an election may be questioned on, among others, that the election was invalid by reason of corrupt practices, and argue that this provision, that is section 134, has a proviso in section 135(1). So the fact that an election shall not be liable to be invalidated by reason of non-compliance with the provisions of the act, if it appears the election tribunal or court that the election was conducted substantially, compliance with the principles of the act and the non-compliance would have substantially affect the result of the election. Relying on the cases of Ojukwu and Yaradua and Yusuf versus George, Senate Council submitted that for petitioners to sustain their ground of corrupt practice and non-compliance of the election with the provisions of the act, they are required to not only plead the fact of non-compliance, but further assert positively in the petition and prove that the non-compliance and corrupt practice complained of substantially affected the result of the election. To properly do that, they argued petitioners must plead and show how many votes were affected by the irregularities and that the deduction of such votes would void the return of second respondent as the winner of the election. That not only the petitioners not assert in their petition that the non-compliance complained of substantially affected the election, they did not also plead the votes or polling units affected by non-compliance to enable this court form an opinion on that non-compliance and corrupt practices complained of substantially affected the result, or that second respondent polled majority of lawful votes in the election and so ought to be returned. Without those facts in the petition, the petitioner's counsel submitted have simply blown quote unquote muted trumpet and their petition lifeless and failed to disclose a substantial cause of action. So it is liable to be dismissed. Resolution of issue 2. This issue does not, in my view, deserve any serious consideration. The reason being that petitioners expressly stated in paragraph 17 of their petition that, quote, the petitioners averred that the election was not conducted in accordance with the provisions of the Electoral Act and other relevant laws, and that the non-compliance substantially affected the result of the election. In that, the second respondent ought not to have been declared and returned as the winner of the election. That sufficiently answers the question of first respondent. Issues 2 and 3 and 4, the first respondent first application. Answer to first respondent, their issues 3 and 4, which they also argue together, basically relied on their contentions in issue 2 of the lifelessness of the petition to submit that the petition as by reason of the alleged submission in the petition identified above had become academic and constitute abuse of process of court, so this court is robbed of jurisdiction. Entertain it. This combined issue is founded on issue 2, and since issue 2 has been determined against first respondent, issues 3 and 4 perish with it, and so are hereby resolved against first respondent. Now I come to second respondent similar application, seeking dismissal of paragraphs 14 and 15, 19 to 81. Right. For this application, letter counsel second respondent simply said that the sole issue for determination thus was that in view of the provision of paragraphs 14(1)(d) of the first schedule to the relevant electoral act and relevant judicial decisions, whether paragraphs 14 and 15, 19 to 81, 87 to 104, and 108 of the petition are not liable to be struck out. We set out the arguments, both of them. He said, in the course of determining first respondent's application on the same issue of vagueness and precision in the complaints, I dwelt extensively on rationale for exchange of pleadings, generally and particularly in election particulars, as further set out by the lawmaker. I hereby adopt all those pronouncements. Same exercise are also considered and pronounced on the same complaints of vagueness, lack of particulars, generic and imprecision. Of the complaints of the petitions, paragraphs 92 to 146 of the petition, also made by the second respondent here, I there determined, we said what we listened, and said, I abide by those findings. I shall therefore simply focus on paragraphs 14 to 19 and 147 to 150, and the few paragraphs between paragraphs 92 to 147 of the petition omitted by the first respondent in the application, determined the complaints of second respondent of whether petitioners' complaints in those paragraphs were vague, imprecise, and generic. I now start that exercise. Without prejudice to what I had said earlier, and which I hereby reconfirm on the invalidity of the statistician's report relied on by the petitioners for particulars of the averments in the petition, I am of the opinion that paragraphs 14 to 15 of the petition, where the petitioners specifically complained only about correctness of the contents of INEC forms, are so clear as to the issue raised and so not vague. Paragraph 16 of the petition are not attacked by first respondent and so are also skipped. We also do not find paragraph 20 to 20 of the petition where the we do not also find paragraphs 20 to 20 of the petition where the petitioners complained that first respondent did not keep to his earlier promise of electronic transmission of election results to its IREF portal in real time when it returned this in vague. We, however, find vague, imprecise, and falling far short of the requirements. I, however, find vague, imprecise, and falling far short of the requirements of paragraphs 4(1)d and 15 of the first schedule of the Electoral Act 2022, the requirements in paragraph 23 of the petition, where the petitioner's complaint as a result of the election as announced by INEC does not represent lawful votes, and that lawful votes cast for them were massively deducted from their scores. Those paragraphs ought to contain the lawful votes of the petitioners that were alleged, quote, massively deducted, as well as those alleged to have been allocated to second respondent by INEC. We find properly and sufficiently pleaded paragraphs 24 down to 72 of the petition. We, however, find vague, imprecise, and lacking particulars paragraphs 82 to 86 of the petition, where the complainants complain that permanent voters' cards collected the unit results where elections were collected or did not hold across the country is above 1,000, is above 1,810,206, which is the margin of lead between first petitioner and second respondent. Consequently, the turn of second respondent was hasty, premature, and wrongful. This pleading ought to contain the precise number of permanent voters' cards alleged collected in the polling units, which by petitioner's contention would have closed the margin of lead between first petitioner and second respondent to make the latter's return unlawful. Without that information, the complaint is difficult to understand and respond properly to, let alone resolve. Paragraphs 87 to 90, where the petitioners complain of corrupt practices in conduct of the election, which practices they complain took the form, among others, of manipulation by second respondent through deliberate suppression and discounting of votes, is vague insofar as the polling units where the said corrupt practices took place are not stated. Paragraphs 92 to 97 of the petition, less paragraphs 135 and 36, also complained of by second respondent as vague, imprecise, and generic, have been dealt with by us while considering first respondent's petition on the same issue. We hereby adopt our findings in that application, resolving the complaints of second respondent in this application. As for paragraphs 135 and 136 of the petition, we have the view that paragraph 135, where petitioners complain of manipulation of election in Lagos State by first respondent, resulting in depletion of their votes and inflation of second respondents' votes, is vague in the absence of pleading of the number of votes so depleted and inflated. In respect of paragraph 136 of the petition, even the petitioners again complained, even the petitioners again complained that the votes returned by the first respondent for Obi Akwa and Port Harcourt local government areas of Rivers State did not reflect the actual votes. If not express the actual votes scored in the said local government areas, or even those updated to IRF by INEC and so liable to be voided, no correct quote unquote figures of the actual votes cast as reflected in the IRF were pleaded. So it is also bad for vagueness and imprecision and therefore liable to be struck out. Sum total of the foregoing are complaints of vagueness, imprecision, and genericness of environments, all by second respondent against the petitioner, only made out as regards paragraphs 23, 82 to 86, 89 to 91, 92 to 95, 98, 121, 124, 126, 129, 133, 135, 136, 147, 144, and 146 of the petition. Accordingly, those paragraphs are hereby struck out, while the remaining paragraphs of the petition are deemed in order and pass the vagueness test of paragraph 4(1)d of the first schedule of the Electoral Act. Pronouncing the said paragraphs of the petition bad for vagueness and liable to be struck out, we are not unmindful of the argument of petitioners that second respondent's remedy lies in an application for further particulars and not striking out. We are, however, of the petition that application for particulars is only one of several options open to second respondent, who in any case is not under any obligation to help petitioners make out their case against him by asking for particulars of their generic and nebulous complaints. That is also the point that was made by Fabi EJS in PDP versus INEC, when his lordship said at page 524 that, and I quote, the application for another for further particulars or the like is merely a shield in the hand of a party who so desires, and not a sword to be used by a party whose pleading is grossly inadequate, insufficient, or devoid of necessary particulars. The decision in Olawekpo versus Saraki, cited by legal counsel on both sides, is in point. It is not the duty of a respondent to groom a petitioner on how to draft his petition, end quote. It is also quite revealing, if not even reassuring, we must say, that this argument of the petitioners of duty of second respondent to ask for further particulars, because that's their main argument, in their petition rather than asking for striking out the particulars, was also rejected by Muntaka GSC while delivering lead judgment in PDP versus INEC in 2012. Even as the same argument had found favor with his lordship, that is Muntaka, 2 years earlier in his contribution in Nwankwo versus Yaradua. His lordship in the latter case of PDP versus INEC endorsed the stand of trial tribunal in that case, that paragraph 12 sub 5 of the first schedule to the Electoral Act, same as paragraph 12.5 of this present Electoral Act. Okay. Permitting respondents to apply to strike out a petition did not exist in the 2000 Electoral Act in force at the time Nwankwo and Yar'Adua was decided, and that made all the difference. Regarding the further argument of second respondent, petitioners complained that first respondent did not observe his own promises to transmit election results to IRF portal in real time, was caught and made comatose by Section 134 of the Electoral Act, stating Electoral Act. We think it is, I think it is neater and even safer to defy to the main argument for determination on its merits, especially since that contention is also one of the main complaints of the petitioners in the petition itself. That is what case law decides. Advice is sorry. See again Nwankwo and Yar'Adua, citation given. Third respondent's application on the same issue of vagueness of paragraphs. Our own application, that is the third respondent this time. In his own application of 8 May, third respondent, like the first and second respondents, also pleaded to strike out all of paragraph 17 to 146 of the petition on the same grounds of vagueness, imprecision, blah, 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 and failure to join Mr. Adejo and Governor Yahaya Bello of Kogi State, against whom allegations of electoral infraction were made. Additionally, it's also complained that petitioners' amendments in paragraphs 19, stated them, and 45 of the petition are all pre-election matters which occurred after the petition and outside the jurisdiction of this court, sitting as an election petition. Again, the petitioners argue in response that their complaints were properly pleaded in the petition and so not imprecise, nor pre-election matters as alleged by third respondent. Resolution. Since the application of third respondents relates to the same paragraph of the petition objected to by first and third respondents, over which we have already made findings, we abide by and adopt those findings in determining the application of third respondent. We further hold that petitioners' amendments in paragraphs 19, 20, 21, 35, 41, 42, and 45 of the petition are not pre-election matters. In fact, whereas the issues of the assurances given by INEC of real-time transmission of results to IRF raised by petitioners in paragraphs 19 and 20 of the petition, how the elections were generally funded by the federal government of Nigeria on account of those assurances as averred, and how first respondent transferred his in-house experts from one department to another before the election as alleged in paragraph 35 of the petition, cannot by any means give rise to a cause of action, let alone a reasonable cause of action. In petitioners, sorry, what is there? In petitioners, the amendments in paragraph 42, 43, and 45 of the petition are simply notices by the petitioners to subpoena witnesses, testify about first respondents' omissions and commissions in the conduct of election, and so cannot by any means be described as causes of election, let alone pre-election matters for which they could have commenced action as alleged. In conclusion, the applications of first, second, and third respondents succeed only partly, and the following orders are made on them. Paragraph 23, 82 to 89, 88 to 91, paragraph 95, 95, 98, 121, 124, 126, 129, 133, 135, 136, 143, 144, and 146 are hereby struck out as prayed. The remaining paragraphs of the petition attacked past the vagueness test and paragraph 41D of the first schedule of the Electoral Act 2022 and are hereby upheld. That leaves us with the standalone application of third respondent also filed on 8th of May 2023, as well as the 3 applications of third respondents, all objecting to petitioner's replies to their petition, to their reply, sorry. Second respondent, so we take that one. We try to produce the arguments there. We said, then we went on to say that the thrust of the response of petitioner's counsel, that is 455. Thrust of the petitioner's counsel is a suit number SCV 351 that was not filed by the petitioners. So this petition, sorry, I'm still reading 544. And now it is settled to the position of the law that once a court is satisfied that a proceeding before it amounts to abuse of process, it has the right and indeed duty to invoke its coercive powers to punish the party in abuse. Quite often that power is exercised by dismissal of the action that constitutes abuse of process. But multiplicity of actions, which is the complaint here, on the same subject matter and issue will only constitute abuse of judicial process if the parties in both actions are the same or previous to one another. See your case of Attorney General of Anambra State. It necessarily has to be so because except where a person is shown to be privy of another as recognized by law, no man can be punished for the actions or sins of another. That is the crux of the issue here. It is whether the petitioner, that's Alhaji Atiku Abubakar, and its political party, the PDP, can be properly described as PVs of the governments of Adamawa, Akwa Ibom, Bayelsa, Delta, Edo, and Sokoto states, who undisputedly instituted suit number SCCV against the Attorney General of the Federation before the Supreme Court of Nigeria. That question can only get a negative response. For the government of a state, regardless of the political party platform on which its executive governor is or was elected, represents all shades of opinion in the state, including even those who may not belong to any political party at all. In fact, a state government is not even bound nor obliged to take instructions from the political party of the governor. Interestingly, our law reports are replete with cases where state governments elected on the same party platform with the federal government have repeatedly sued the federal government at the Supreme Court. A good example is this. Okay. A good example is the recent new currency case. The new currency case that was instituted by the Attorneys General of Kogi, Kaduna, and Zamfara states against the federal government, even as both parties were APC governments. In that situation, one wonders where counsel would place this proposition of privity by affinity. There are other cases, we cited them, so we go on and on. In short, we reject this argument of second respondent of abuse of judicial process on account of litigation commenced by state governments against the Attorney General of the Federation. That is, as we also take note of the notice of discontinuance of case the said suit number SCCV 354/2023 filed by the plaintiffs in that case since the 3rd of March 2023, which notice was tendered by the petitioners in this court as Exhibit PV in the course of the hearing of the main petition on the 6th of June 2023. This court is obligated by Section 1221M of the Evidence Act to take judicial notice of its proceedings. The other argument of note of second respondent in this application is the one of failure of petitioners to again join Friday, Adejo, and Yahya and its effect on the petition. We have already struck out the relevant paragraphs of the petition where allegations of malpractice were made against the two gentlemen. We abide by that decision. Just simply add that we do not agree with second respondent's argument that the entire petition merits dismissal for non-joinder of those two men. Proper sanction in circumstances of this case, as we have already pointed out, citing Wankwa and Yaradua, to strike out the paragraphs of the petition where those allegations were made. That order will also further add, and contrary to the argument of second respondent, will not affect the paragraphs where allegations were made against unnamed thugs. Unnamed persons cannot be joined to an election petition like it is sometimes done in trespass cases. Obasa and Joe and Yusuf, where a similar argument was rejected out of hand by Kutigi and Pastor Chalon on JSC. Thus, it was said there that it said, quote, "It is impossible to drag unknown touts, police, and hordes of others to court and join them. That would be bizarre," end quote. Okay. So the next one, we now go to the challenges, the replies filed with the petitioners. All the respondents also challenge the validity of the replies and the accompanying witness statements on oath and list of documents petitioners served on them in response to their replies. Their common complaint in those petitions is that the said replies or paragraphs thereof offend paragraph 16 of the first schedule of the Electoral Act governing filing of replies by the petitioner, and so liable to be struck out. First respondent's objection was against the reply of first petitioner that was served on it. They sought striking out of paragraphs 1.1, 21, 23, and 21 of the petitioner's reply, striking out the further witness statement on oath of DM, who later revealed himself in the production as Senator Dino Melaye, and PDPC both deposed on 20th April, striking out the petitioner's list of additional documents dated 20th day of April, which accompanied it. Sorry. Thrust of the argument, which is counsel founded principally, and we reproduced the arguments, and we reproduced the reply. To start with, I am not persuaded by the petitioner's argument that the new facts or issues raised by them in their impugned reply relate to non-qualification, which is one of the arguments, and not the conduct of the election by first respondent. So second respondent, who is supposed to be first respondent, that is INEC, who is supposed to be neutral in that matter, cannot be had to be objecting to them. The issue raised by first respondent, that is INEC, actually relates to the competence of a major process before the court to which the reply filed by petitioners. It is an issue which counsel to first respondent as ministers in Temple of Justice, and even first respondent itself as a party to the petition, have a duty to bring to the attention of the court. that obligation even becomes more pronounced when it is realized that a substantial number of first respondents counsel are members of the inner bar who even have greater responsibilities to the court by virtue of their ranking. This preliminary objection, like the argument of petitioners, therefore rejected. Coming now to the merits of the application, it is common ground that the provisions of the electoral act most relevant to the resolution is paragraph 16 of the first schedule. We reproduce it. This provision, with the employment of the word shall, forbids the addition of new facts, especially if such new facts may have the effect of tending to amend or even just adding to the contents of this petition. Cited cases, I think we have spoken on it in 03. Incidentally, this paragraph also reflects in the case of this thing, only restate the well-settled position of adjective law that a claimant's claim or grievance are made in a statement of claim or petition as the case may be, and not in his reply to the statement of claim to that claim, statement of defense to that claim. That position also finds expression in Ulubodu and Lawal. Cited what the Supreme Court said there. They said a plaintiff must not in his reply make any allegation of fact or raise any ground of claim different from what is contained in the statement of claim. If a plaintiff does such a plea is irretrievably bad and no evidence would be admissible in his proof, end quote. In fact, that settled position of law is that except in some well-defined situations, a reply to a statement of defense is not even permitted where no counterclaim is served. This is so because there is in law an implied joinder of issues on any fact raised in the statement of defense, and any averment contained therein is deemed denied. This is cited. As to what will amount to a new issue, we cite again Egesimba versus Nuzurike, earlier cited in appeal number 03. Guided by all these and paragraph 16(1)(a) of the first schedule, it does not by any means appear to me that the new facts of conviction, conviction/fine, forgery, and dual citizenship of second respondent introduced by petitioners into their reply. The additional averments of how results could not have been uploaded to INEC's IREV after the 25th of February, and C, whether it was done at all and relevant officials of INEC could not have been involved in it. Not to talk of the petition's reply of averments already made by petitioners in their petition can pass as reply filed pursuant to paragraph 16(1)(a) of the Schedule of the Electoral Act, particularly as relates to the further details as are quote and unquote, as petitioners labeled them in their reply, of non-qualification of second respondent contained in paragraph 2(1)(b) of their reply. It bears reiterating that all that the petitioners refer to in paragraph 146 of their petition is the bare statement that, quote, the petitioners aver that second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, unquote. No details whatsoever was given by them of what they meant by second respondent's non-qualification. So first respondent, who was obviously satisfied that second respondent was qualified to contest the election by the documents he presented to it, also simply joined issues with them in a similar general manner. It is now through their reply that petitioners, who themselves seemed to have had no clear idea of what they meant by second respondent's non-qualification for the election, or simply deliberately kept it back when filing their petition, want to now introduce through their reply at a time when respondents have no further right of responding to them. Such unfair tactics cannot and is not allowed by our law. It must be noted, too, that under Section 131 of the 1999 Constitution of this country, there are as many as 4 different qualifications the person must possess before he can contest presidential election, and another 10 different grounds that can qualify such a candidate who has all the 4 qualifications of Section 131. Therefore, an assertion that merely says that a person is not qualified to contest election by reason of non-qualification will leave not just the person so assailed, but every other person involved, including the court, at a loss as to what the pleader has in mind. In fact, to allow such pleading will amount to upsetting the very essence of filing pleadings in a case, which is to give the adversary and the court a clear notice of the pleader's case, a point further fortified in paragraph 61(a) of the first schedule to the Electoral Act. Still on this issue, I must not fail to point out that the petitioners were only being clever by half when they claimed in paragraph 2(1)(b) of their reply that they were simply given, as they put it, other details, quote and unquote, of the non-qualification of second respondent by averring to the conviction, fine, certificate, forgery, and dual citizenship of second respondent that they raised in their replies. They had never given any details of second respondent's non-qualification, and so cannot talk about further details, quote and unquote, let alone hide under such further details to smuggle in the new facts they averred in paragraph 1(b) of their reply. These new allegations are not also mere, as they call it, evidence in support of their ground of his non-qualification, as their counsel also tried to make them out. There are facts which can only be contained in the petition itself, and not in the petitioner's reply to respondent's defense to the petition. Paragraphs 2(1)b and c of the reply, where petitioners avowed to no uploading of polling units results by first respondent, presiding officer at the election, we also agree with first respondent, are new issues or at least mere further denials by the petitioners, respondent denials of the petition. Such is not also permitted in the reply. See again, Bakar and another, versus Ibrahim, Akeredolu versus Akinremi, Egesimba versus Nuzurike, Spasco versus Alrain, Ishola versus LGB, and Obot versus CBN. In the light of all the foregoing, the two witness statements as well as list of documents accompanying that reply, all of which were based on the new facts contained in the impugned paragraphs of reply in the issue, are also incompetent and liable to be struck out. In summary, first respondent's applications of 9th May succeeds in its entirety. Accordingly, paragraphs 1, 2, stated them of the 1, 2, Roman figure 1, Roman figure 2, Roman figure 3, Roman figure 4, Roman figure 5, and 2(1)b, 2.1b, c, and d of the petitioner's reply, file a response to reply of first respondent together with two witness statements or note and list of documents which accompany that reply are all hereby struck out. Second respondent's application seeking striking out the self-respondents. Learned counsel, he also made his arguments, and then we come straight to the resolution. And I said here, my Lord said here, that I'm not even in the least persuaded by the argument of the petitioners, that they simply reply to new issues raised by second respondents in reply to their petition. Petitioners, like they did in their reply to the reply of first respondent, introduce fresh facts and issues of non-qualification of second respondent on grounds of his alleged criminal conviction, forgery of documents, and dual citizenship. That is foul play, which paragraph 16 sub 1a to the first schedule of electoral act expressly forbids. Consequently, paragraphs 1b, 1, Roman figure 7, A, B, C, and Roman figure 8 of part 1, as well as paragraphs 2, 3, Roman figure 1, 2, 3 of part 2 of the reply of petitioners. Second respondent, where the petitioners avert new facts of purported criminal conviction for future proceedings against second respondent adverse to his purported dual citizenship or grounds of non-qualification, are all hereby struck out. Paragraphs 8, 11, Roman figure 1, 24, and 24b of the petition we hold on the state of the authorities earlier considered are also new facts or at best mere denials and so liable to be struck out too, as they do not qualify as replies. Bearing the above, all other paragraphs of the petition filed on the 23rd, petitioner's reply filed on the 23rd of reply 2023 stand either not objected to or the complaints against them are not made out. In other words, the application of second respondent also succeeds partly as stated above. Third respondent's application as relates, and now we come to third respondent's application. And we come straight to say that I find necessary to first observe that, like all other replies of the petitioners, the impugned reply of petitioners of 24 that was served on third respondent is in parts A and B. Part A is devoted solely to the preliminary objection raised by third respondent's reply to the petition. That part is understandably not challenged by third respondent, so it shall remain as it is. It is only part B of that reply that is challenged by third respondent, and it's also this part that contains in its paragraphs 32 and 33 the fresh facts of second respondent's alleged status as ex-convict and having dual citizenship, all of which now insist disqualified him as a candidate for the election. These facts I have already determined can only be raised in the petition and not in their reply to the respondent's reply to their petition. They therefore offend paragraph 16a stated above. Besides these two paragraphs, every other amendment in paragraph 2 of the reply, that last paragraph 35, are, as third respondent's counsel rightly pointed out, either mere denials of third respondent's reply to the petition or repetitions of petitioners' averments in their petition, and so not permissible in a reply as per paragraph 16ab, 1a of the first schedule of the Electoral Act. See again, cited cases. It's also not the law, as erroneously argued by petitioners' counsel, that failure to reply to facts averred by third respondent in his reply to the petition would mean admission of those facts. Somehow, counsel like arguing always like that, not just this one. Failure to deny averments contained in a statement of defense does not imply admission, like it does with failure to deny averments in a statement of claim. See against Simba's case, Ayola GSC, I cited the summary. Third respondent's application succeeds in its entirety. Consequently, barring paragraph 35, the entire part B of the reply of the petitioner's reply of third respondent is incompetent and is hereby struck out. That concludes and settles all 7 applications trust preliminary objections of respondents. So that is it. So I now hand over to my leader, as politicians who want to call it, so that from there.
We'll go to the respondent's objections to documents tendered at the trial. My learned brother, by my immediate right, read the ruling.
Thank you. We want to take on the respondent's objections to documents tendered by petitioners at the trial. In the course of the hearing of this petition, objections were raised by the three respondents. First, to the validity of the witness statements and oath deposed to by some of the witnesses of the petition. Specifically, EW 12, that is petitioner's 12th witness, Eguma Friday. EW 13, that is Grace Timothy. EW 14, Grace Ajagbona. EW 15, Abidemi Joseph. EW 16, Ms. Edosa Obasa. EW 17, Ms. Aleri Ayuba. EW 18, Ms. Sadia Mohamed Haruna. EW 21, Mr. Samuel Odunta, the statistician. EW 23, Janet Nuhu Turaki. EW 24, Christopher Bulus Ado. EW 25, Victoria Sani. EW 26, Hitler Egwonu Nwala, the forensic expert. And PW 27, Mr. Mike Enahoro Eba, legal practitioner. These are those who witness statements. Witness statements were filed or deposed to long after petition was filed, and so did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act 2022. That is stating that election petition shall be accompanied by a list of the witnesses that the petitioner intends to call in proof of the petition. This objection was argued comprehensively by counsel to parties. The ruling on it deferred by the court till final judgment. Objections, therefore, were also raised by the respondents to virtually all the documents tendered by the petitioners in proof of their petition. But unlike the earlier objection on witness statements, counsel only gave notice that they will give reasons for those objections in their final addresses. They have since fulfilled their promise by filing separate addresses on those objections. The petitioners, on their part, also objected to some of the documents tendered by the respondents in the course of their defense and gave notice that they will also give reasons for their objections in an address to be filed at the close of the evidence. They, however, seem to have had a change of mind and have not filed any written submissions as promised. I am therefore left with only the objections of the respondents. I now proceed to consider the said objections of respondents. 1, the validity of witness statements on oath of PWs, that is petitioners' witnesses, number 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, that did not accompany the petition as required by paragraph 45E of the first schedule to the Electoral Act 2022. This objection was taken and comprehensively argued by First Respondents Council on 8th of June 2023, when PW12, Mr. Eguma Omachono Friday, the presiding officer in the disputed 25th February 2023 presidential election, tried to adopt his witness statement on oath, which he deposed only on the 5th, which he deposed to only on 6th of June 2023, long after the petition was filed on 21st March 2023. Subsequently, when the petitioners called their witness numbers 13 to 18, 21, 23 to 27, who also only deposed to their witness statements in the same June 2023, long after the filing of the petition, and even after hearing of the petition had commenced, Respondents' counsel again raised and adopted the same objections against those witnesses and their witness statements. As explained earlier, the thrust of the objection, which was championed by Chief Wale Olanikwekwe SAN for second respondent, was anchored on paragraph 45B of the first schedule to the Electoral Act 2022, requiring that the election petition shall be accompanied by, among others, witness statements on oath of the witnesses the petitioner intends to call in proof of the petition. Learned counsel argued that insofar as the witness statements on oath of the said witnesses of the petitioners did not accompany the petition of petitioners as required by paragraph 45B and 6, sub 6 and 7 of the first schedule to the Electoral Act, they were incompetent and cannot be relied on by petitioners or the witnesses concerned. It is irrelevant. Counsel argued that the said witnesses came to testify on subpoena issued to them by this court as paragraph 45B of first schedule to the Electoral Act makes no distinction between ordinary witnesses and those who were testifying on subpoena. Then that argument was taken, and after hearing the argument, this is our resolution. Now, this contention of the respondent has far-reaching consequences, as its resolution in favor of respondents will result in the court discountenancing the evidence of all the presiding officers, namely PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25, who were in the polling units in the election and so were eyewitnesses to the alleged failure by INEC to transmit and uphold the election results to IREV, major pillar of the petition. It will also result in discountenancing the evidence, oral and documentary, presented by petitioners' two expert witnesses, PW 21 Samuel Odunton and PW 26 Hitler Nwala, but also their last witness, Mike Enauro-Eba, PW 27, who alone testified on the non-qualification of second respondent for the election and tendered documents in that direction. That is, even as we must not fail to remind ourselves that the relevant facts in the petition and replies of the petitioners that would have supported the evidence of PW 21, 26, and 27, Mr. Samuel Odunton, Hitler Nwala, and Mike Enauro-Eba, have already been found incompetent and struck out by this court while ruling on the applications like preliminary objections of the respondents. Coming back to the objection of the respondents that paragraph 45B of the first schedule to the Electoral Act 2022 does not make any dichotomy between ordinary witnesses and those testifying only on subpoena as regards the duty to front-load witness dispositions along the petition. So the evidence of PW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, whose witness statements or notes were not front-loaded with the petition are incompetent. Paragraph 45B of the first schedule to the Electoral Act 2022 reads thus. I want to mention it. It says the election petition shall be accompanied by B, written statements on oath of witnesses. And clearly, this provision, particularly the word witnesses, whose written statements on oath the lawmakers require that shall accompany the election petition, must be given its literal interpretation. See the recent decision of this court in Ogba and Vincent, and then that of Senator Ararumi and INEC, all citations supplied. The unreported decision of this court also of 17th of July 2020 in Advanced Nigeria Democratic Party ANDP, versus INEC and two others, appeal number EPT 406/2020, and People's Democratic Party versus Okogbo, citation supplied on the issue. Where the words of a statute or instrument are clear, like paragraph 45B of first schedule to the Electoral Act is, particularly the unqualified witnesses, in quote, employed there, the court has no duty than to give it its literal meaning. Now, in Advanced Nigeria Party, Democratic Party, ANP versus INEC, in appeal already cited, presided over by Justice Igenimpa and Agim, our colleagues, as Agim as he then was unanimous in his decision on the point in issue. JCA, pronouncing the leading judgment, said, I am of firm view that if Section 145 of the Electoral Act 2010 and paragraph 34554 of the first schedule to the Electoral Act 2010 are juxtaposed with Order 3, Rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019, it is eminently clear that Order 3, Rules 2 and 3 of the Federal High Court Civil Procedure Rules is outrightly inapplicable to the situation the appellants find itself in this case. Paragraph 3 and 4 of the first schedule to the Electoral Act 2010 contain express and adequate provisions as to what the contents of a petition should be and the documents that must be front-loaded and accompany an election petition, including a list of witnesses that the petitioner intends to call, improve of the petition, and more importantly, written statements on oath of witnesses. Well, there is also, it says further, there is no dichotomy between witness statement mentioned in paragraph 4.5 of the first schedule to the Electoral Act in respect of witnesses' statement on oath, witnesses and witnesses' statement on oath of a subpoena witness. There is no distinction between ordinary witness and subpoena witnesses under paragraph 4.5 of first schedule to the Electoral Act. In essence, paragraph 4.5 of first schedule to the Electoral Act covers witness statements on oath of all categories of witnesses the petitioner intends to call at the trial of his or her petition, unquote. In Senator Ifeanyi Ararume and INEC, this court also decided over by my Lord Justice Samani JCA, the concurrence of my brothers Owade Kimbami, Bolaji Yusuf, and Bayero JCA, again confirmed this position when in that decision was held. Learned counsel for the appellant has argued that PW2 was before the court on subpoena, therefore the tribunal could not turn around to prevent him from testifying. It is not disputed that the said witness was before the court on subpoena ad testificandum, but it must be realized that this witness was subpoenaed on the application of the appellants. He was not summoned by the tribunal in the exercise of their powers pursuant to paragraph 41, 5, and 6 of the first schedule to the Electoral Act. He was therefore, for all intents and purposes, witness for the appellants. In that respect, his written statement or note was subject to the requirements of the law as stipulated by paragraph 4, 5 of the first schedule. Strict compliance with paragraph 4, 5 of the first schedule to the Electoral Act is mandatory. It's of such a nature that there is sanction in subparagraph 6 of paragraph 4. This point was also earlier made in petition 03. Also see the decision of PDP and Okagwe, and then Ogba and Vincent, Midira and Patricia Ete, Awoyemi, Lasun and Awoyemi. All these cases have the citation here and they already referred to in our earlier 3. Okay. It is of interest that in all these cases, the earlier decisions of this court, Midi Ram versus Patricia Ete and another, and Lasun versus Awoyemi, relied on strongly by Mr. Chris Uche SAN, what the petitioners were cited and considered but departed from by this court. Quite remarkably too, in his book, Modern Nigerian Election Petitions and Appeals Law, published in November 2017, which book Chief Chris Uche SAN, the lead counsel for petitioners hearing, wrote a glowing forward to. The learned author, Mr. Kelechi Peter Ikoroga, Esquire, had this to say at pages 134 to 140 while commenting on this same issue, the SR position of this court in Omirira and Ete, and then Lasu versus Awoyemi. There, Chief Uche SAN, who is incidentally is present here, says, just like a petitioner in an election has 21 days from the date of the result of the petition to file his petition, otherwise such a petition becomes statute bar, there is also a time limit to the period within which a petitioner is to file a deposition or other document not filed along with the petition. Thus, all evidence required in proof of a case must, as a precondition to exercise jurisdiction, be brought within the stipulated time frame. That is to say, 21 days after the declaration of the result. The Supreme Court has consistently, in the long line of cases, insisted on this strict and inelastic approach in enforcing the electoral laws. Thus, the efficacy of the decision of Omidiron versus Sete, see also Lasso and Awoyemi, citation supplied, wherein the Court of Appeal held that it will be appropriate to meet the justice of the case for a tribunal to order the filing of witness depositions by subpoenaed witnesses outside the stipulated time frame has been watered down, in that all evidence required in proof of the case must be brought within stipulated time frame. See the case of Ogba and Vincent, where the Court of Appeal, Agim JCA, as it then was in lead judgment, held. I think that this court in Obidira and Ete and the Supreme Court in Oke and Mimiko adopted different approaches in addressing the issue of whether a tribunal or a court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election proceeding. Omidiron's case did not strictly enforce the time limits prescribed in Section 141 of the Electoral Act 2006, the provisions in the first schedule thereto in prohibiting the introduction of additional facts in the proceedings after the period allowed for filing the petition and closure of pleadings, paragraph 1(1) of Election Tribunal and Court Practice Directions 2006, and the content and form of the petition. It held that the purpose of the practice direction is to guide and regulate compliance with and observance of the provisions of the first schedule to the Act and the Federal High Court rules where applicable. This elastic approach of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the election tribunal, and court practice directions as overriding the rules of court in election cases. In Oke versus Mimiko, the Supreme Court approached the issue in keeping with the current judicial trend of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The law has laid out strictissima juris in Oke and Mimiko is that a witness deposition that is not filed along with the petition within 21 days allowed for filing the petition cannot be filed in the proceedings. It held thus: if there was evidence which was fundamental to the determination of the petition, that evidence ought to have been placed willy-nilly before the tribunal within the time specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition, even if it was being withheld by any person. There are several ways to go about placing same before the tribunal. The Evidence Act is very clear on this, and the petitioner ought to have resorted to that procedure. Put this in italics, we have earlier mentioned it in 03. As earlier said, Chief Chris Uche, SAN, in his foreword to that book, glowingly endorsed this author's position and even recommended it to judges like us in these words: the author has ably and remarkably sought to examine the legal framework of electoral legislation within the landscape of judicial decisions emanating from disputes arising from elections in the context of election litigation, from the preparation of the election itself through the pre-trial proceedings, the actual trial, the judgment and trial proceedings. This book truly stands out in the midst of several other books in this field. As an avid participant in electoral litigation, I wholeheartedly recommend this book to all, particularly to lawyers, judges, students of electoral laws, litigants, and as well as all stakeholders in the development of our constitutional democracy, unquote. I shall hold counsel to his words, not just because they are coming from him, but also because they are correct. Permit me to still say a word or two on petitioners' contention that Order 3 Rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019 permitting parties to file witness deposition of a subpoena witness even after commencement of the action applies automatically to election petitions by virtue of paragraph 54 of the first schedule to the Electoral Act 2022. So witnesses' statement as said of their witnesses filed by them after hearing of the petition had long commenced wherein were in order, were in order, full stop. In the first place, paragraph 54 of the first schedule to the Electoral Act simply states, subject to the express provision of this Act, the practice and procedure of the tribunal or the court in relation to election petitions shall be as nearly as possible similar to the practice and procedure of the Federal High Court in the exercise of its civil jurisdiction, and the civil procedure rules shall apply with such modification as may be necessary to render them applicable having regard to the provisions of this Act, as if the petitioner and the respondent were respectfully the plaintiff and the defendant in an ordinary civil action. This provision clearly makes application of the civil procedure rules of the Federal High Court in election petitions subject to the express provisions of the Electoral Act. It is not the other way around of modifying provisions of the Act to agree with the rules of the Federal High Court as suggested by Petitioners' Counsel. That much, paragraph 54 further clarifies by stating that even where the Federal High Court rules are considered applicable, they shall only apply with such modifications as may be necessary to render them applicable, having regard to the provisions of this Act. Unquote. What all that means is that where there is express provision in the Act on a particular situation, such as it clearly is in paragraph 45B of the first schedule to the Electoral Act 2022, that says the election petition shall be accompanied by written statements on oath of witnesses, the provisions of the Federal High Court Civil Procedure Rules will not apply. Fortunately, there is again high authority in support of this position in the dictum of Muntaka Kumasi GSC in Nwankwo versus Yaradua, citation supplied, where His Lordship, after producing paragraph 50 of the first schedule to the Electoral Act, now paragraph 54, had this to say. Say from the above, it is crystal clear that the provisions of the Federal High Court rules are subject to the provisions of the first schedule of the Electoral Act 26, and if there is any conflict between them, the provisions of the rules under the Electoral Act will prevail. It is where there is a lacuna in the provision of the rules provided in the Electoral Act 2006 that the provisions of Federal High Court rules will apply. I shall also add that the Parliament have expressly stated without dichotomy in paragraph 45B of the first schedule that to the Electoral Act that petitioners shall front-load witness statements of their witnesses along with their petitions. It is not within the province of the court to give that provision a different interpretation. It is also no moment that in the court's opinion, the say literal meaning of paragraph 45B of the first schedule to the Electoral Act 2022 seems harsh, may not meet the justice of the case, as is being suggested by the petitioners, that subpoena is only issued to an unwilling witness, so it is not contemplated by paragraph 45B of the first schedule to the Electoral Act 2022 that a witness on subpoena should also depose to a witness statement before the subpoena to compel the attendance is served on him by the court. If anything, the argument rather brings to mind the very strong admonition of the British House of Lords of Lords, Lord Denning MRL in Newport Steels Limited versus SIRS, citation supplied, where the learned Lord Scaman in his speech said, but in the field of statute law, the judge must be obedient to the will of the Parliament as expressed in its enactments. In this field, Parliament makes and unmakes the law. The judge's duty is to interpret and to apply the law, not to change it to meet the judge's idea of what justice requires. Interpretation does, of course, imply in the interpreter a power of choice where different constructions is possible. but our law requires that the judge chooses the construction which in his judgment best meets the legislative purpose of the enactment. If the result is unjust but inevitable, the judge may say so and invite Parliament to reconsider the provision. But he must not deny the statute. Palatable statute may not be disregarded or rejected merely because it's unpalatable. Only if a just result can be achieved without violating the legislative purpose of the statute may the judge select the construction which best suits his idea of what justice requires in any case. That is a settled position of the law, even in this country. See Ndomaegba and Shukwogo, citation supplied. Aromolara versus Aguru. Coca-Cola, Nigeria, Akinsanya, then Global Excellence, cited earlier, and Donald Duke. There, summarized aptly, wherein my Lord said, the duty of the court is not to deal with the law as it ought to be, but as it is. Paragraph 45B of the first schedule to the Electoral Act 2022, I will even venture to say further, appears to have been inserted by Parliament in further realization of the sui generis time-bound nature of the election proceedings, a point further driven home by the Constitution of the Federal Republic of Nigeria, Second Alteration Act 2010, which introduced, among others, a new section 285 sub 6 into the 1999 Constitution. That provision states that an election tribunal or court shall deliver its judgment in writing within 180 days from the date of filing of the petition. This time limit for disposal of proceedings, it must be noted, is peculiar to election petition proceedings in our body of laws. It is not found in any other proceeding in the entire body of laws of this country. It thus imposes on the election court or tribunal a duty to properly utilize its case management so pre-hearing session as effectively as possible to carefully plan the future course and particularly its plenary hearing of every petition so as not to fall foul of the maximum 180 days limit. That necessarily includes trimming the number of witnesses where necessary once pleadings are closed in the petition. That is also the point echoed by this court in People's Democratic Party and Chibuzo, Okogbu, and others, citations supplied, where my colleague Abadwa JCA said, what is deducible is that witness deposition filed by a witness not listed in the petition cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. It was stressed also by this court hearing that to allow a petitioner to file an additional witness statement at any stage of the election proceedings would destroy the regulated environment that must exist to ensure that both parties to the petition are expeditiously heard and the petition determined within 180 days from the date of the petition. This court observed that such an indulgence will remove the control of the pace of the proceedings from the control of the Constitution, the Electoral Act, and the first schedule to the Electoral Act, and leave it at the whims and caprice of the parties and open the floodgates for all kinds of abuses of the judicial process. Quote. I think the same point is also deducible from the following. In the dictum of Toby mentioned similar things in Buhari and INEC. And then Buhari and INEC also said a lot about that. We have mentioned it earlier. And then by rules of stare decisis, the decision in Oke and Mimiko and Ogba Vincent, decisions of this court is bound not only by decisions of the Apex Court, but also by its own previous decisions. And these are known issues. Victor Rusek and ACB is there, and then ITPP Limited and UBN Limited. See the decision of Ogbuagu JSC. Long and short of all the foregoing is that the objection of the respondents to the witness statements of PW12 Eguma Friday, PW13 Grace Timothy, PW14 Grace Ajagbona, PW15 Abidemi Joseph, PW16 Ms. Edosa Obosa, PW17 Ms. Aleri Ayuba, PW18 Ms. Sadia Mohamed Aruna, PW21, Mr. Samuel Odunsan, the statistician. PW23, Janet Nuhu Turaki. PW24, Christopher Bulusado. PW25, Victoria Sani. PW26, Hitler Ewonu Mwala, forensic expert. And PW27, Mr. Mike Enauroeba, legal practitioner, which did not accompany the petition as required by paragraph 45B for the first schedule to the Electoral Act is hereby sustained, and the witness statements being incompetent are hereby struck out and expunged from the records of this court. The further consequence of that decision is that given the provision of paragraph 41 sub 3 of the same first schedule to the Electoral Act 2022, stating that there shall be no oral examination of a witness during his evidence in chief except to lead witness to adopt his written deposition and tender in evidence all disputed documents or other exhibits referred to in the deposition. It follows that all the evidence, including evidence in cross-examination and all documents, reports included, namely PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1B, PAR1C, PAR1D, PAR1E, and PAR1F, and PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD1A, PBD2A, PBD3, PBD4, PB1, PBE2, PBE3, PBE4, PBE5, PBE6, PBF1, PBF2, PBF3, and PBF4, coming from and tendered by the said petitioners' witnesses, namely, as I already listed, EW 12, 13, 14, 15, 16, 17, 18, 21, 22, 23, 24, 26, and 27 aforementioned are incompetent and are hereby expunged from the records of this court. Other objections of respondents. That takes me to the other objections raised by the respondents to the admission of documents tendered by petitioners at the hearing, which objections they only gave notice that they will give reasons at final address stage. All three respondents filed their submissions on the objections and adopted them on 1st of August 2023. Petitioners on the same 1st of August also adopted their responses to those objections. Now, before going into the objections, we deem it necessary to first dispose of the preliminary argument of counsel to petitioners that some of the documents objected to by respondents are electoral material certified by the first respondent INEC, which documents parties had agreed at the pre-hearing session that they will not object to. So respondents cannot resile from that agreement and raise objection as they are doing. They even cited section 169 of the Evidence Act 2011 to say respondents are stopped from resiling from that agreement. The simple answer to that argument is that this court, and indeed every court, is bound to act on only admissible evidence. So if a document or piece of evidence is inadmissible in evidence, the court must expunge it, and it must do so even if that will require it to overrule its own interlocutory decisions admitting that evidence. See Shano and AfriBank and other authorities in that respect. As counsel, as ministers in the Temple of Justice are therefore within their right and in fact duty bound to draw court's attention to that fact, regardless of whatever agreement they may have had with petitioners at the pre-hearing session. In any event, the court is only bound to honor lawful agreements, not unlawful ones, to admit evidence that may well be inadmissible. With that said, I now proceed to the objections as contained in the addresses filed by respondents. Here, I shall take them together as I would have done if reasons now advanced for them were canvassed earlier. Now, let's look at first respondents' alleged allegation of improper or non-certification of INEC documents. Answer to the first respondent in paragraphs 1.34 to 1.36 of first respondent's written address filed on 14th of July 2023 second respondent at paragraph 3.13 of his 20th of July 2023 address, and third respondent in paragraph 1.14 of his written address on objections filed on 14th of July 2023, all argue that that payment for certification is one condition precedent under Section 104 of the Evidence Act 2011 for certification of public documents. They said petitioners did not pay for certification of some INEC documents, specifically exhibits PAJ1, PAJ to PAJ 37, PAJ 38, PAJ 39A to F, PAJ 40, PAJ 41 to PAJ and PAJ 41 to PAJ 7. There's something wrong. PAK1, PAK13, PAL1, PAL2, PAQ to PAQ14, exhibits PAS1 to PAS20, exhibit PAT1 to PAT17, then PAU1 to PAU17, PAV to PAV20, PAW1 to PAW25, PAX1 to PAX13, PAY1 to PAY18, PAZ1 to PAZ17, PBA17 to PBA27, PBB1 to PBB21, and did not provide any evidence of payment of certification fees. Senate Council, all citing the cases of Tabik Investment and GTB, Jimon, Minister of Federal Capital, Emeka and Chuba Ikpeazu, argued that certification fees for the said documents having not been paid by the petitioners, documents remaining admissible and liable to be expunged from the records. Petitioners in response argued in paragraph 4.1 and paragraph 6.0 to 6.2, paragraph 2.123 of their response to second respondent, and paragraph 2.16 to 2.7 of their response to third respondent, that they actually paid certification fees to first respondent for their said documents, and that there were issued receipts by the first respondent. Some of those receipts, they said, were attached to the documents themselves, while others were separately receipted for, including in one instance, payment of 6,669,301 naira 25 kobo, and another for 150,967 naira 50 kobo. They argued that it was therefore unconscionable of first respondent who collected such huge sums of money from them to turn around and plead non-payment of certification fees. Then Senior Counsel on petitioners' behalf also pleaded the Evidence Act's presumption of regularity of official acts and submitted that it was strange that a public institution like first respondent will come before a court of law to disown documents officially issued by it. In specific response to third respondent's argument, counsel to petitioners argued that section 104(1) and 2 of the Evidence Act 2011 does not prescribe that the amount paid for certification must be reflected on the certified true copy of the document as part of the certification. So the argument of third respondent's counsel that because the certification of the said exhibits did not carry the amount paid for certification, certification fees were not paid for is clearly erroneous. Now, section 104 of the Evidence Act provides every public officer having custody of public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees prescribed in that respect, together with a certificate written at the foot of such copy that it is a certified true copy of such document or part of it as the case may be. Secondly, the certificate mentioned in subsection 1 of this section shall be dated and subscribed by such officer with his name and his official title and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies shall be called certified true copies. There is nothing in the foregoing provision, particularly subsection 2, dealing with what should appear on the certification, that suggests that the fees paid for certification of a public document should also appear on the face of the document, like the date, name, and official title of the public officer issuing the document, as required by subsection 2. Payment of certification fees is only a condition precedent to the certification. So it could be stated in any other place, including another document. That point, this court also made plain in answer to a similar argument in Dagash and Bulama. And see also Uzoma and Sodike, ANPP and PDP, all these were made clear there, where it was held that certification in fee contained in separate document is sufficient. In this case, not only is there evidence of certification fee payment by petitioners first in the form of SBPD, showing payment by petitioners to INEC of the sum of 150,967 naira 50 kobo for some documents. There is also a second INEC receipt in INEC's own letterhead and attached to Exhibit PAF 4C. This latter document evidencing further payment of certification sum of 6,696,301 naira 50 kobo by the petitioners, Atiku/PDP legal team, shows that it was made by the receipt number RRR 270-842-653235 and on INEX receipt number 069727 of 25th of May 2023. It specifically states on its face thus the sum of 6,696,301 naira 25 kobo only being payment for CTC IPO electronics of a copy of data level number data level, although not very legible, with time, then stamp, event history, polling units of EC8As and S yet to be uploaded from EC9 and other documents 2023 presidential election unquote. All that, in my opinion, is sufficient evidence of certification fee payment. Even more so, when the receipt indicates that the said payment also covers other documents outside those specifically mentioned therein. The burden had thus shifted to the first respondent, INEC, to show that the monies it received from petitioners for certification fee payment did not cover the documents they are now talking about, which documents INEC interestingly also certified. That burden INEC never discharged, especially when account is taken of the fact that it did not even give the amount assessed, if any, that petitioners were owing them for certification. By the provisions of Section 1041 of the Evidence Act, an applicant for certification of public document is only obliged to pay what is assessed by the public officer. What is more, the mere fact that respondents certified the said documents for petitioners, coupled with the evidence of certification fee payment by petitioners in Exhibits PD and PAF 4C, sufficiently triggers the provisions of Section 168(1) of the Evidence Act 2011 that says when any judicial act or official act is shown to have been done in a matter substantially regular, it is presumed that formal requisites for its validity were complied with. This ground of the objection is therefore overruled. Then on the issue of alleged engravement of certification, it was also argued by the respondents relying on Berguri and Ahmed that certification of the same documents was done by public officer of INEC by engravement of his name, official title, and date instead of subscription, so that also, he said, is invalidated the documents and rendered them inadmissible. I've carefully perused the said documents and verified that unlike Berguri and Ahmed, the documents in issue here bear the longhand signature of the relevant certifying public officer of INEC. That, in our opinion, is substantial compliance with Section 104 of the Evidence Act and attracts the presumption of genuineness via Section 146 of the Evidence Act. First and second respondents in particular also argue that exhibits PAH1, PAH2, PAH3, and PAH4 tendered by PW21 Mr. Samuel Odunta and exhibit PAR-A to F tendered by PW26 Mr. Hitler A1 Nwala were made during pendency of this proceeding or in anticipation of it, and therefore inadmissible in evidence by virtue of section 83.3 of the Evidence Act 2011. In their response, the petitioners argued that the said documents were made pursuant to the orders of this court, pursuant to section 146(1) of the Electoral Act 2022, permitting them to inspect documents, so they were properly before the court. Much as I am not oblivious of our earlier ruling, that these same documents coming from witnesses whose witness statements on oath were not front-loaded with the petition, are incompetent and so already struck out. I'm also of the opinion that the petitioners seem to 595 seem to completely misconceive the objection raised by the respondents, which is to the effect that the said documents, having been undeniably made during the pendency of this petition or in anticipation of it, are rendered inadmissible by the principal law guiding admissibility of evidence, the Evidence Act 2011, and Section 83 thereof, sub 3 thereof. It is therefore lame of the petitioners to find their breach of that provision on account of the orders of this court made pursuant to Section 146(1) of the Electoral Act 2022, that they be allowed to inspect polling documents in the custody of INEC. In any case, Section 146(1) of the Electoral Act 2022 merely states that an order for inspection of a polling document or any other document or packet in the custody of the Chief National Electoral Commissioner or any other officer of the Commission may be made by an election tribunal or a court of competent jurisdiction if it is certified that the order required is for the purpose of instituting, maintaining, or defending an election, unquote. This does not in any way give petitioners the leeway to adduce evidence in breach of Section 83, sub 3 of the Evidence Act 2011. Section 146 of the Electoral Act 2011 and the interim orders of this court only permitted the petitioners to inspect election documents for the purpose of instituting or maintaining an election petition. Nothing in that provision allows the petitioner to file evidence, let alone the bulky expert reports, as in exhibits PAH1 to 4, PAH1AF, PAR1A to F, during the pendency of the petition. The whole idea behind Section 83.3 of the Evidence Act 2011 is to eliminate the danger inherent in allowing a party to manufacture and bring in evidence specifically tailored in anticipation of a case, or was to produce such fresh evidence after the case had begun and parties had fully joined issues in it. That is exactly what the petitioners sought to do with exhibits PAH1 to 4 and PAR1A to F, prepared and filed by experts long after pleadings in the petition had closed, when respondents will no longer have opportunity of retaining their own experts to respond to the evidence presented against them in the said reports. I'm in agreement with the respondents and hereby uphold their objection that the said reports, which were admitted in evidence as exhibits PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1B, C, D, and E, and F are without prejudice to our earlier decision that the incompetent is also rendered inadmissible in evidence by virtue of Section 83, sub 3 of the Evidence Act 2022. Oh, sorry, Evidence Act 2011. Then the next one is inadmissibility of election documents tendered as exhibits by petitioners on grounds of absence of pleading to support them and consequential irrelevance to the petition. The respondent's argument here are given. So we now skip that to the resolution. We've seen that, and the resolution we have is, it appears clear to me that the respondent's objection here is misconceived and founded on isolated reading of paragraph 143 of the petition, where the petitioners aver that the first respondent and its agents wrongly and deliberately entered wrong scores results for the underlisted 22 states, namely Abia, Adamawa, Akwa Ibom, Anambra, Bauchi, Bayelsa, Cross River Delta, Edo, Enugu, Gombe, Imo, Kaduna, Katsina, Kebbi, Niger, Oshun, Taraba states. Pleadings, they said, of party is not read in that isolated manner to get at a party's complaint. Pleadings must be read holistically to get at the complaint in issue. If that is done as it should be done, the respondents would have come across where petitioners left no one in doubt that their complaint about the election is nationwide and not isolated to only some few states. That much is clear. First, from paragraph 107 of the petition, where petitioners averred that the petitioners shall give evidence to show that the election results as purportedly declared by first respondent in respect of each state of the federation, including the Federal Capital Territory, the details of which are contained in the table below, and table was given, are wrong. Then they proceeded to list each of every state of the federation. They also gave in the table wrong election figures declared by INEC for each state and FCT. Then in paragraph 147 of the same petition, they listed 60 different types of sets of documents they intended relying on to prove the said averment in paragraph 107 of the wrongness of the result declared by INEC for each state and the FCT, the presidential election. Among those documents listed by them are BVAS CTC reports, B, Forms EC8 series, then EC8A, EC8B, EC8C, EC8D, EC8DA, EC8E, that's a certificate of return received by petitioners' agents at the election. C, summary of the total registered voters on units basis. D, summary of PVCs collected on unit basis. E, data and event logs from all BVA's machines used in the election. And F, PVC collation records. These documents were specifically listed at paragraphs 147.1, then 6, 36, 37, 56, and 57 of the petition. These are the same averments to documents respondents are asserting were not pleaded by the petitioners and so irrelevant and inadmissible in evidence. They are indeed wrong. This ambit of the objection of respondents is therefore overruled and rejected. Then objection made by only the third respondent. The next set of objections to documents tendered by the petitioners were raised by only third respondent. I now proceed to consider them. Admissibility of video clips. Arguments were advanced there on, okay. Okay. Yes. So we said, I'm of the opinion that the contention is also misconceived, especially when regard is had to paragraphs 1, A, B, E, F, G of the certificate of authentication of the said video clips made by PW19 Dr. Ter. The authentication required by Section 84 of the Evidence Act in the circumstances the video clips in issue were made is statements assuring the court that they are in exact state, same state they were in the internet from where Dr. Ter, PW19, downloaded them to his laptop computer and subsequently to his flash drives before bringing them to this court. That much is evident in the contents of Dr. Ter's certificate in XBPAF 4B above. For the same reason, the argument of Dr. Ter is not in, the argument that Dr. Ter is not in position to answer questions on the said clips, and so his evidence on them is hearsay, is also non sequitur. Then there is also the issue of dumping of documents on court as ground for admissibility. With this one. Okay, that's part of the issue, which will be considered deeply. Okay, you see, that is it. This is, okay. Some of them are listed. The simple and straightforward answer to this argument is that the issue of dumping of documents on court, which expression in any case suggests that the documents so dumped are already in evidence before the court, only goes to the weight to be attached to the documents by the court. On this reasoning, this ground of the objection is rejected and overruled. Then also there is allegation that some documents tendered were either made during pendency of this proceeding, I think we have seen that, and anticipation of it by interested parties. I think we've done a little consideration of this earlier. So we'll go to number 3. They said also that exhibits PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2A, PBD3, and up to PBF4, tendered by the petitioners through PW27, Mike Enauro, to show second respondent's non-qualification for the presidential election on grounds of his alleged conviction stroke fine in the United States of America, forgery of certificates, and dual citizenship are irrelevant to the proceeding and so inadmissible in evidence, petitioners having not pleaded necessary facts in their petition to support them. This also was looked at by us, and okay, and I have already ruled while considering the preliminary objection of the respondents to the petition and replies of the petitioners that paragraph 146 of the petition, where the petitioners averred to non-qualification of second respondent for 2023 presidential election, was bereft of facts to sustain it. I also held that the fresh facts of a second respondent's conviction / fine by a district court in Illinois in United States, alleged forgery of documents and dual citizenship, all of which petitioners only introduced for the first time in their replies, were incompetent. They ran foul of both paragraphs 4.1d and paragraph 16.1b are incompetent, liable to be struck out, and were indeed struck out. I'm also aware that we have just a few seconds ago ruled here in this judgment that evidence of PW27, though through whom they say the documents SB now impeached by third respondent were brought in, is incompetent for non-compliance with paragraph 45B of the first schedule to the Electoral Act. Those rulings constitute issue estupel, binding not only on the parties but on this court too, meaning further that this court cannot depart from them. See Francis Shano and Afri Bank, and also Lawal Daodo and Cardoso and Daniel and all that. Consequently, the objection of third respondent to the admissibility of this evidence earlier highlighted, the objection is hereby upheld, and the said documents are further ruled inadmissible and expunged from the records of this court. Summary of all the foregoing is that 1, the objection to the evidence adduced by PW12 witness Eguma Friday, PW13 Grace Timothy, PW14 Grace Ajabona. Okay. Well, we said all those ones we have mentioned and also recouched here, we say that the objection is upheld, and that evidence together with the documents, reports included, tendered by the same witnesses are hereby expunged from the records of this court. Secondly, the objection of respondents to exhibits PAH1, PAH2, PAH3, PAH4 made by Mr. Samuel Odunton, PW21, and exhibits PAR1A to F made by Mr. Hitler Wanwala, PW26, is also further upheld, and the said documents already held incompetent and inadmissible by earlier rulings are again hereby pronounced inadmissible in evidence on this ground too. Then the third one now, exhibits, or the objection of third respondent to the admissibility of exhibits PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2A, PBD3, PBD4, PBE1, up to PBF3, PBF4, tendered by PW27, Mr. Mike Enauroeba, is also upheld, and the said documents are further ruled inadmissible and expunged from the records of this court. Save for these ones mentioned above, all other objections of the respondents to documents tendered by the petitioners are overruled. Well, at this level, I hand over, like my brother said, to my continue with the judgment. Thank you.
Well, I now consider the substantive matter, the substantive petition. I however wish to state that despite our conclusions above on the objections raised by respondents to documents tendered by the petitioners, I am still mandated to evaluate evidence adduced and consider merits of the petition. The only evidence I shall not revisit are exhibits PVD, PBD1A, PBD1C, 1B, 1C, 1D, 1 PBD1A, PBD2A, PBD3, PBD4, PBE1, 2, 3, 4, 5, 6, PBF1, 2, 3, 4, and 4, relating to second respondent alleged non-qualification that were tendered by PW7 at 27. Mr. Mike Enauroeba, the said documents, in our view, being bereft of pleadings to sustain them, as elaborately stated earlier in this judgment. Coming to the hearing, the petitioners called a total of 27 witnesses and closed their case on 24th June 2023. The respondents opened their respective defenses starting from 3rd day of July 2023. The said respondent called one witness as one of its staff, RW1, and closed his case. The second respondent also tendered documents and called one witness, RW2. The third respondent did not call any witness but tendered documentary evidence. At the close of the case of the parties, the court ordered written addresses. The addresses were filed and scheduled. In the final address for the first respondent filed on 14 July 2023, the learned leading senior counsel of first respondent, Mr. A.B. Mahmoud SN, raised 4 issues as follows. 1, whether having regard to section 47, subsection 2 and 3 of the Electoral Act 2022, paragraphs 38 and 92 of the regulations and guidelines for the conduct of elections 2022, and totality of evidence adduced at the trial, the inability of the first respondent to transmit the polling unit results electronically in real time using the BVAS device to the IRF portal constitutes non-compliance with the Electoral Act if such substantially affected the outcome of the presidential election held on 25th day of February 2023. 2, whether there exists cogent and credible evidence of corrupt practice to warrant the nullification of the presidential election held on 25th day of February 2023. 3, whether going by the provisions of section 131 and 137 of the Constitution of the Federal Republic of Nigeria as amended, the second respondent was at the time of the presidential election held on 26th day of February 2023 not qualified to contest the said election. 4, whether upon proper construction of section 134(2)(b of the Constitution of the Federal Republic of Nigeria 1999, the requirement that a candidate must score not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states in the Federation of the Federal Capital Territory, Abuja, means that a successful candidate must specifically score at least 1/4 of the votes cast in the Federal Capital Territory, Abuja, in addition to 2/3 of all the states. The second respondent, through his counsel, Wale Olanipekun, SAN, filed his written address on 14 July 2023. He raised for determination 4 issues which were listed as follows. 1, considering the relevant provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, the salient provisions of the Electoral Act 2022, as well as admissible evidence on record, whether the election of the second respondent into the office of President of the Federal Republic of Nigeria on 25th February 2023 was not in substantial compliance with the principles and or provisions of the Electoral Act 2022. 2. In view of the clear provisions of the Constitution, the Electoral Act 2022, and plethora of judicial precedents on the criteria for qualification of candidates for election to the office of President, coupled with the peculiar circumstances of this petition, wherein the petitioners pleaded no fact in support of their allegation of non-qualification of the second respondent, whether the second respondent was or is not eminently qualified to contest the presidential election of 25th February 2023. 3. Upon a combined reading of Section 134 and 299, as well as other relevant provisions of the Constitution, Section 66 of the Electoral Act 2022, and other relevant statutes, whether the second respondent has not satisfied the necessary constitutional and statutory requirements to be declared winner of the presidential election of 25th February 2023 and returned as President of the Federal Republic of Nigeria. 4. Considering the constitution of the petition and the task evidence adduced, whether this honorable court can accede to any of the reliefs being claimed by the petitioners. The third respondent, through her lead counsel, filed its final address on 14 June 2023. Similarly, 4 issues were generated for determination. 1. Whether, having regard to the relevant and admissible evidence led by the parties, the conduct of the presidential election held on 25th day of February 2023 was vitiated by non-compliance and corrupt practices that were substantial enough to direct or directly attributed to the second respondent as to have affected the outcome of the election and to justify nullification of the election in a manner envisaged by the applicable provisions of the Electoral Act 2022. 2. Whether the burden of proving that first petitioner and not second respondent scored majority of lawful votes cast and satisfied the constitutional requirement of having 1/4 of the votes cast in each of at least 2/3 of all states of the Federation and the Federal Capital Territory to be declared and returned as the winner of the presidential election held on 25th February 2023 has been discharged by the petitioner. 3. Whether, having regard to the issues joined and evidence led on the qualification of the second respondent to contest in the presidential election held on 25th February 2023, the petitioner has established that second respondent was not qualified to contest the presidential election as provided for in the Constitution and the Federal Republic of Nigeria, 1999, as altered. And 4. Whether, having regard to the totality of the evidence led by the parties and the applicable law, the petitioners are entitled to succeed on any of the reliefs sought in the petition at all, or that the petition ought to be dismissed in favor of the respondents. In response to the addresses filed by the first, second, and third respondents, the petitioners, through their leading counsel, Chief Chris Uche, SAN, filed their respective written addresses on 22nd July, 22nd July, and 23rd July 2023. The petitioner senior counsel filed separate written addresses in response to each of the first, second, and third respondent addresses. The issue for determination raised in the 3 written addresses filed by petitioners in response to each of the written addresses of each of the respondents are the same, and they are: 1. Whether the return of the second respondent in the election to the office of the President of the Federal Republic of Nigeria held on 25th day of February 2023 was not invalidated by reason of substantial non-compliance with the provisions of the Electoral Act 2022 on electronic transmission of results for collection and verification. 2. Whether the second respondent was lawfully declared and returned as the winner of the presidential election held on 25th day of February 2023, having not secured 1/4 of the value of votes cast in the Federal Capital Territory, Abuja, as required by the Constitution of the Federal Republic of Nigeria, 1999, as amended. 3. Whether the second respondent was not disqualified under the provisions of the Constitution of the Federal Republic of Nigeria, 1999, as amended, to contest the presidential election held on 25th day of February 2023, having regard to the alleged order of forfeiture arising from that related offense, his acquisition of the citizenship of a country other than Nigeria, and presenting a forged certificate to the first respondent. 4, whether the first respondent was not wrong in returning the second respondent when he was not duly elected by majority of the lawful vote cast in the election. A look at the issues formulated by the parties will show clearly that, though differently worded, they are similar in context and content. It is in the face of this that we choose the 4 issues formulated by the petitioners, albeit with necessary modifications to anchor the determination of this petition. The issues for determinations as modified are as follows. 1, whether the return of the second respondent in the election to the office of President of the Republic of Nigeria held on 25th day of February 2023 was invalid by reason of substantial non-compliance with the provisions of the Electoral Act 2022. 2, whether the second respondent was lawfully declared and returned as the winner of the presidential election held on 25th day of February 2023, having not secured 1/4 of the valid votes cast in the Federal Capital Territory, Abuja. 3, whether the second respondent was not disqualified under the provisions of the Constitution of the Federal Republic of Nigeria as amended to contest the presidential election held on 25th day of February 2023, having regard to the alleged order of forfeiture arising from that related offense, his acquisition of the citizen of the country other than Nigeria, and presenting a false certificate to the first respondent. 4, whether the second respondent was duly elected by majority of the lawful vote cast in the election and the first respondent was right in returning him as duly elected. So we go to issue number 1, which is whether the return of the second respondent in the election to the office of President of the Federal Republic of Nigeria held on 25th day of February 2023 was invalid by reason of substantial non-compliance with the provisions of the Electoral Act 2022. Yes, we have considered the submissions of council, which we have summarized here. So we'll just go straight to the resolution of that issue. This issue of non-compliance is directly standing on the first ground of this petition. Thus, by paragraph 16A of the petitioner stated that the election of the second respondent is invalid by reason of non-compliance with the provisions of the Electoral Act 2022. By section 1341B of the Electoral, non-compliance with the Act is a ground for questioning or challenging an election. Primarily, the law is well settled that the results declared by ANEC first respondent in an election enjoy a presumption of legality. In other words, they are prima facie correct. Section 168 of the Evidence Act 2011, recently applied by the Supreme Court in Atuma and ANEC and APC, where in JSC held as follows. By virtue of section 168 sub 1 of the Evidence Act 2011, presumption of regularity inures in favor of judicial or official acts, including those carried out by ANEC. The exact words of the subsection are thus: when any judicial or official act is shown to have been done in a manner substantially regular, it is presumed that formal requisites for its validity were complied with. Fortunately for the appellant and first respondent, it is only a presumption which implies that it is rebuttable. Any person who questions the validity of an act in favor of which there is a presumption of regularity has a duty to rebut the presumption which, with cogent and credible evidence, a flimsy or half-hearted rebuttal will not suffice. Close of court. Any petitioner who complains that the result as declared is either wrong or not in compliance with the Electoral Act has the onus of proving the contrary. The Newsom Peter side, this case was laid open by the Supreme Court in the case of Andrew and another versus Annie, where the Supreme Court, per Onogen JSC, held as follows. Well, the term is far gone. We'll keep those petitions. When you get the judgment, you will see. Generally, it is the law that he who alleges must offer the requisite proof. The petitioners have the burden of proof, and they must succeed on the strength of their case as per their pleadings. The level of proof required is twofold. The first level is that there is non-compliance. The second level is to prove that the non-compliance substantially affected the result of the election. The learned senior counsel for the petitioners had in this petition argued that the burden of proof is on the person asserting the positive and not on the person asserting the negative. The petitioners, it appears from their position, tend to cross the line of misconception as to who has the burden of proof in adversarial system of justice in civil cases when the primary onus of proof is on the petitioner who makes all the claims against the respondent in this case. Well, we had started this case of Daché and Druven, Ugo JCA, in the earlier petition just determined. That's petition number 3. Usually the burden of proof is the debt owed by the petitioners to the success of their petition. The burden of proof rests upon the party who substantially asserts the affirmative of the issue. It is fixed at the beginning of the trial by the state of the pleadings. If the party with the burden fails or could not discharge the burden, the decision must be against him. The case of Adegoke and Adibi Supra, relied upon by the petitioner, was cited in the recent case of Folarin and Augusto, where the Supreme Court by Okoro JSC held as follows. The quotation is there. It is therefore settled that the terms negative and affirmative are relative and not absolute. The burden of first proving existence or non-existence of an assertion or fact, whether positive or negative, lies on the party against whom judgment will be given if no evidence were produced on either side. In the instant case, it is fundamental to point out that from the pleadings, the allegation of non-compliance is generated by the petitioner. Under Section 1341 and 135 of the Electoral Act, the level of proof required for the success of the petition is doubled. There must be proof of non-compliance and the further proof that the non-compliance affected substantially the result of the election. In the face of such an allegation of non-compliance, the court is enjoined by the law not to invalidate an election if it appears that the election was conducted substantially in accordance with the principles of the Electoral Act. All said and done, the petitioners have the primary burden of proving that there was non-compliance and that the non-compliance affects substantially the result of the election before the burden can shift to the respondents to establish that there was no substantial non-compliance with the Electoral Act in the conduct of the election. If petitioners have in their petition pleaded some of the facts relating to their complaint of non-compliance to the Electoral Act 2022, the key paragraphs of their petition in that regard are paragraphs 18, 22, 23, 25, 28, 29, 35, 36, 37, 38, 39, 40 to 44, 46, and 48 of the petition. The respondents joined issues with the petitioners in respect of this issue, and they all denied the facts pleaded by the petitioners. The denials of the first respondent in its reply are very significant. In paragraphs 17, 18, 19, 31, 32, 33, 34, 35, 36, and 37 of the first respondent reply, to the petition, the first respondent is in great measure denied all the allegations of the petition. In the petition, since those paragraphs are direct and straight denial by the first respondent, the burden of proof remains on the petitioners to establish their claim as required by the law. Apart from the first respondent, who is the primary respondent, due to the fact that it is acts that are challenged in this petition, the second and third respondents, who are the beneficiaries of the declaration of the results, join issues with the petitioners. The second respondent, in its reply to the petition, countered all the petitioners pleaded in respect of this issue. Issue 1 with paragraph 6, 33, 56, and 57 thereof. The third respondent countered the petitioner's allegation with paragraph 26, 37, and 40 of its reply to the petition. Non-compliance in ordinary parlance means failure to or refusal to do something that you are officially or statutorily supposed to do. See Shulua and another versus To J.I. 13, Ojuku and Yaradua and Akirdu and Mimiko. The Electoral Act 2022, in an explicit manner, has laid out clearly grounds upon which an election can be questioned in Section 134 thereof. Then there is Section 135 of the Electoral Act, which looks like a proviso to Section 134 for proper appreciation of the intendment of the law. Section 134 and 135 of the Electoral Act must be considered together. Well, an election may be, 1341 says, an election may be questioned on any of the following grounds. B of it says the election was invalid by reason of corrupt practices or non-compliance with the provisions of this act. Then 135(1) says an election shall not be liable to be invalidated by reason of non-compliance with the provisions of this act if it appears to the election tribunal or court that the election was conducted substantially in accordance with the principles of this act and that the non-compliance did not affect substantially the result of the election. This ground of non-compliance to the Electoral Act has been in all our electoral laws, even from when we had parliamentary system of government. The courts have, over the years, shed a lot of light on the requirement of the law in proving the allegation of non-compliance. A short chronicle of the decisions of our courts will throw more light on the evidential burden of proving non-compliance. For that purpose, we cited the cases of Bassi and Young, Awolowo and Shagari. We also cited the cases of Buhari and another versus Obasanjo and others, and CPC versus Buhari and others. So in all these decisions, the evidential burden of proof of non-compliance lies on the petitioner, who must first prove that there was non-compliance, and secondly, that the non-compliance has substantially affected the results being contested. Let me say that at the risk of sounding repetitive, that it is after the onus on the petitioner is discharged to the satisfaction of the court, that the onus will shift to the respondents to establish that the results were not affected. It follows, therefore, from the authorities referred to, that for the petitioner to succeed in the allegation of non-compliance, they must plead clearly in their petition the non-compliance and call witnesses or place before the court cogent and credible evidence of such non-compliance. The petitioners need to place before this court evidence based on their pleadings, indicating that the non-compliance has affected the votes cast at the election and that the impact is substantial enough to invalidate the election. The petitioners, it must be underlined, pleaded in paragraph 4 of the petition that the petitioners had agents in all the polling units, ward collection centers, local government collection centers, and state collection centers in all the states of the Federation and the Federal Capital Territory, as well as the National Collection Center. Of this crowd of agents, the petitioners did not call any of their agents at the polling units. The said agents at the polling units were the ones who were meant to sign and collect duplicates of results from EC8A. The few agents called were state and national collection agents. Largely, their testimonies were hearsay. Let us now examine their evidence before the court. The PW1 is Captain Joe Agada, retired. His statement on oath is at pages 198 to 200 of the petition. He was the petitioner's collation agent for Kogi State. In paragraphs 7, 8, and 11 of his statement, he deposed that from his analysis, he discovered various forms of non-compliance and corrupt practice such as suppression of votes, manipulation of beavers machines, manipulation of accreditation, intimidation and harassment of voters, massive thumbprinting of ballot papers, etc. This witness did not give particulars of these malpractices. There was no forensic report to support allegation of multiple thumbprinting at the polling units. In PDP and ANEC and others, this court, per Agim Jesse as it then was, held that it is only a polling unit agent, or a person who was present at the polling unit during polls that can give admissible evidence of what transpired during the poll in the unit. See also Goyol and Anada versus ANEC, Buhari and ANEC and others. In the instant case, PW1 was not a polling agent, he was a collation agent. When cross-examined, he said he would be wrong to say that he was present when all the ballot papers and boxes were manipulated, that he visited only 20 polling units out of the over 3,000 polling units in Kogi State. He admitted that his party had polling unit agents in all the polling units and that they are still alive. The PW2 is also a collation agent. His witness statement on oath is at pages 213 to 215 of the petition. His statement is similar to that of the PW1. His name is Dr. Solarin Sunday Adekunle. He was the collation agent of the petitioner for Ogun State on the election day. Under cross-examination, he said he only visited 19 polling units out of the 5,040 of the polling units in Ogun State. PW 3, 4, 5, 6, 7, 8, 9, 10, 11, and 11 are all collation agents. The evidence of these witnesses centered around the events and the duties carried out by the polling unit agents of the petitioners. They agreed under cross-examination that the polling unit agents functioned very well in their units. Under our law, specifically in Section 43 of the Electoral Act 2022, polling agents are permitted to be appointed by political parties for each polling unit and collation center. The wisdom in this is for each of the political parties involved in an election to be represented by its own agents. The duties of an agent are to represent the interests of his or her principal. Having regard to the fact that no mortal can be in all the places at the same time, the law allows political parties to have their agents at all polling units and collation centers. It is therefore not anticipated by the law for any political party to appoint an octopus agent with his tentacles in all the polling units and collation centers. This is humanly not practicable. When therefore evidence is required to prove what happened in any polling unit or collation center, it is only the agent who witnessed the anomaly or the malfeasance that can legally and credibly testify. It follows therefore that PW1, 2, 3, 4, 5, 6, 7, up to 11, PW 19, 20, and 22, who were state and national collation agents of the petitioners, can only testify of the events in their units or collation centers where they voted or acted as agents, and not all over the states of the Federation. The polling agents, as presented in this petition, it must be noted, are not shown to be experts. The issue of the analyzing results of the election of the ward, local government, and state and national level without calling polling unit agents who witness the real casting of votes and events at the voting units cannot therefore arise. They cannot validly testify of non-compliance at the polling unit level. Their evidence can only count as to what they saw, not what they were told by their field agents. What they were told is hearsay evidence. Section 38 of the Evidence Act 2011 specifically states that hearsay evidence is not admissible except as provided for in the law. This court and the Supreme Court in several cases has explained the intent of this legislation. Oda Sati, Jam and Oji, Ute and the state Kasa and the state Ukud and the state Buhari and Obasanjo. It is therefore settled law that hearsay evidence is not admissible to prove a fact of non-compliance with the Act. It follows that the evidence of the collection agents in this case, instant case, who are PWs 1, 2, 3, 5, and 7, relating to the suppression of votes, multiple tampering of ballot papers, entering of wrong scores, strong results, disruption of voting are inadmissible hearsay and are hereby discontinued. In the instant petition, the petitioners called 27 witnesses and tendered documents and exhibits. The main and crucial complaint of the petitioners from the evidence placed before the court was the inability of the presiding officers employed and used by the first respondent to upload and transmit the polling unit results to the first respondent's result viewing portal, that's IREF, and the electronic collection system. Of the 27 witnesses called by petitioners, 10 of whom were presiding officers who manned some polling units on the election day. A look at their evidence will bring out the facts of how the presidential election was conducted in some of the polling units on 25th February 2023. These witnesses are PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25. PW 12 is Yoguma Omachuku. The witness was on subpoena. He was the presiding officer in Collation Unit 07, Ward 3, Aban North of Abia State. His evidence is that the election was conducted as his polling unit and that at the end of the election, the results were recorded on the result sheet and duplicate copies given to the party agents at the polling unit. He stated that he had challenges in uploading the presidential election results from his polling unit to the IRF portal and electronic collation portal. When cross-examined, the PW12 testified that the election was peaceful and that it was the image of the result on Form EC8A that was supposed to be uploaded to the IRF portal. He further testified that the result sheets were delivered at the Ward Collation Center to the annual Ward Collation Officer. He said he was happy with the conduct of the election. PW13, Grace Timothy, who was the presiding officer for a polling unit in Bauchi State, corroborated the testimony of the PW12. She could not upload the result of the election to the RF, but that the party agent signed from EC8A and that she took the original result to the Ward Collation Center. PW14, Grace Ajabona, whose petition was polling unit 6, Ward 1, Yaba West, local government area of Kogi State, equally testified that the election result from her unit from EC8A was signed by her and all the party agents before she took the result to the Ward Collation Center. The PW15, Abidemi Joseph, was the presiding officer in charge of polling unit 047, Ward 9, Maji of Babambola community in Maji, Suleja, Niger State. She gave the evidence also that election was conducted in her unit and that the results were signed by her and the party agents before she took it to the Ward Collation Center. She also could not upload the result to the average viewing portal of ANIC. The PW16, Edosa or Bosa, was the presiding officer at polling unit 09, Welu Health Center, Ego Ward 05, Edo State. She equally testified that even though voting went well in the election at her polling unit, she was unable to upload the result of her unit to the RF using the beavers. She did the manual recording of the results into Form EC8A and signed the result along with the party agents. The result was equally taken by her to the Ward Collation Center. The same story was told by the PW17, Alheri Ayuba, who presided at the polling unit 05, Garki Ward 02, FCT Abuja. She used beavers for accreditation of voters, but could not load the results through beavers to IRF. She and the party agents signed the results, and she took the results to the Ward Collation Center. Even the testimony of Mohammed Haruna Sadia, the PW18, is in the same order. He was the presiding officer for Unit 05, Amak City Center, Ward 06, in FCT Abuja. She testified she could not also upload the results to the RF. She entered the results manually to form EC 8A and took it to the Vote Collection Center. She testified that she gave copies of the result to the party agents before taking the original to the Vote Collection Center. Janet Nuhu Turaki, the PW23, who was the presiding officer for Bolori West Ward 04, AB Bomala Danladi Jalo Polling Unit 03, Gombe State, could not upload the results to IRF after using beavers to snap the result as recorded in Form EC8A. She, however, testified that the party agents signed the results with her before she took the results to the Ward Collection Center. The same run of evidence was given by TW24, Christopher Bulus Arro, presiding officer in Maru Ward 04, polling unit 012 years, Sohor Kaswa, Maru, Zamfara State. In paragraph 9 of his deposition on oath, he said the election was successful except for failure to upload the results to the RF. The PW25, Victoria Sani, who was the presiding officer at polling unit 020, Ward 01, Atagarawa local government area of Katsina State, had the same testimony and experience with the beavers and the issue of uploading results to RF. The testimony of these witnesses were so clear and cogent that the election went well. The only difficulty was in uploading the results to the RF portal. These highlighted witnesses were all called by the petitioners. The witnesses were emphatic that the voting and the election in their respective units went well. The votes were collected and results announced at the polling units. Party agents signed the result from EC8S. The witnesses called to establish the fact of non-upload of results emphatically and directly testified that the election went well and votes were accounted for and sent to the Vote Collection Center for collection of the results. These 10 witnesses were all presiding officers engaged by the first respondent for the election of 25th February 2023. There is no gainsaying the fact that under the Electoral Act 2022, election is not just a process, it is a well-regulated process. In fact, in the case of OK and another was Mimiko, the Supreme Court Odiligency scripting out the meaning of election held as follows. On this facts issue, I will want to hang for support on the case of Abubakar and Yaradua, in which election was defined thus. Election is a process spanning a period of time and comprises a series of actions from registration of voters to polling. Then in Bile and the state, the court, Panguta JSC, explained further that election is defined as inter alia, the act of choosing or selecting one or more from a greater number of persons, things, causes, or rights. See Black's Law Dictionary Special Deluxe, 5th edition, page 464. The Oxford Advanced Learners Dictionary, page 372, defined it as the action or an instance of choosing by vote one or more of the candidates for a position, especially in political office. The process of election commences with the nomination of candidates through political party primaries. Then it moves into the election proper, which entails the voting, collection, announcement of results. To make this process steady, clear, and credible, the Electoral Act devotes time into making provisions for specificity of actions and steps at each stage. It will not be out of place, my lords, considering the strategic and fundamental nature of election, to survey some of the provisions of the law in this respect. The law made provision for accreditation of voters and voting in Section 47 of the Act, which provision I have reproduced in this judgment. This law has made it mandatory for accreditation of voters for the election to be done with the aid of a smart card reader or any other technological device that may be prescribed by the first respondent. The first respondent exercised the discretion given by the law to prescribe the use of bimodal voter accreditation system, that's BVAS for short, and popularly known as BVAS or BVAS machine. As the name indicates, BVAS is primarily a technological device for accreditation. By paragraph 18A of the Regulations and Guidelines for the Conduct of Elections 2022, the use of BVAS for accreditation is mandatory, and all the poll officers who fail to use it for accreditation shall be accused of dereliction of duties and penalized. It is after a voter passes accreditation that he will be allowed to vote. The bottom line of every election exercise is to choose one out of many or to show affirmation of the approval of a candidate who wins the election to lead the country in the instant case as the president of the country. To achieve this goal, election must be result-oriented and successful. A successful election must produce a winner who is expected to emerge by popular vote and as specified in Section 134 of the of the 1999 Constitution. It is in this respect that all votes cast at an election must be duly secured, collected, and counted. The Electoral Act is so clear and explicit on the issue of the votes cast and the results of the election. So for that purpose, I produced Section 25 of the Electoral Act, which stipulates the steps to be followed. So this provision makes it clear and straightforward that voting for all elections takes place at the polling units, and that is where the election is won or lost. The law requires that since the election, the present election, unlike others, is not done in one location but throughout the country, collection of votes commences at the registration area through ward level after voting, then it moves to the local government level, and then to the state collection center, and finally to the National Collection Center. It is after this that the winner of the election shall be announced. Furthermore, Section 60 and 60 of the Electoral Act deal with the counting and collection of votes cast. These provisions of the Electoral Act are very simple, plain, and straightforward, and do not require any technical rule of construction. The law is tried that where words used in a statute are clear and unambiguous, the courts are enjoined to interpret the words in their ordinary and natural meanings. Words used are to be interpreted in a way that will not clash with and defeat the manifest intention of the legislation. Every legislation is scripted by the lawmakers with a purpose. The court must be careful not to interpret the law so as to create absurdity or make nonsense of the law. See the cases of Imano and others versus Anekwe and others, Jegede and Anek, Guma and versus APC and others, Lado and another versus Masari and others. The law as prescribed in Section 60 and 62 of the Electoral Act 2022 does not in any form or sense make any provision or pretension as to any form of counting and collection of election results other than manual collection. In Oyetola and Anik Supra, the Supreme Court, per Agim JC, held on transmission of results, the essence and status of the collection system, and the Anik RF portal as follows. Court, as I had held herein, there is no part of the Electoral Act requiring the presiding officer to transmit the accredited voters in the polling unit or the polling unit result during election to the Anik database as part of the election process. As stated in Section 62(1) of the Electoral Act 2022, after the recording and announcement of the result, the presiding officer shall deliver same along with the election materials under security and accompanied by the candidates or their polling units, polling agents, where available to such person as may be prescribed by the Commission. This is to enable the Commission compile, maintain, and update on a continuous basis a register of election results. This intention is clear from subsection 2 of Section 62, which provides that the Commission shall compile, maintain, and update on a continuous basis a register of election results to be known as the National Electronic Register of Election Results, which shall be a distinct database or repository of polling unit by polling unit results, including collected election results of each election conducted by the Commission in the Federation, and the register of election results shall be kept in electronic format by the Commission at its national headquarters. As their names depict, the collation system and the ANEC result viewing portal are part of the election process and play particular roles in that process. The collation system is made of the centers where results are collected at various stages of the election. So the polling unit results transmitted to the collation system provides the relevant collation officer the means to verify a polling unit result as the need arises for the purpose of collation. The results transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results on the election day. It is clear from the positions of Regulation 38(1) and 2 that the collation system and result viewing portal are different from the National Electronic Register of Election Results. The collation system and result viewing portal are operational during the election as part of the process. The National Electronic Register of Election Results is a post-election record and is not part of the election process. With this step of the law, let us now assess the case of the petitioners in this petition. The petitioners, as earlier mentioned in this judgment, are claiming that the failure of the first respondent to upload the election results constitutes non-compliance to the Electoral Act. They pleaded in paragraph 14 and 15 of their petition. Thus, for reproduce paragraph 13 and 14. So the petitioners, by this pleading, are relying on the summary of final collation and declaration of results, which are in forms ECDA, in bracket, ECHE, as issued by the first respondent. The issues generated on this were not about the scores, but the alleged invalidity of the scores and the error of calculation of the scores. This pleading was not admitted by the first respondent. In reply, the first respondent joined issues with the petitioners in paragraphs 9, 10, 11 of their reply filed on 11 April 2023, which paragraphs are produced. It is settled law that issues for trial by the court are joined in the pleadings, and the parties and indeed the court are bound by the pleadings of the parties. The petitioner's case stands to collapse if no evidence is called on the issue. See the case of Uruwari and Osla and Nada versus Dixon. In the instant case, the petitioners anchored their case in this issue, on the report of the statistician, forensic examiner, and other experts. The statistician's report referenced by paragraph 14 and 15 of the petition was tendered in court through PW21, Mr. Samuel Oduntan. It is filed on 14th of June 2023. The statistician's report were tendered, admitted, and marked exhibits PAH1, PAH2, PAH3, and PAH4 respectively. This report was challenged by the respondents, and in our earlier ruling, we came to the conclusion that it was incompetent and liable to be struck out, and was in fact struck out. Without prejudice to that ruling, I wish to assess its value. Nevertheless, PW21, the maker of the said reports, was cross-examined in court by all the respondents, and he showed clearly that he is an unreliable witness. He was contradicting himself on issues around his report, apart from the fact that this witness is a subpoena witness whose witness statement of oath was not front-loaded. He did not present himself as a credible witness. Hear him under his cross-examination by Mahmoud SN for the first respondent. He said, I have formal training in information technology, IT, as stated so in my written statement. I was commissioned by the petitioners. I was compensated by the petitioners for my work. I am an expert in statistics. Apart from what I stated in paragraph 5 of my witness statement, I have enough experience in my work and election petitions. One does not need to be an expert to read ANEC forms EC8S. I commenced my work sometimes in April. It took me about a month to complete my assignment. I cannot recall any proceeding where I admitted that I am not an expert. I agree that if my primary data is defective or incomplete, my conclusions could not be wrong or incorrect. I could be wrong or incorrect. I also agree that if my methodology is wrong, my conclusion will be wrong. I have seen page 4 of exhibit PAH1. That page refers to the methodology I use as referring to forms EC8S. I inspected the forms EC8As at the ANIC headquarters. I do not know if those forms EC8As are before the court. I am aware that the form EC8As are stored in the various state headquarters. If what are stated in paragraph 2 at page 4 of Exhibit PAH1 is wrong, my conclusion will be wrong. I have seen column 1 of volume 3, Exhibit PAH4, at page 1, line 1. It refers to polling unit 009, ward 6 of Anambra State. When cross-examined by Chief Olani Pekun SN for the second respondent, the PW21 said, I have seen paragraph 5A of my written statement on oath. It is true that I did not present the report in Khalil and Yaradua. I agree that no pictorial images of the electoral documents I referred to in my statement are attached to my statement. I am aware that PDP won the election in Adamawa State. By my report, we are not satisfied by the votes returned by ANIC in Adamawa State, including the votes scored by the first petitioner. I say so because I'm not satisfied by irregular votes recorded in Adamawa State. That is why I sought the deduction of those votes. By my report, the petitioners won the election in 12 states. By my figures, I am not satisfied with the score for PDP in those states because they are printed with irregularities. I'm also aware that Labour Party also won the election in 12 states. In all the states won by Labour Party, I have also called for the deduction of those votes. I was in the situation room of the PDP on the day of the election. I have seen the report for Kano State in Exhibit PAH2. Furthermore, in response to the cross-examination of the Learned Senior Counsel for the third respondent, Fabian ESN, the PW21 said, it is true that I have been following ANIC activities since 1999. There was a time that ANIC chairman said the results for the 2023 election will be transmitted electronically and real time. I did not hear the ANIC chairman announce 2 days to the election that due to security and cash crunch, elections will not be possible it will not be possible to transmit the results as promised. The inspection of the electoral documents was carried out in the presence of agents of PDP. I did not make copies of those documents. I was assisted in my assignment by a number of people. Each of these people played a role. I stated the role played by each of those persons. I have seen volume 3 of my report. The said volume 3 of my report deals with ANIC documents, which were not signed or stamped. I did not indicate which of them were not signed or stamped. I have seen the table in paragraph 11.2 of my witness statement. Only 26 states are mentioned therein. In my report on the electoral documents not signed or stamped, I mentioned 28 states. I stated that I analyzed the electoral documents from 36 states. It is true that my candidate's votes cannot be deducted more than once in a unit. I did not conduct extraction of the BVAS report. I'm aware that BVAS machine was used for accreditation. I'm the only one who signed the report because I was the team leader. I worked in all the states where alteration took place, including states where PDP won. That's the state treatment of PW21 under cross-examination. It is tried in our law that cross-examination is a formidable tool for the demolition of the case of the opponent. The purpose of cross-examination is to discredit the witness called by the adversary. In the recent case of PDP and others versus Muhammad and others, Supra, the Supreme Court held that the primary object of cross-examination is to contradict the evidence of the opponent's witness in order to weaken his case. It is best resorted to in order to test the veracity of the witness. It is in the instant case, it has in the instant case been clearly established that by cross-examination, the PW1 testimony has lost esteem and value. A close look at the reports, Exhibit PAH1 to PAH3, will indicate that the witness was talking of 5,270 polling units, wherein he claimed that from EC8A series were altered and were not signed. It also talked of 15,002 polling units, where from EC8As were not stamped and signed. Yet all that is contained in the report are figures and data of these forms. None of the physical forms was exhibited in the report or tendered separately by any of the witnesses. In that situation, it is very difficult for the court to ascertain the truth of the allegation that several forms EC8A series had a lot of alterations and that they were not signed by the presiding officer. The law particularly requires that the presiding officers must sign the results. Signing Form EC8A is subscribing to the authenticity of the results. Where there is allegation that the forms were not signed, it must be clearly proved by the petitioners. The result forms must be presented in court for the court to verify lack of signature, stamp, and any alteration on the forms. Since PW21, who authored exhibits PH3 and PAH4, did not place this in his report, and the petitioner did not call any of the polling unit agents to testify and place the forms before the court to give vent to the allegation of alteration and non-signing of the Form EC8S for the 5,270 polling units listed in Exhibit PAH2 and the Form EC8S not signed, stamped for the 15,002 polling units in Exhibit PAH3. That allegation is unfounded and not proved as required by the law. On petitioner's allegation, the first offender fails to collect the election results using the electronic collation system. The petitioners have not been able to prove that the Electoral Act or the guidelines made it mandatory for electronic collation system. I have carefully considered the submissions of parties on this issue of non-compliance with the provisions of the Electoral Act and the paragraphs of the regulations and guidelines for the conduct of election 2022. The Independent National Electoral Commission, INEC, the first respondent herein, is established by Section 153F1F of the Constitution, and part of its functions as stated in paragraph 15, item F, part 1 of that schedule to the said Constitution is to organize, undertake, and supervise elections, including election to the offices of the President and Vice President, among other political offices listed. Being a creation of the Constitution, INEC is empowered by Section 161 of the Constitution to make its own rules or otherwise regulates its own procedure, and in so doing, it shall not be under the control of the President. Indeed, by Section 158(1) of the Constitution, INEC shall not be subject to direction or control of any authority or person. By Section 4 of the 1999 Constitution, the legislative powers of the Federal Republic of Nigeria is vested in the National Assembly, which in the exercise of that power has enacted the Electoral Act 2022 to regulate the conduct of elections in the federal, state, and area councils of the Federal Capital Territory. Section 47(2) of the Electoral Act, relied upon by the petitioners, mandates every presiding officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Also, under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of accredited voters and the results of the ballot, in a manner as prescribed by the Commission. Section 62(1) of the Act specifically provides that after the recording and announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their agents where available to such person as may be prescribed by the Commission. Further, Section 64(4) says that a collection officer or returning officer at an election shall collate and announce the results of an election subject to his or her verification and confirmation that A,